Yes, thank you, Mr. Overy.
Good morning, Your Honour. Just as a preliminary, we've managed to agree to that extension of time for any appeal against the existing decision. I suspect what we'll do is put our heads together afterwards and try and find a formulation for an order and let Your Honour have that.
Thank you, that would be good.
If that's helpful. Thank you. In which case, I was just going to dive straight into my closing.
What's happened about the attachments?
Oh yes, that's agreed as well. Thank you. So it's agreed that the document that was attached to that email was the 10,000 metric ton contract. I believe that was the issue.
I think it went beyond that, that the other document attached was, I forget what, but the link was indicated.
The AK Global letter. Referring to the 10,000 metric ton transaction.
Yes.
I think we've seen the email. We accept that it is what Manifest says it is.
Thank you. I'm grateful for that.
So yes, I mean, unless there's anything further as preliminary, I was going to dive straight into my closing.
Away you go.
With the transcript point that we raised on day 2, just to clarify that on the record. Just a very small point, Mr. Montague-Smith, you may remember, after I finished cross-examining Mr. Chinana, objected to the way I phrased certain questions. So just in case the court is going to rely on that part of the transcript, I'd just like to clarify how it should be read, just in order to avoid any appeal on this basis. So it's day 1, and it's page...
I can't see the slightest possibility of this having anything to do with an appeal, but if you want to get the transcript right, go ahead.
It's day 1, page 157, and it's lines 7 to 13. And in these lines, my question is it correct that there are no other invoices which directed payment directly equate flour or equate supply to AK Global? The answer is I believe there are 17 in total. The question is, okay, we haven't seen any others. These are the only 3 that we've seen, and if I'm wrong on that, Mr. Montague-Smith will take you to that in the bundle. So now please ask the court, if you're going to rely upon this part of the transcript, if you can take the references to other invoices, we haven't seen any others, these are the only 3 we've seen, could you change those to no other invoices in the bundle, we haven't seen any others in the bundle, and these are the only 3 we have seen in the bundle.
But are you saying the transcript is inaccurate because you used those words?
No, the transcript is accurate. I just want to avoid the issue that Mr. Montague-Smith had flagged in case you were to rely on
the transcript will remain as it is, because that is the transcript.
I was not asking for the transcript to be changed. It was just all I wanted to make clear was if you're going to rely upon what I've said in the transcript, I'd like to retract that question and rephrase and have it understood to be rephrased to documents referring into the bundle.
Yes. Right, let's move on.
Thank you, Your Honour.
I don't propose to take that any further. Thank you. So, Your Honour, dealing with my closing, then, what I was going to do is deal first, if I may, with the counterclaim. I know it's sort of back to front, but in a sense it comes first in time, and then I was going to come on to deal with the various heads of claim and then Mr. Chinana's position. But what I wanted to do at the outset was highlight 2 particular points, which I say run through both parts of the claim and the counterclaim. Now, the first is a point that we have to some extent canvassed in opening, and Your Honour flagged it as an issue that there might be a battle with the pleadings. And it's this question of how IDBI's counterclaim is pleaded. And I've said it's pleaded in a very specific way, and I say it is narrower than has been presented by my learned friend. So I need to take you to that, but just to herald what I'm going to come on to next, we will look at the pleadings, but what I will be saying is actually, in a sense, this has now gone by the wayside, given what happened during the course of the trial. Because the second overarching point that I'm going to be making is that actually when it came to the cross-examination of my witnesses, very little of their evidence was in fact challenged. Very little of the defendant's case, even the expanded case, was actually ever put to my witnesses, and I will come on to deal with the consequences of that. So what Your Honour...
Could I just stop for
Yes.
a moment? Why are you dealing with the counterclaim, as it were, in chief? Would you not ordinarily be responding to Mr. Francis's submissions on the counterclaim?
Yeah, I can do that.
If you deal with it now,
Yeah.
it may or may not be said that you don't have an opportunity to respond to Mr. Francis's submissions.
Yes.
Would it not be better to wait until you hear what he says?
I can do that. I think that what the rules say is that the claimant goes first, the defendant goes second. So we've lined up to give speeches in that regard. But obviously that's all up to, it's all up to Your Honour as to what order we do these things in and what would be helpful.
Well, it's true that there's reference to the claimant first, etc., but one must look at what the issues are. You are a claimant,
Yes.
so is Mr. Francis.
Well, yes, I see. There's a counterclaim.
Yeah. The sensible course, to me, subject to what counsel have in mind, and if they wanted apart from that, I probably have no objection, would be for you to give your submissions on your claim. Mr. Francis then reply to that and his submissions on the counterclaim.
Yes.
You then respond, and there may or may not be a further opportunity after that.
I'm in Your Honour's hands.
I'm in the hands of counsel also. If you've prepared on the basis
Well, I have, but I
and
can
you're
just
going to
go
be thrown off your stride, then we'll continue the way you wish.
No, not at all. And I'll do it in that way, given Your Honour's indication. There may be a little bit of stumbling around, but I don't think it will throw me off my stride.
Well, we'll see what Mr. Francis says about that course. Which way would you prefer, Mr. Francis?
Your Honour, I'm happy to proceed as you've indicated.
All right. Well, I think do it that way. That seems the logical way, and it avoids any procedural arguments.
All right, thank you. Well, look, then, I was going to start with the pleadings aspect of it, but that's specifically on counterclaim, so I'll come back to that. So
Yes.
I know the phrase says, and skip then forwards a little bit in my notes. Now, and this is where my submissions may overlap slightly. The first point I was going to make, and that relates really exclusively to the counterclaim, is the way that the counterclaim is pleaded. But as I was saying, I was going to go on to make the point that in a way that's water under the bridge to some extent because of the way that my witnesses were dealt with in cross-examination. And so the point that I'm making here is that hardly any of the claimant's witnesses were actually challenged on their evidence. And hardly any of the defendant's case was actually put on the defendant's response to my case and also the defence's response to my witness evidence, as we anticipated it would be. And as was heralded in Overy, hardly any of that was actually put to the witnesses. And this was a theme that went throughout. And as I say, my submissions here may overlap slightly with what I would say in relation to the counterclaim, but for example, it was never suggested to Mr. Chanana that any of these other breaches of contract that were heralded in that are suggested in the witness statement, that any of them actually occurred. Things like failure to produce documents, things like failure to maintain credit ratios and capital, asserted breaches of presenting information, providing documents. None of that was even suggested to him, and he was never given any chance to answer those questions. And this affects the issues on the claim as well, and I'll come on and deal with those more specifically. But what I say is that even if, just looking at those issues on the counterclaim, even if there might have been some prospect of broadening out the case or interpreting the pleadings in a broader way than I suggest, that was not done in cross-examination, and so the position on those cannot be maintained in closing. And I wanted to show Your Honour an authority on that, an authority from England. It's a recent authority. The reason I want to show it to you is because it's a helpful summary, helpful recent summary from the English High Court of the relevant principles at play in this respect. And I know that there are DIFC court judgments which deal with this sort of issue and take this sort of approach, and I believe one of them is a judgment of Your Honour's. But the Keckman case, which we've included and circulated last night, it has a helpful summary. You should find it, I don't know whether it's in this. So there should be an F2 bundle.
Yes.
And it's 12A, I think, is the tab. Keckman case, and it's a long judgment, I'm afraid, but the relevant paragraph is at paragraph 89 to 92, and those appear on page 61 of the judgment itself, or page 361.63 at the bottom right, under the heading "Challenging a Witness's Evidence." There won't be anything surprising to Your Honour in relation to this, but because this becomes quite an important point in this case, I just go through these principles, and as I said, they're quite helpfully summarised here by Mr. Justice Bryan in the Commercial Court.
Well, this is a principle which I'm familiar with under the heading of the so-called rule in Brown and Dunn.
Yes. So there's two aspects to it, in a sense. One is, in particular, in relation to certain types of allegation. If you're going to level that allegation at an individual, you have to give that individual an opportunity to answer that allegation. So where you're talking about allegations of fraud and so forth. But there is the broader principle as well, which is if a witness gives evidence on a particular area, or if it's part of your case, generally, if it's a fundamental part of your case, you need to put that to the relevant witness, the witness either giving the evidence or the witness who could speak to it. So the principles applicable start with paragraph 90, and you'll see the summary which is endorsed by the judge in Phipson on evidence, paragraph 90. In general, a party is required to challenge in cross-examination the evidence of any witness of the opposing party if he wishes to submit to the court that the evidence should not be accepted on that point. This rule serves the important function of giving the witness the opportunity of explaining any contradiction or alleged problem with his evidence. If a party has decided not to cross-examine on a particular important point, he will be in difficulty in submitting that the evidence should be rejected. And there's reference to the EPI Environmental Technologies case. I regard it as essential, over the page, that witnesses are challenged with the other side's case. This involves putting the case positively. This is important for a judge to enable him to assess that witness's response to the other case orally by reference to his or her demeanour and in the overall context of the litigation. A failure to put a point should usually disentitle the point to be taken against a witness in a closing speech. This is especially so in an era of pre-prepared witness statements. The judge does not see live in-chief evidence, thereby depriving the witness of presenting himself positively in his case. And then reference to where the rules come from, and the reference to the Holsbury's passage, failure to cross-examine a witness on some material part of his evidence or at all may be treated as an acceptance of the truth of that part or the whole of his evidence. And so, again, I'm afraid my submissions will overlap a little bit, my response to the counterclaim, but Your Honour will recall, for example, that while my client does not deny that it owed the balance of the buy, 26th February, just by way of example, the balance of the 26th February buyer's credit on that date and did not repay it, that was subject to 2 points. One was the set-off, but one was also, we'll come on to that, but one was the main point. You cannot rely on a breach by the other party where you've caused that breach. And so we'll come back to looking specifically what was asked of Mr. Shannon, but my proposition in relation to that was that it was never actually suggested to him that after the 26th of February there was some other means that he could have deployed to pay down that 26th of February buyer's credits. I'll skip then forward to my notes on the claim. And I'm going to deal, if I may, with the first two heads of claim together. So those are the loss of profits from the diverted sales and what's been called the loss of margin because of the loss of the supply contracts. And in relation to this, I do say that my learned friend is constrained in what he can now submit, because my client's evidence was out there and very little of it was actually challenged. When one comes to these two heads of loss, the first central factual question is this: what were the contractual arrangements between IDBI and AK Global? Were they, as the claimant alleges, this umbrella contract of 30,000 tonnes and then subsequent shipments pursuant to execution contracts at varying prices? The second potential question in this context is, in effect, is the information in the sales and purchase matrix that we've seen, is that accurate? Is it reliable? Because that affects what has been shipped, at what prices, and therefore what remains to be shipped, and also what was diverted. Again, the problem here for my learned friend is that neither of the advocates who cross-examined Amira's witnesses actually challenged the evidence on this effectively. So to start with what we have in terms of the evidence, I don't think I need to take you to them at this stage, but Your Honour has seen 3 documents, 3 contracts between AK Global and Amira. So you've seen those, the 30,000 metric tonne contract, one price, the 10,000 metric tonne contract, another price, and the 8,200 metric tonne contract. So you've got those parts of what we say, the last 2 of which are in supply or under the umbrella of the 30,000 metric tonne contract. And you have the explanations of how they fit together. Firstly, we've got an explanation from AK Global itself, and that is at the bundle. I will show you this. We've seen it, but I'll show you again very briefly. It's at bundle D4, tab 197, if I may.
I've seen it several times. Do I need to look again?
All right. Well, if Your Honour needs the references or is going to work from the transcript,
by all means,
I'll tell you the references, and then we don't have to go with that. But so you've seen that. You recall what it says, and I won't labour that. It's consistent with and supports the position given subsequently in evidence by Mr. Chanan. Now, that is hearsay evidence. I accept that. It's admitted into evidence. Hearsay evidence is still admissible. It's admissible under the English rules, and in fact, the DIFC approach, the approach to evidence is even more liberal. The court can adopt whatever approach it wishes to. It's within the confines of the rules that have been established. Obviously, the fact that it is hearsay evidence goes to its weight. And again, that was an issue in the Keckman case that I've shown you. And I won't take you back to that case, but if I give you the reference to the paragraph numbers, it's helpful, because paragraphs 82 to 88, Mr. Justice Bryan dealt with a complaint about the nature of the evidence that was being put forward in that case. And the point that was being made was there was reliance on the Djibouti case, where that was the case, quite extreme case, which involved hand grenades and freezing orders and quite a lot of fallout from that. But in that case, what there was something that the judge had called a swearing match between a witness who was present in court and an affidavit that had been provided by a witness who didn't attend And so, in that context, the judge has said, well, actually, I'm going to give that hearsay evidence very little weight, in fact, no real weight. And so it was submitted in the Bryan case, in the Keckman case, that was the effective approach to hearsay evidence. And Mr. Justice Bryan said, no, this is a different context, particularly when you have all of the evidence that's coming from one party, where it's corroborated by witnesses who stand up and do give all the evidence. Then it can't be said it has no weight. It has less weight than it might if a witness had come from APA Global, but it still has weight. Now, in this context, that evidence is corroborated. It's corroborated by Mr. Chinana. He gave evidence and reference in the transcript as day 1, page 117, lines 8 to 13. Explained it in terms which were consistent with the AK Global explanation and are consistent with the case that I advance. And again, none of that was actually challenged by my learned friend. What we got instead in the cross-examination was a series of forensic questions about features of the contract. So the point was made, for example, well, there are different delivery dates in the various contracts, aren't there? Answer, yes, there are. The documents show that. There's nothing there. But it was never actually suggested, well, that means that the contracts would have expired, or that means that these contracts are actually for different things. And if we actually, just dealing with that point on the delivery dates, if we actually go to the contracts, we can see, and I'll show you this if I may, it's behind Bundle D2, tab 42. This is the 30,000 contract. So the shipment dates on page 436. What you see at the bottom there, you're on a shipment up to March 2018. So the point's being made, well, that would have expired, and so there wouldn't have been further deliveries. But if you want to look at the consequences of that below, shipment up to March 2018, shipment period, this shipment of goods must be effected as per contractual dates. Buyers have the right to cancel the contract if shipment schedule is not complied with. So the effect of that shipment date, as a matter of contract between Amira and AK Global, is simply to give Amira the right to cancel the contract if it wants to after that date. It doesn't, on its face, give any right to AK Global to cancel the contract after that date, and it was never suggested that the effect of that shipment date might have the result that actually AK Global wouldn't have supplied, or that it was never intended that it would have supplied under those contracts. Another forensic point that was identified was that it was said that as between the original contracts, if I can call them that, the 30, the 10, the 8,200 on the one hand, and the replacement contracts, tier and impulse contracts on the other, the original contracts identify rice from the 2016 crop. The replacement contracts identify or specify rice from the 2017 crop. But again, it was never actually we can all see that from the document. It was never actually suggested to any of the witnesses that that makes any difference whatsoever to the parties to the terms of supply in reality. It was never suggested to any of them, for example, that the 2017 crop might have been a more expensive product. If that had been suggested, Your Honour would have heard a response to it. Your Honour would have heard, and Your Honour did in fact hear part of the response in answer to a different question. Mr. Chinana said, when talking about whether basmati rice is a commodity or a specialty, he said, well, it's like wine to some extent, in that it ages like wine, it improves with time. Was the effect of what he's saying. The reference to that in the transcript is day 1, page 180, lines 5 to 12. But the importance of that is simply that there are answers to those questions. It's not enough to say to a witness, well, look, here's a difference. One has to go forward and say, well, what is your case on that difference? What is actually the case? Are you saying that that means that these are different contracts? And if we just pause for a moment to consider what would have had to happen if these documents, the 30,000 contract, cannot be relied on. What are the consequences of that allegation if it's being made? And they are quite serious, because the suggestion would have to be that these documents have been fabricated and that AK Global's letter had been concocted, and presumably, to make sense, that would have had to have happened with the collaboration of Amira. Because why would AK Global write that letter? Why would AK Global lie to the court in correspondence? Now, there was a line of questioning of Mr. Peters, which appeared to be suggesting something like this. So when Mr. Peters, the expert, was being cross-examined, there was some suggestion, there was a line of questioning, and the end result of which appeared to be the suggestion that, in fact, some of these documents were sham documents. Some of these documents weren't real. If you remember, there was a line of questioning about over-invoicing, whether Mr. Peters whether red flags had been raised, and all the rest. And Your Honour quite properly put an end to that line of questioning. Those sorts of questions, the effect of the allegation, if that was the allegation, would be that these documents are not real documents, they're sham documents. That is an allegation of fraud. Because a sham document is a document designed to deceive the world about the true terms of supply. And so it's well established that if you're saying sham, you're saying fraud. But even that line of questioning was predicated on the assumption that the 30,000 metric ton contract was in fact a binding contract. And the other contracts were shams. Because the suggestion that was being made to Mr. Peters was that there was over-invoicing under the subsequent contracts, under the 10,000 metric ton contract. So it's predicated on the assumption that the true invoice would have been at the 30,000 metric ton rate. Now, in opening, during the course of my learned friend's opening, you want to put the question squarely to my learned friend. So we had lengthy submissions about the timing of the disclosure of the 30,000 contract. My learned friend was saying, well, it only came out at a certain point in proceedings. And you want to ask the question, it was said, firstly, that goes to foreseeability. And we see that, and I'll deal with that, I'll come on to that. But you want to press my learned friend and said, are you saying that all of that means that you don't accept that this contract actually existed and worked in that way? My learned friend never answered that question with a yes, as far as I could tell. What he said was actually the consequences are firstly foreseeability, but also actually there are all these other breaches that I'm going to allege. And I'll come on to whether those were alleged when I deal with the counterclaim. And the thrust of the questioning, I say, when you want to look at it, in the transcript, was to the effect that these documents were binding documents. There were these arrangements. They were never disclosed to IDBI, were they? Those sorts of things. So on the issue of the terms of supply, I would suggest there can now be only one answer. Because the case was never properly challenged. And in any event, even if that weren't the case, Your Honour has evidence from both of the parties to that arrangement. It is consistent one with the other, and there is no reason at this stage to doubt that that was in fact the arrangement. Certainly none was suggested to the witnesses. So what I say is that Your Honour can comfortably accept that the overarching arrangement between AK Global and Amira was this umbrella contract for 30,000 metric tonnes. The evidence is there to support it, but in fact, in any event, that evidence was never challenged, and so my learned friend is not anymore in a position to dispute it. Once one gets to that point, then the next question is, well, what was supplied, and at what prices were those supplies made?
I just check one understanding that we don't have the contract with Kuwait Flour. We are, I suppose, assuming that the contract, 30,000, 10,000, whatever it was intended to service a contract with Kuwait Flour. Is that a correct approach?
One doesn't actually need that assumption for the purposes of the claims, because it's right for the diverted sales.
Because we have to have a price for sale to Kuwait Flour.
We do for the diverted sales, so it affects the diverted sales. But my case in relation to the other part of it, and the much more significant part of it, is that the damage, the loss that was suffered by Amira was that it had this supply of goods that were going to be a cheap supply of goods, and it had to replace those supply of goods with a more expensive supply of goods. So its loss is simply by reference to the supply contracts, not by reference to the sales contracts. So you can show that.
But as a matter of fact, in just understanding what was going on,
yes,
am I correct? We don't actually have a copy.
We don't have a copy of the sales contract.
Kuwait Flour sales contract.
That is correct.
Underlying all that we're doing is that there was some kind of sales contract.
I don't think it underlies, that's what I'm saying, I don't think it underlies all that we are doing.
As a matter of fact, there had to be. They weren't buying this for fun.
No, I agree. But they're a sales, they're a basmati rice trader. So they're going to sell, they sell rice. So unless Your Honour thinks, well, as I say, they're never going to be able to offload this at any price. But even that is not an essential part of the case for lost margin.
But Kuwait Flour was told to pay direct.
Yes.
So we're not dealing with buying rice against the possibility that they might offload it later on. We're dealing with servicing some arrangement with Kuwait Flour. I don't think there's any debate about it. I'm just trying to understand the extent of our knowledge of the arrangement with Kuwait Flour.
Yes, well, we can see the sales invoices, and I'll show you what we have. So we can see the sales. So I'll come on to this, but essentially we can see we can derive from the bank statements the sale prices of the 4,900. And you recall I went through that in the experts. The next load of shipments are the 3,000 that were actually supplied. There's no loss in relation to those, but we can see the sale price in relation to those from the sales invoices, which we do have for those 3,000 shipments. In relation to the diverted shipments, what we have are essentially statements from AK Global about those, because, as you say, we can see what prices were achieved by AK Global when they did sell that direct, because we've been told that from AK Global. And so I think as to the rest of it, what is said by my learned friend is what comes after the cancellation by AK Global is that the price of sale goes up. That's his case. So the price actually rises subsequently. Now I say that's irrelevant, and I'll come on to why that's irrelevant to the loss. But whatever, if I can put it like this, if Your Honour accepts that the rice that was purchased would have been sold at some price, at whatever the terms of that would have been, and they were subsequently sold because we can see that from what came after, then it doesn't matter what the price would have been for the sale when one's looking at that second head of claim. Does that make sense? Because it's the difference between the supply prices.
It does, but that's not what I was actually asking.
I'm sorry.
Okay, move on.
I know I want to grapple with this point, and if I haven't answered the question, I'd like to do so. The question is, do we have the sales contracts? And I've answered that we don't.
Okay.
I accept that. The next question is, what are the consequences of that, if any? And I'm trying to
You
make my
say
point.
it doesn't really matter.
It doesn't make any difference.
Yes.
But what we can see was what was supplied. And we can see prices at which that was supplied and also the prices at which that was sold. And if I was going to do this exercise, I can leave to one side for the moment the diverted sales, because there's controversy about how many of those there were and the total amount of shipments. On one hand, my client says there were 70 shipments which were diverted, and that would have been 8,500 tonnes of rice, basmati rice. And I think on the other side it's that we don't accept any were diverted, but at best you can show on the documents that 30. So there's that difference. But if we pick up the sale and purchase matrix, if we might, just so I can remind you on where we are, probably the best place to look to start would be at page 51, which is the supply side. And so it's if you want to recall, the way we've been dividing it up to make it easier to remember is that there's a set of shipments which amount to 4,900. Those are in two parts. The first part is from lines 149 to 153. And you'll see there that the purchase price per tonne is the 128,750. So you see that's about 2/3 of the way along on the right, giving the total price for each. And the second part is at lines 177 to 181. So they come afterwards. So those are 10 shipments, they amount to 4,900. They are supplied at the 30,000 metric tonne contract price of 128,750. And then we see the sales side of it, 44 and 45. And we see the sale price is the 1,398, I think in both cases, per tonne. So that gets to the 699. Now, just to orient it, what we can establish in relation to this sales and purchase matrix, we know that those shipments were supplied, bought and sold by Amira at those prices. We've got the banking records to show that. I took Mr. Fritchie through those. He accepted that, doing his best, they appeared to confirm the entries in the sales and purchase matrix. The specific references to each of the payments I won't burden you with, but I will give you the range for those bank statements. And the range is, firstly, in relation to the first batch is bundle D3, tab 138A, pages 641.13 to 641.19. And then the second batch, bundle D4, tab 185A, pages 735.1 to 735.16. Now, Mr. Fritchie said that he had observations about what other documents he might expect, but if the evidence that we have establishes the facts, then the prospect that there might be some other evidence out there which might come along is just speculation. It doesn't undermine that conclusion. And I think he accepted that unless the bank statements are wrong, then that system established that those lines in the sales and purchase matrix were correct. But in any event, Mr. Gandy gave all evidence on this, and he said that he had produced this sales and purchase matrix. He'd done so using the underlying documents. He was never challenged on that. He was never challenged on the accuracy of this documentation. It was never suggested to him that it might be inaccurate or it might be incomplete. That was another suggestion that was made subsequently by Mr. Fritchie. After the first batch of 4,000 of the 4,900, we get to the 3,000 that were actually supplied. Now they were supplied at a higher price, a 10,000 metric ton contract price of 1,389, and those appear in lines 154 to 159 of the sales and purchase matrix. So those are the ones where payment went via IDBI. We have substantial documentation in relation to those. We have all of the invoices, both purchase and share sales. There are other documents, bills of lading, packing lists, and so forth. But for your notes, the purchase invoices for those are bundle D2. I don't have the tab numbers, I'm afraid, but it's just pages 458, 462, 466, 479, 483, 487. The sales invoices, which will therefore reveal the price, will be at D2, and again I've got the pages 470, 473, 476, 494, 491, 497. So in total, at this point, we've got independent verification for the 7,900, even if there was some doubt about the accuracy and contents of this sales and purchase matrix. Because you say, well, what's the evidence of the sales price? Well, amongst other matters, we would say, well, it's the information in this sales and purchase matrix, which the witness has said is based on looking at the documentation. So if we accept that there's a 30,000 contract, what we've looked at so far is 7,900 tonnes that's been supplied, and that leaves a balance to be supplied under the 30,000 contract of 22,100 tonnes. Now there is this dispute about how many of those shipments were actually diverted, as I say. Was it 13, was it 17, was it some other number? Was it 6,500, was it 8,500? In relation to that, we have this letter from AK Global, and I don't know whether you've seen it a number of times again. The reference is bundle D4, tab 196, page 784, and that sets out what AK Global says are the shipments which were paid for directly, and that incorporates the 17 shipments. And Mr. Chanana gave oral evidence that there had been 17 diverted sales. And again, I say that evidence was never squarely challenged. It was never said to Mr. Chanana, well, actually, only 13 were diverted, or none were diverted, or is it possible that this didn't happen? You can't be sure, can you? Or as I say, the consequences of that AK Global letter being wrong, none of that was ever explored. This letter is concocted. None of that was put. If we look at what was said in this regard, Fiona has the transcript bundle. It should be volume G. Yeah. We go to page 141 of the transcript. You'll see, starting around line 10 and going downwards, there's a series of questions about what documents were available. There's no record of a letter from you. to Kuwait Supply requesting that Kuwait Supply make direct payment to AK Global for any invoice number from 162 onwards? Is there? I believe there should be, well if there was, and so forth. But it never, so question, line 21. Let me ask a question. There's no record or document before the court of any letter like this from you, and any letter to Kuwait Supply asking them to make direct payment to AK Global for any invoice number from 162 onwards. Is there? I can't recall whether it is or not. The fact remains the payment was made directly to AK Global. We have evidence of that. It's not here and it should be here. Okay, well, if it's there, I'm wrong. Mr. Montague-Smith will no doubt take you to it when we've finished your questions. Next question is this. There's no record of any correspondence. It goes on like that. So he's never squarely challenged on these issues as to what in fact he says was diverted. He's never squarely challenged on the evidence about AK Global and where that letter must have come from. Whether that letter is just some sort of copted document to mislead the court. And that would be a serious charge and one that would need to be asked. So again, I say, Fred is simply stuck with the evidence on this. But anyway, in relation to the diversion of sales, I say it doesn't actually matter to the net result. Because the point here is that the loss would be the same in total over the first two claims, regardless of what is diverted. Now, I recognise that there is an issue as to foreseeability in relation to the second head. I don't think there is an issue as to foreseeability in relation to the first head, but I may be wrong. I think the point made as to foreseeability is we didn't know about the 30,000 contract, so it's not foreseeable there would be loss under that contract. So if Your Honour is attracted by that argument, and I'll explain why it ought to be rejected, then it may matter how you allocate the profit between claims 1 and 2. But otherwise, the net result of claims 1 and 2 will not be affected by this question of how many shipments were diverted. So you'll recall, when we dealt with the 4,900 and 3,000, you've got to 7,000 that has been shipped.
Well, this is what you put to Mr. Frischi, wasn't it?
Yes, and he seemed to accept, ultimately, that must be right. But just to do the exercise, say it's correct and only 6,500 tonnes were diverted. That means that the profit lost on those diverted would be only the profit lost on that smaller number of shipments, smaller number of tonnage. But then you have a larger number of shipments to run on the remaining contract, on the master contract. So if you accept that the whole 8,500 was diverted, then you have the lost profit from the whole of that, but of course then there's 2,000 tonnes less to be supplied under the master contract, once those have been taken into account. And the result, as we went through with Mr. Fritchi, was that the net outcome is the same. And the fallacy that comes by looking at each head individually, because you have to consider, if you don't accept the full amount of the claim under the first head, the knock-on consequential effect of that on the second head. Once you do that, you see that you're just shifting claim monies from one claim to the next. So what I say is this, that once you accept the terms of supply, the 4,900 tonnes and the 3,000 tonnes that have been supplied, it's possible then to calculate the prices for the rest of the shipments that were due under the 30,000 tonne contract. Again, I went through it with Mr. Fritchi, he agreed with the methodology. I don't think he was in a position to do the calculation. I don't think the calculation would be challenged. Now, as I say, the precise amount will depend on conclusions as to the diverted shipments. So when one looks specifically at the second claim and what needs to be supplied, the amount to be supplied and therefore the average price that was to be applied to that would be affected by how many shipments have been diverted. So there's two possible bases One is on the basis of the 13 diverted shipments, one is on the basis of the 17. But again, that's the way that you offset the change to the profit in claim 1. I would suggest that it doesn't look like there would be any real dispute about any of that once one goes through those calculations. So then, what I say when one looks at this second part of the claim is, well, was the contract for supply with AK Global cancelled as a result of IDBI's breach? If so, what were the replacement terms? And again, you have the evidence both from AK Global and from the Claimants on this. The reference to the letters from AK Global are at D4182. I believe it's D4197, maybe 197A, but it's page 787. And in the latter, AK Global explains that it would have supplied these shipments had it not been for these events related to the irrevocable letter. They terminated as a result of what happened there, because they were given the impression that Amira was about to be shut down and they did not want to do any further business with them. That's what was stated in the letter. That is supported by the evidence from both Mr. Chinana and Mr. Gandhi. And again, when it came to his cross-examination on that, and I may be wrong because we've only had the transcripts for a short time, but the only thing that I could find, at least in the time that I've had, is if Your Honour has still the transcript under G, go to page 168 of that. This is day 2, of course. Sorry, day 1, sorry. So we start on line 11. Your Honour will see there's reference there to this AK Global letter, the letter of D4 tab 182. That's the first letter. So I'll just show you that so we can just remind ourselves which letter we're talking about here. D4 182 is the letter in which AK Global terminated the supply contract. So it's a letter to Amira saying, as per your visit in our office, so it's dated contemporaneously 28th of June 2018, saying that they have received the money from IDBI, 4.134 million US dollars, and then saying, as per your visit in our office dated 2nd April, 1st May, 21st May, 3rd June, 28th June, regarding continuation of our business, they say, we have decided not to do any more business with you and cancel all pending contracts. It's tab 182.
I'm sorry, I rather lost your point. The cross-examiner
Yeah.
doesn't say why.
I'm sorry?
The cross-examiner put that it doesn't say why they are not going to do any more business.
Yes.
And it doesn't say.
No. We can all read that.
Yeah. So
the point is, well, that's all that's asked. Now, over the page on page 170, there is further suggestion that...
Well, I'm sorry, is your point that the cross-examiner doesn't go on to put to Mr. Chinana, well, there were numerous other reasons why they might have decided not to do business?
Yeah, quite. So
yeah, I thought
the evidence is they cancelled for this reason. The cross-examination is, well, here's the letter, doesn't say that.
Yes.
It doesn't go on to say, he never challenges the actual evidence, which is given by my client, which is, this was the reason for termination.
No, I understand.
But anyway, I say, there's no reason to doubt what is being said by AK Global, what is being said by the claims witnesses, that was the reason for termination. The explanation given by AK Global makes sense. And if one just takes a step back, one sees Amira's main supplier terminating all of its supply contracts with Amira shortly after all of these events. You've seen the correspondence where AK Global became very exercised about that, wrote to the bank, and you've seen, if I can put it like this, the fragility of these arrangements. Once you stop the money, everything stops. There was this point raised, it was raised in opening and also in cross-examination, that there were questions leading to this suggestion that in fact Amira should have sued AK Global. Just to deal with that point, I mean, effectively these are assertions of plea, mitigation. So it's effectively a plea that my client should have mitigated its loss by taking action against AK Global. So they're saying, well, even if AK Global refused to supply, this is what we should have done to mitigate that loss. And these sorts of questions arise quite regularly in relation to insurance contracts. So your Honour might be familiar with this. So often one has a situation.
Can I just to clarify my mind, my recollection is that the suggestion was they should have done something to recover the lost profits from AK Global,
Yes.
not to have sued AK Global for wrongful cancellation of some kind. I may be wrong. That's my impression of what was being put,
Yes.
which may affect what you are about to say.
I think there were two allegations. I'll hear what my learned friend says about it. But as I was understanding, at least in relation to the opening, he picked up on something I'd said in the opening. So I'd said, well, it gave, it's perhaps a loose phraseology, I said it gave AK Global the excuse to terminate. And I think what's being suggested in the opening, at least part of it, was that if it was an excuse, it might have been a bad excuse, and therefore Amira should have insisted on performance of the full contract. Now again, I don't think that was ever properly investigated with the witnesses. But in any event, there was then a subsequent line of questioning. I was going to come on to look at that, which appears to be aimed at suggesting that actually Amira did in fact recover some of these profits. You might recall there was some cross-examination on detailed bank statements, and then there was adding up and the suggestion that money was sufficient to cover what would have been the profit on the 10,000 tonne contract. I'll show you that in a minute.
Yeah.
But again, none of that was never actually put in those terms. Just said, oh well, there it is. But I'll come on to that in a minute.
Again, just to clarify in my own mind, do we have any clear evidence as to whether what Kuwait Flour paid direct to AK Global was the Kuwait Flour price or the AK Global price?
It was the Kuwait Flour price. I believe we do have that in the bundle. Because we've got a letter from AK Global saying this is what we received. I will.
That's right. If that can be just looked at to satisfy my mind, because
Yeah,
I
absolutely.
was not conscious of it.
Yeah. Would you just give me 1 moment and I will dig that out? Nick, do you have that reference? Sorry, I did. Yeah, let's do that.
That's the letter.
I think it's
Yes,
default.
I remember it ends up by OK Global saying we'll adjust later or something like that.
I think it's behind, yes, it's behind tab 196 in D4.
No, that's not what I was thinking of. Thank you. That's good.
So you'll see there,
Yeah.
12th of March 2019, and you've got 699, which corresponds to
I see that, thank you, yes.
Um,
According to my post-it note system, I haven't looked at that before.
Ah. All right. Well, yeah. So I think, yes. So I think that there were two suggestions, perhaps, and it may be that I've misunderstood, and we'll hear from my own friend. But insofar as, and in fact, there might be three suggestions. One was that perhaps Amira did in fact recover profits. Another was perhaps Amira should have asked AK Global to get those profits back and/or taken action against them. But I had understood that there was a third proposition that perhaps they should have insisted on further supply under the contract or taken some sort of action. I think we've been here far too long already. That's probably a prompt for me to speed up. I don't actually have a huge amount more on my closing anyway, but but insofar as, I mean, put to one side the question of what was actually whether or not profits were recovered. Insofar as what was being suggested was that some sort of action to have been taken by Amira against AK Global. The analogy that I was going to draw was with those insurance cases, because quite often you have a position where an insurer says to the broker, go and get me some insurance. They get the insurance, the event occurs, and then the insurer says, well, you're not covered. And so in those sorts of cases, what used to happen was the broker would say, well, actually, you are covered, you have to have a fight with the insurer. And the answer to that is always, well, actually, no, because the breach is not just in not getting the right cover, it's also if you have managed to arrange cover in a way that's ambiguous, or puts that cover in doubt, then that is the breach. The loss that flows from that is simply the refusal of the insurer to pay. And so the claimant, the insured under that, doesn't have to establish that as a matter of law they're not covered, and they're not required as a matter of mitigation to embark on a risky litigation against a third party. That's simply the loss. And if the broker in those circumstances wants to say, well, you are actually covered, the insurer should be paying something, then it's up to the broker to bring that party into the action. So that could have occurred in this case. So the point of all of that is that insofar, and it may be your Honour's right, and there's no suggestion that there ought to be claims against AK Global. I thought that's what was being suggested. But the point of all of that is to show that there has that the argument goes to mitigation, and that's the context. As to mitigation, there's no pleading, and again, there was actually no suggestion that there should have been some sort of action in cross-examination. Albeit it's right that Mr. Chinana rather anticipated that question and did provide an answer as to why he said he didn't do that. And I think he said he anticipated, he was trying to keep them sweet in effect because he anticipated that they would continue to do business. So again, I say the case just wasn't properly put that the evidence that was being given about the reasons for termination were wrong. And so forensic points about why that might be right needed to be put to those witnesses so they could have a chance to answer them. But in any event, there's no reason to doubt what is being said by the claimant's witnesses and by AK Global, and that the event that happened in relation to the irrevocable letter led to that termination of contracts. So then, if one gets to that stage, the next question is, well, what are the terms of the supply that were replaced? That replaced the 30,000 tonne contract? And we do have the replacement contracts. For your notes, they're at bundles D4, both in bundle D4, at tabs 175 and 189. And now, I mean, again, a couple of forensic points were made about those documents, as I say, these points about delivery times, these points about dates at which rice was supplied. But again, it was not squarely put that actually those were not the terms of supply. It was said in opening, well, these just aren't comparable contracts. You've replaced the original contract with something that's totally different because the rights is different, because the shipment dates are different. But it was never that was never a canvas with the witnesses at all, that those differences in those contracts actually had any impact whatsoever on the terms of supply, on what in fact was being supplied, or on whether or not things would proceed as they would otherwise have proceeded. Now, these points about the rice in particular tie into the part of my own friend's case about the fact that margins actually go up after the termination of the AP Global letter. And so Mr. Gandhi was cross-examined on this. And the question was so look at the sale and purchase matrix. He said the sale price goes up, the sale price of Kuwait flour goes up after this. So actually, the margins go up, so actually you made a profit after the termination of the AP Global contract. But again, that is a rolled up argument. You have to analyse out its parts. So, as I say, my case is simply the cost of supply rose. That is my loss. Goods which I would otherwise have paid X for, I subsequently have to pay X plus Y, so my loss is Y. That's the loss that I suffer. Now,
why do you leave out of account the price at which it did in fact sell?
Because unless that changed as a result of the breach, then there is no reason to bring it into account. The question is that increase in the sale price a collateral benefit which flows from the breach of contract? That's how it's legally analysed. If it is a collateral benefit, if it is consequence of the loss, then in the right circumstances you can take it into account in assessing what the losses are. So if I enter into a contract, just to make it easier, if I enter into a contract to buy and sell a car, if I was always going to sell the car at a certain price, but the cost of supply goes up, then I make the loss on the difference in the cost of supply. Now, if the sale price goes up as a result of that change, then yes, the courts will take into account that increased income in determining what my loss is. But the burden for my learned friend's case on that is to establish that causative link. He has to show that the effect of changing supply was that the price went up. And that's where that was the thrust of Mr. Fritchie's evidence about, well, it's 2017 rights, not 2016 rights. And in my view, the price went up because of that. Now, all of that would have had to be dealt with Mr. Chenal. All of that would have had to be investigated. And it never was. And if it had been investigated, there would have been an answer to that. As I said earlier in one of my comments, in one of his answers, Mr. Chenal suggested that basmati rice ages like wine. So that's a fragment of what would have been the answer to those sorts of questions. But the implicit assumption, which was never properly proposed, was that the effect of changing supply was that we ended up with a more valuable product. Simply nothing to support that. So what I say is that if you accept that the 30,000 metric ton contract was the umbrella contract in the way that's been stated, if you accept that the 4,900 was shipped at that contract price, you accept, as it appears to be indisputable, that the 3,000 was shipped at the particular price, 1,389 a tonne. And if you accept the balance of the contract after the diverted sales was terminated, cancelled, as a result of IDBI's breach, and that the replacement contract was at the 1389 price stated in those replacement contracts, then I say the losses for the rest simply flow from that. All that remains to be determined is actually how many shipments were diverted, but the only effect of that is which box you put the profit in from those particular heads. Now, I, as I say, I do say that Your Honour should find, and has evidence to find, that 17 shipments were diverted, not 13, and that the loss should therefore be allocated in accordance with that. So I say the net result isn't affected. Just to deal with this one point, my learned friend said in opening, all right, but there's another point here. There is a question, he says, as to whether Amira held on to the profit. But again, that question was never actually put squarely. And let's just have a quick look at what was put. We go to page 173 of the draft. I'm so...
I don't quite understand the way you put that question, whether Amira held on to the profit.
Yes.
Maybe Mr. Francis's
I
like to you indicated he wasn't sure either.
Yes. So there was a line of questioning, as I said, which went to look at the bank statements from Mashreq Bank and identified that there were certain payments coming into that bank account from AP Global back to...
Whether in fact they got it back.
Well, so the line of questioning appeared to me, and it's difficult to know because the question was never put, but the question that finally was put was, if you add up all of those payments, they actually add up to a little bit more. I think it was 1,097,755 over the period 1st of May to the 14th of June. So then he said, well, isn't it right that if you take the profit rate, the profit margin that would have applied on average over the 30,000 contracts, then in relation to the 10,000 contracts, the profit from those 10,000 would have been 1,105,000. And so then he says, and this is the references, page 176, line 18, he says, well, isn't it right, Mrs. Shanana, therefore, that the amounts that you received, that we can see coming in to the account from AP Global, are enough to cover the profit on the 10,000 metric ton contracts? Answer, yes, they are enough to cover that. But then he leaves it, and he never goes on to say, well, is that what it is? Were you actually getting the payments in through the back door? That seems to be where that line of questioning was going. But the point was never pressed. Just said, oh, we'll leave it to the lawyers now. And if you think through, if that is the allegation, if that is to be advanced, if you think through what that would actually mean, it would appear to be saying, well, there must have been some side agreement between Amira and AP Global to claw back some of the profit on the whole, or all of the profit, on the whole of the 10,000 shipments. I say, well, that doesn't make any sense, because the suggestion would then be, firstly, that Amira actually got the profit on 3,000 tonnes of that, because we know 3,000 tonnes were shipped. The payments went through Amira's IDBI bank account, 20,000 per tonne. But then, so the suggestion appears to be that AP Global actually paid back the whole of the profit on the whole of the 10,000 that would have been earned. So there appears to be some suggestion that there was this side agreement, but that was, again, that was just never asserted to the witness, and he was never given a chance to deal with that. And again, in effect, the suggestion would be that these are sham arrangements that are designed to give a false impression. So I say there's just nothing in that line of question, if that is to be advanced as a submission, it shouldn't be allowed. Now, and the other point on that is this, that Mr. Chanana wasn't able to give specific answers on where those payments came from. And at the end of his evidence, he suggested, well, I think he said that they might be shipment claims, there might be shortfalls in supply. And actually, if one goes to the documents, the bank statements, I'll give you an example for reference. Bundle D4, tab 177A, page 721.3. One looks at that, I think it does say payment against claims debit note. So that would be consistent with what Mr. Chanal was saying, that those payments would relate to. Shipment claims, quality of goods, under supply, that sort of thing. But he didn't know. He frankly said, I don't know what the answer to that question. So I asked him, who would know? Would Mr. Gandy know? Answer, he might. Mr. Gandy was here to give evidence. This was an unheralded point. No notice of this has ever been given. So there's nothing in the witness statements about this. Mr. Chanana was saying, well, I think Mr. Gandy might know. Mr. Gandy's tendered as a witness, and he's never asked the question at all. He never asked about his payments. Had he been asked, he would have been able to give that explanation. But it was never put.
He might have been able to give the explanation. That's what the evidence is.
Well, and there's a reason for that.
Yeah.
There is a reason for that.
I'm sure.
I understand your
for current purposes.
I understand your point. I understand your point. But I think, right. Yes, that's my submission. You might agree to. I think go any further than that for the purposes. All right. Now, in relation to all of this part, at least, of the claim, so the second head of claim, there is this assertion that the loss was not foreseeable. That's the argument. It was too remote. And the reason that's being given is that the IDBI bank did not know about the 30,000 metric ton contract. That point, I say, is wholly unsustainable. And I'll just show you two short authorities on that ought to be tried. We pick up the bundle of authorities, bundle F. Firstly, I'd like to take you to tab 2, which is the law of damages and remedies. And Article 12. So Article 12 deals with foreseeability of harm. So you'll see, firstly, if you start on page 4, you'll see this is under heading Part 2, Damages under the Law of Contract. Do you see that? And you'll see this part, Article 7, this part applies to where the Law of Contract applies, so it's dealing with that. Foreseeability of harm, Article 12. The non-performing party is liable only for loss which it foresaw or could reasonably have foreseen at the time of its non-performance as being likely to result therefrom. And so that is different from the common law position in many jurisdictions, which look at the question of remoteness of the date of contracting, not at the date of breach. So we're looking at it at the date of breach. So what the bank was told at the time of contracting, it's not irrelevant, it is obviously relevant, but the question then is what more did they know? What did they know at the time of breach and subsequent failures, which come all the way up to, frankly, the 20th of May when the payment was made. So the next point, we need to go then to tab 14. I'm afraid it's just an extract from Chitty, and anyone will be well familiar with this. Go forward to page 375, which is the final page. So, under the heading, the type or kind of loss. Paragraph 26, 126. the reference to the loss and the formulations of the test for remoteness of damage is to be interpreted as the type or kind of loss in question. The, quote, party who has suffered damage does not have to show that the contract breaker ought to have contemplated as not being unlikely the precise detail of the damages or the precise manner of its happening. It is enough that he should have contemplated that damage of that kind is not unlikely. There's a similar formulation, test for remoteness of damages and tort. The essential factor in determining liability is whether the damage is of such a kind as the reasonable man should have foreseen. So such a kind. However, we shall see that in cases of breach of contract, the test is applied differently from the way it's applied in tort. If the parties ought to have contemplated a particular type of loss, head of damage, they need not have contemplated the extent of that loss. And then the application of the test for remoteness to a particular set of facts, therefore, depends largely on discretion, judicial discretion. So there's room for separating out types of loss into particular categories and being more specific about what constitutes a particular type of loss. But none of them are going to be dividing between lost profits on the same type of transaction, or losses caused by different contractual relationships with particular parties. Quantum of the loss need not be foreseeable, just the type. As we know, the Hadley and Baxendale test, there are two limbs, and we see it in the statute in the DMCC, losses which generally flow from these sorts of breaches, and losses which the contracting party has been told will flow from these sorts of breaches, or losses which it could reasonably have anticipated would flow. And we would say that these losses fall into both categories. If you cause a party to fail to pay their supplier in these circumstances, we would say it's fairly obvious that you put the supply contract at risk, that you put that person in breach of that supply contract, and therefore you are likely to risk them losing that supply contract. And we say it's fairly obvious that if you lose the supply contract, you're going to have to replace it, and the replacement might well be for a higher cost. We also say it's fairly obvious that if you breach, if you cause this to happen, and the effect of that, as we've seen, is that payment was required to get shipments loaded, that therefore shipments will be likely to stop, and you risk losing out on transactions with your buyer, other transactions with your buyer. You put that contract at risk. So that's the first limb. We say here that this falls into the second limb too, because there were a series of communications.
But I'm really not. I don't approach this through the two limbs, though, do I? There might be background, but I approach it through Article 12.
Yes, Article 12 has those two limbs. So it has exactly.
Well, it's in different language.
Well, all right. Let's look at it. It's behind tab 2, Article 12. Liable for loss which it foresaw. So that's the second limb, I would say. So in the actual contemplation, or could reasonably have foreseen. And in fact, I suppose the limbs cut across both then, because reasonably have foreseen would apply to both limbs, I would suggest, which is that if it's the kind of loss that would ordinarily flow, then it would fall into that definition anyway. If you've been told it's likely to happen, it would also fall into that definition.
My point is that I start with Article 12.
Yes, that's fair. Yes, quite. So if we start with Article 12, you heard Mr. Ravi Kumar's evidence, and I put to him some of these communications that I'm going to remind Your Honour of, and his answer was, well, I didn't believe them, in fact. I didn't, so they were saying, this is putting my supply contract at risk, this is putting my sale contract at risk, and I'll take you to those in a moment. And his position, I said, well, wasn't it clear then that if you didn't pay, those sorts of things might happen? And his answers to those were always no. Now, Your Honour will have formed a view of Mr. Ravi Kumar's evidence, and in my submission it was defensive, and inexplicable, frankly, in the face of these repeated statements. This is the harm we're going to suffer. For him just then to say, I don't believe you. That may be true, may not be true. I suggest it's unlikely. But even if it is true, that he himself didn't anticipate, he should reasonably have foreseen these things. Because he's being told about them, and because they're logically likely to flow. So, Your Honour, just then dealing with the series of communications, I can either take you back through those, or I can give you the references.
I think just the references.
Thank you.
Yes.
Some of them, you will recall, were directed specifically or came to Mr. Kumar. Others were directed in letters addressed to the manager of IDBI Bank. Mr. Ravi Kumar was unable to say who had seen those letters, but I would ask you to infer that someone must have seen them, and in particular some of these emails were in fact copied to him. But the references are all in bundle D3, tabs 122, 129, 132, 138. The letter at 132 was the letter from AK Global. It doesn't, in terms, say, well, we're going to cancel the contract with Amira. But it clearly shows, we say, that this was causing AK Global concern, difficulty, and enough concern to take action directly and write to the bank. And Mr. Kumar's response to that was to say, well, that's a matter between Amira and its supplier, it's not our problem. So that seemed to be the thrust of a lot of his evidence, which seemed, I would suggest, to lead to the conclusion that, frankly, the bank wasn't giving much thought to the impact on Amira, might not be giving much thought, didn't care about the impact on Amira of the default, of the failure to pay out under the irrevocable letter. But as I say, even if the conclusion to be drawn from that is actually they didn't themselves foresee this loss, they reasonably ought to have, in face with statements of that nature, and the logic of the position. So I say, the type of loss which is foreseeable, the type of loss which occurred in these cases is directed at the loss of the sale contract, the loss of margin, the fact that we might lose the sale contract with AK Global and therefore have to replace it, and that might be at a higher cost. I say that there's just nothing in the argument that sort of loss, that kind of loss, is not foreseeable. Your Honour, unless you had any questions for me on heads 1 and 2, that's all I was going to say about them. That is the diverted sales and the lost margin. The head 3 is this lost transaction. And Your Honour will have seen the email that is an internal email, it's bundle D4, page 178, tab 178. That heralds a transaction which would, at least on its face, have generated profit of $35,000 US, and Mr. Chanana explains in his evidence, and also Mr. Gandhi explains in his evidence, the impact of the breach by IDBI, and that part of that impact was that Amira was unable to obtain credit from other banking institutions. And again, when one looks at the cross-examination of Mr. Chanana, it just is never, that conclusion is never challenged. All that is done is that, as I can see, is that I think it was Mr. Gandhi was taken, and I might be wrong, it was pointed out that the only contemporaneous document that shows that lost transaction is that email. But again, you've got the oral evidence from the witnesses. And in any event, I would suggest there's no real basis, no reason why you wouldn't accept that evidence, even if it had properly been challenged. If Your Honour recalls, Mr. Ravi Kumar accepted in his evidence that one of the measures that the bank had taken in response to the alleged default by Amira in 2018 was that it had entered details of the default onto a database which was accessible to other lenders. Not terribly surprising that IDBI, having told, in effect, the banking community that Amira was in default, Amira was then unable to obtain banking facilities of this sort. The 35,000, both experts accept, would have been subject to certain banking charges. I think Mr. Peters said he would anticipate that would be in the region of $1,000. Mr. Fritchie wasn't sure. He said it would be less than 5,000, but he didn't know whether it would be less than 3,000. So it's a fairly narrow dispute when it comes to the quantum of that. I wasn't going to say anything more about that. You've got my submissions in the skeleton things to small about. The next head of claim, however, is obviously on the most substantial, which is the harm to the reputation done to Amira as a result of this breach. And what is said against me is that I cannot prove that as a result of the breach, that led to harm of reputation which caused specific losses flowing from this harm. Special damages, I can't establish special damages. The answer to that, I say, is that I don't need to. And the first point to make on this is that I say the fact of the harm to the reputation has already been established in the May judgment. I'll show you that very briefly, if I may. It's in bundle E, tab 1, page 9. And it's paragraph 31. Second line, at the end of the second line, the failure to honour the facility agreement by the bank resulted in loss of present and future business and risk of loss of further business with knock-on damages to reputation. All those matters will be hard to quantify. So there is an established loss.
Sorry, I was looking at the wrong tab.
Oh, sorry, it's tab
I have
1, E1,
Yep.
page 9, paragraph 31. I was looking at the end of the second line. So that's, yes, the end of the second line, the failure to honour. So it's been established that there is loss of reputation, and I'll come on to the evidence in a moment. The second point on this is that there is a presumption of such harm. That I can show you that in a case called, I think it's called Corpora Law, but you find it in the authorities bundle at tab 8. And this is a judgment from the English Court of Appeal of Stanley Evans. Do you want to have it? It's bundle F,
Yep.
1, I think.
I have it.
Thank you. And if you turn, please, on the bottom right pagination to page 221, just for purposes of speed, can I ask you to read from the middle of that page? I will start with the authorities down to over the page on 222. You'll see the final main paragraph there. So the question becomes just to the end of that sentence for now, rather than me reading it out laboriously.
I have in fact read this before.
You've read it before, great. And so the other passage that I wanted to refer you on to is the passage at page 224 and the first paragraph of that. So the point there is that there is a presumption of loss as a result of the harm to a trading party's credit reputation, and you do not need to prove special damages flowing from that. So it's a general damages situation. Now, as to the extent of the harm, there is plenty of evidence of that from the witnesses. I'll give you the references for future reference in the witness statements. The first is Bundle B, tab 4, page 33. You'll see it paragraph 20, subparagraph C. I don't need to take your honour to it now unless you want me to show it to you. I can summarise the effect of it. Or we can go through it. If you
No, it's all right.
and then I was going to show you Bundle B, tab 5, page 44, paragraphs 26 and 27. And also paragraphs 29 to 32 and 35 to 39 of that document. And the effect of it, firstly, that they were unable to obtain additional credit, that they lost another major customer, and that the consequences, they say, are that the profits of the business fell. We also have evidence of the tumbling share price of the parent. To recall, it fell from $4.04 to $1.50. And in Mr. Chanana's third witness statement as well, she will find, I think at tab 7 of that, Bundle B, let's not go to it. Paragraph 29 again, he's saying in March 2019 that even then they still could not get financing. Again, just none of that evidence was challenged. And I reiterate again the fragility of this sort of business. It all depends. So letters of credit, for example, have been explained as the lifeblood of international trade. And that is why when letters of credit, people seek injunctions to restrain payment against them, and seek injunctions to restrain presentation, bank guarantees and those sorts of things in this context, the courts are very slow to grant those sorts of injunctions, because they're supposed to work like cash. Sorry, there's a question.
Yes, just to help on this point, how one fits an authority like the Kapura case in with the law of damages. Article 11 says compensation is only due for loss established with reasonable degree of certainty.
Yes.
At first blush, that throws some doubt upon things like general damages. Then, where the amount of damages can't be established, the assessment is at discretion.
Yes.
Is that the vehicle for bringing back in, as it were, general damages and relevantly here, a presumption of damage?
Yes.
So my question is, do you know of any authority in this court explaining how Article 11 works?
I do, and I've taken...
There's one decision that I had where I think I said something about it.
TVM Healthcare.
That's what it was.
So that's behind tab 5.
Okay.
And we can see that page 43 of the bundle.
This is an interesting question. What did I say?
You said it reflects the common law position when you take the two together.
Right.
It doesn't actually make much difference.
Okay.
Because what you said was paragraph 190. I think this is your judgment. I'm so sorry.
It was me.
Great. Paragraph 190 on page 43, if you have that. Under the damages law, loss must be established with reasonable degree of certainty. But this must be read subject to the direction where the amount of damages cannot be established with a sufficient degree of certainty, The assessment is at the discretion of the court. This reflects the common law position.
That was a rather different point. That was where
About the quantification.
where quantification was a hard task.
Yeah. So what I say about that is the question could arise. I can see how it could arise, but it doesn't arise in this case. Why not? Because A, I've got the judgment, which establishes the loss. And how you quantify that loss remains open. But that is what certainty of loss relates to. It's about a finding that Amira has been harmed in some way. And so the point in corporal, for our purposes, is simply that I don't have to show, for the purpose of quantifying that loss, specific, identifiable, pecuniary loss. You can still have general damages in the compensation part of it once you get to that phase. You also have evidence of damage in the sense that you have the evidence from the witnesses who say, well, we couldn't do this, we couldn't get credit, we lost a customer, we lost a supplier, all the rest of those sorts of things. And that damage to the creditworthiness of the claimant is established. Now, what is the value of that to the company? That comes at the second stage.
Yeah. Well, two things. One is an observation. I don't think it matters. I'm not at all sure that what Justice Cook said about there is damage to reputation is in fact a binding consideration, because it was not really a matter of issue before him. It probably doesn't matter because you have said there's evidence that shows that anyway. The second thing, back to my question, apart from the remarks in Hashimi, are you aware of any other cases in this court on how Article 11 works?
I think there is another case. Off the top of my head, I haven't looked at it. I think there is another case. It might be Carafi, but I can't remember. I think it's one of the Carafi judgments.
Well, if Mr. Carnell can find the reference to whatever is said and you can give it to me, I'd be grateful.
Certainly. I will dig that up. I'm struggling to remember. I mean, it could be the Court of Appeal looked at it in this case as well. Because your judgment was subject to an appeal which was dismissed. So they may have made observations in this case as well at the appeal stage. We don't have the transcript of that.
Anyway, let me know, please.
Will do. If you can just sort of give a Google, see if you can find it. They're going to make some inquiries now. If you can find it before I sit down, we'll provide it. But otherwise, I'll look in the break.
Now, how is timing going?
I'm almost there.
Should I take a break or not is the question. I imagine the court reporters would like a break.
Yes, I would have thought about 10 to 15 minutes left.
Okay. The way we're going, I think we may well not complete by lunchtime, so I think we might need to assume we're going to be gathering after I've dealt with this other case. That's a working assumption for the moment. How are you going? Can you keep going or not? Or would a break be good?
I think that would be good. I think we'll go back.
Yes. Take 10 minutes now, I think.
10 minutes?
Yes.
10 minutes.
All right.
Yes. Your Honour asked about whether there are any cases which have referred to Article 11. I've done a quick search. From what I can see, we've got the TVM case in first instance. There is a decision at the Court of Appeal level. From my reading of that, it's consistent with my understanding of it previously, is that there's no real judicial treatment of the question. They simply looked at the way Your Honour had approached the question, described it, and then they ultimately agreed with the conclusion, but they didn't clearly apply themselves to the question of how those two provisions interact. It's referred to also at the first instance level in a decision in the Ithmar Capital litigation, but again, might have to check this, but I don't think there's any real judicial treatment of the test, if I can put it like that. There are some small claims tribunal cases in relation to those. I would tend not to cite those as authority in this court. They can sometimes diverge a little bit from the mean, but there is one in which, for example, the court has treated the Article 11 tests in 1 and 3 as alternatives. So in saying, can you show with certainty that there is loss? If you can't show with certainty that there is loss, then you can get to the judicial discretion. I'm not sure that's quite right. It seems to me the first deals with loss and the second deals with quantification. So I think...
Well, the present question is how they fit in with the law in Overy, and that no doubt was not considered in the SCT.
No, quite. And I think, what would I say about that? I mean, I think there are policy reasons for the rule in Overy, and in fact, you can see in Overy when you read it that what Santi Evans was doing is he was saying, times move on, because the rule had originally only applied to parties who were, quote, traders, and so there was a long debate about what that meant. And he said, well, so far as this person isn't a trader, things have moved on. And if that's your business, in effect, then, you know, the law is prepared to assume that you will suffer that sort of loss. Now, I don't see any inconsistency between presumptions of that sort and the requirements of Article 11. Article 11 requires certainty. That certainty can be achieved either through presumptions or through evidence. I was then just dealing with this aspect of the loss and talking about really this issue, which is the fragility, the importance of these sorts of arrangements, and also the fact that the fault is with the bank. That increases the harm to the party, because people expect banks to act properly. So when they see that a bank is asserting that a customer is in default, then they will inevitably take that at face value. They will assume that this is a delinquent party that doesn't pay its debts. It's obviously going to be difficult to put a number on this. And plainly I say that this should be a very substantial number. It is difficult for you. We've tried to give you some assistance with that. In his witness statement, Mr. Gandhi had produced a table. He was asked some questions about that table. It is there. What it shows is revenues falling from 2017 to 2018 year. In that year, revenue was 958 million dirham, around $260 million. The profit in that year, 119 million, 0.61, which is about 32.5 million US. So that's what his evidence was, the profit was for that year. The projections, and that was what was investigated for the next year, were dire. They were revenue 502 million dirham, 160 million US, that would be, down from 260 million US. Profit, 34.5 million, which is about $9.4 million, down from 32.5 million US dollars. So that was the change in position. Now, it is said, well, you can't show that change in position was caused by these events. And I've explained that I don't have to show that, but I also rely on a discrete legal principle, which is that if a party is able to establish both a breach and the sort of loss which you might expect to see resulting from that breach, then the court will readily infer causation. It will take a robust approach to causation. That is best shown in a case called Drake and Harbour. I'll show that at tab 12. So this is a case called Drake and Harbour, English Court of Appeal. If you go please to page 357 of the bundle, you'll see just 2 paragraphs I'd like to draw your attention to, Your Honour. The first comes in the judgment of Lord Justice Longmore, paragraph 15, causation. He says, it's convenient to deal with causation first. It seems to me that in a case where negligence has been found and the damage which has occurred is the sort of damage which one might expect to occur from the nature of the work which the defendants have been carrying out, a court should, as Lord Justice Chadwick said in a slightly different context of Roadrunner and Dean, be prepared to take a reasonably robust approach to causation. And then he endorses what the judge has done. And in the judgment of Lord Justice Tolson, as he was, you go forward please to page 360, paragraph 28. In the absence of any positive evidence of breach of duty, merely to show that a claimant's loss was consistent with breach of duty by the defendant would not prove breach of duty, if it would also be consistent with a credible non-negligent explanation. So that's when you're dealing with the question of breach. But where a claimant proves both that a defendant was negligent and that loss ensued which was of a kind likely to have resulted from such negligence, this will ordinarily be enough to enable a court to infer that it was probably so caused, even if the claimant is unable to prove positively the precise mechanism. It does say that is not a principle of law, nor does it involve an alteration of the burden of proof. Rather, it is a matter of applying common sense. So, I don't say it's a principle of law, but these are the kind of losses that one would expect to see. Tumbling profits resulting from this sort of breach. And so I say Your Honour can join the dots insofar as you're not satisfied that the evidence itself, which there is, fills that gap. All right. Now, obviously, that is we've got the amount that is sought in relation to that, and I'll give you that in my headlines, $89 million. I'm not going to say any more. I'm going to come down from that. I understand that everyone's going to have to apply a mind to how that is. I've given you, I hope, the help, the assistance that I can to show you the sorts of features of this case which will guide you in that exercise and which I say should lead to a very substantial award in relation to this. This is a substantial enterprise and it's had serious damage to its financial standing. The next head of claim then is the loss management time. I won't spend much time on this, it's a small aspect of the claim. It's a little over $14,500. It is based on Mr. Gandhi's salary. He gave evidence as to what that was. It's not challenged. It wasn't challenged in evidence, albeit it was pointed out that we don't have a copy of the contract. We don't have a copy of the contract, but he's told us what's in it. You've heard from Mr. Gandhi. If you think he's lying, no doubt you can decide that. But there's no reason to reject his evidence on that, I would suggest. You've also got a schedule which, for the references at D4193, it sets out the times he says, so it's bundle D4, tab 193, the times he says he's spent on this enterprise. He accepted in evidence that it is an estimate. He thought that it was pretty accurate. It is not exactly excessive, say, so there it is. It's taking him away from his general role, which is in the management of the company. It was said that because it's not an incremental cost, it can't be recovered. I can show Your Honour the authorities on that, or I can just give you the reference to Mr. Justice Ramsey's decision in the Bridge UK case. If you go to the authorities bundle, tab 10, you will see there, page 266. He relies on a case called R&D Vesicarum. We can look at it if it's helpful. It's tab 10.
This takes up the judgment of Justice Gloucester.
That's right, yes. Lady Justice Gloucester in the R&D Vesicarum case. But it's just a more recent recital of that judgment and a fee. But The RMV case is a particularly complicated case, and so it can be quite difficult to navigate the judgment. That's why I put this one in, but it's the same thing. So as a matter of principle, it's recoverable. Obviously, it needs to be demonstrated that there has been substantial diversion of management time away from the ordinary course of business. But the principle to put against me is, well, because there's no incremental increase in costs, that is not recoverable. That is wrong as a matter of law. It is recoverable, and in effect, it is an instance of a claim for wasted expenditure. So the court is entitled to assume that all things being equal, that time would have been spent on activities which would have at least brought in enough profit to cover the salary, because that's how businesses operate. So it's a very conservative approach to that sort of loss. The next head is interest. This is the interest that was paid, demanded on the 22nd of April 2018. The demand is at bundle D4, tab 153, and it was subsequently paid by the claimant. There is a calculation of that interest. It's a $41,000 payment. The claimant, in fact, the demand was for just slightly less than that. The calculation of that interest is in bundle D4 behind tab 187. And I say, when one looks at that calculation, it's quite difficult to understand, but what can be seen is that it is based on the assumption that the buyer's credit was due for payment and overdue for payment. 26th Feb, buyer's credit was overdue for payment as at the 22nd of April 2018. And so that depends on whether it was in fact, so the calculation depends on whether or not the bank can rely on that, and I say it can't. I won't repeat that ground. So I say, if there is a proper counterclaim here that needs to be met, it should be deducted from that counterclaim. If there isn't, it should be handed back. My learned friend says, well, he doesn't understand the basis of that claim. I say it's pretty simple. If you demand payment from someone and get that payment, and it turns out that it was never due, you generally, under the law, have to return it or knock it off what would otherwise have been due. It sounds in restitution because one party has been unjustly enriched, you have received it, unjustly enriched at the expense of the paying party, and the relevant provision, though it doesn't go much further than just say unjust enrichment, is the DIC Rule of Obligations, Article 33.
Well, I would hope that this really turns on whether the interest was payable or not. If it wasn't, I would hope that the responsible bank would not say it was entitled to hang on to it.
Not quite. That appears to be its position at the moment. But there we are.
We'll see.
We'll see. That is it for the claim. There is obviously the counterclaim against the third-party claim against Mr. Chenana, and I'll leave that. Albeit I haven't got much to say about that beyond his counterclaim.
But you've got Mr. Chenana's own claim.
And then I've got Mr. Chenana's own counterclaim.
Yeah.
So I'll deal with that very quickly. The simplest explanation of it, if I can take you to this was a calculation I started to attempt with Mr. Fritchie, if you recall, and I'm afraid I suggested...
Even before we get to quantification, does Mr. Chenana need a cause of action, and if so, what is it?
Well, that's never been a point taken against me. If I had to answer that question, I suppose I would say that he's entitled to insist on the terms of the facility agreement himself under the provisions for third-party rights, because in effect the court can find that the obligations of the bank under that contract are obligations in part for his benefit.
Well, wait a minute.
So breach, therefore, sounding damages taken.
Well, that might need a little bit of amplification, because I don't have in mind enough detail.
Yeah.
Under the facility agreement, subject to my looking at it more carefully, I don't think the bank, I'm sorry, I'll put it differently, I don't think the bank promised in the irrevocable letter to Mr. Chenana to make the payment.
Correct.
I'm not aware that in the facility agreement it promised Mr. Chanana to maintain facilities, issue bills of
No. There's no express
buyer's
terms
credits,
after that.
etc., etc. So he doesn't have a promise to rely on.
Correct.
What has he got?
Well, as I say, I've not developed a case on this because no case has been advanced against me on this. But,
Well,
if pushed,
there's a general denial, though.
yeah, if pushed, I would suggest that because he was given the guarantee at the time, that therefore to that extent, he as a third party under the rights of third party contracts, that the effect of the facility agreement is to confer a benefit on him. It's a negative benefit. That is that there will be compliance with the facility agreement. It may be that it doesn't matter, in the sense that clearly there is a degree of overlap between what he says he has lost and what Amira has lost, because the effect on his shareholding is the result, he says, of the damage to Amira.
Yes, but that's why I asked, though, whether he needs a cause of action in order to recover that.
I hear what you say.
I don't know whether Mr. Francis is going to press, but
Well, he
consider
may-
me pressing.
He may now.
He may now.
Thank you, Your Honour.
And I don't think I'm being silly, because
No.
I really ought not to grant relief if I cannot see a basis for it.
I understand. Well, look, I'll take some instructions on that.
Indeed.
I'll see whether I can adjust the position in relation to that. But I think, that's the best answer I can give you to that question.
Right.
All right. So, in which case, I won't take you on to that calculation for now. Well, perhaps I should just to show.
Deal with that now. Then you've dealt with it subject to one.
I'm grateful.
Yeah.
If you look then, please, at bundle A, and it's the second to last page in bundle A, you've got this calculation.
Yeah.
And the point there is that the price dropped from the 14th of February 2018 down from $4.04 down to $1.50 on the 12th of October 2018. And so, leaving aside causation and liability and the rest of it, what was Mr. Chinana's loss as a result of that fall? And what happened during that period is certain shares were sold off at different times at varying prices as the share price fell. And so what you can say is that if you add up the amounts achieved for the total sales of those shares, a little bit over 1 million shares were sold, you can compare the price that was received for that to the value that they had at the 14th of February. And the difference is then going to be 4 million, which is the sum which reflects the value of just those shares at 404, and the sum received, which is 2.5 million, just short. And if you could take one from the other, then you get 1.55 million. So
in principle, though, isn't the correct comparison between the price at which they were sold and the price which they would have held at the time of sale,
Yes.
but for the breach?
Yes.
Is not necessarily
I agree.
the price as at February.
Yeah. If there were other factors at play that caused the fall in the price, the fluctuation in the price, then it wouldn't have been caused by the breach.
Then we're thrown into the question that is otherwise a little obscure. Other things may have affected price.
Yes. But what things? What's the case on that? So I accept that. I accept everything you already said. That is logically possible. All I can do at the moment, and I don't want to dwell too much on this and spend too much court time on this. All I can do at the moment is show you for now what the financial damage to Mr. Shannon, what was that financial damage as a result of the share price falling. I agree that there is then a subsequent question: was that fall all or partly caused by these events, and if so, is the bank liable for it? So at the moment, I'm just dealing with the first part of it. This is how you calculate it. And as I say, you do that by taking the value at the high price, knock off what you've received along the way, and then you know, amongst what was sold, what the difference is. And the difference comes out at $1,553,895.74. So that's the loss over that part as a result of the falling share price. That's not the full extent of his loss as a result of the falling share price, because the share price has fallen across the whole of his shareholding.
Why does one look at that for when he retains the shares, and for all we know they may be worth $1 million each tomorrow?
Yes, but then you're into the question of collateral benefits. So the question is, what's his loss? And you normally would say that the loss is the reduction in the value of his asset. So as I said, I think in opening I started to embark on a diversion into house prices. But so say someone tells me, so a surveyor tells me that the house that I'm proposing to buy is worth $1 million and it's actually worth $500,000. I then buy that house, I spend $1 million on it. My loss, principally, is the diminution in value, the reduction in value of that property, whether I sell it at $500,000 or not. The fact is, I've ended up with an asset that's worth less than I paid for it.
But that's because you paid more than you should have, so that was a loss that crystallised at that time.
Yes, but the reason it crystallised at that time is because the asset that I'm left with is not the price I paid for it. So do you see? So it's not about what happens next, which is whether I sell that property. So the distinction that you're drawing is actually the one that comes before, which is how did I come into this property? How did I get hold of it? What did I pay for it? And that, my position is that should not be relevant to the calculation, because Mr. Chinana's position, having been the shareholder of this as a founding shareholder of the company, should be no different than somebody who had come in on the 14th or 13th of February and paid $4.04 for the share price. Their positions, as at the next day, 14th of February, are identical. So one leaves out of account how they came into the assets. The real question is, does it matter that he didn't sell those shares? Does it matter, therefore, that they might recover in value? The answer to that question is no, because the assets that he has are not worth as much as they were before. So his net value, his net asset value is reduced, and that therefore is his loss. Anyway, it may or may not matter. So I'll unless you wish to engage further, then I'll leave it there if I may.
Thank you.
And that's it for the claims and Mr. Chinana's counterclaim. As Your Honour has seen, there's really nothing, I would say, legitimately between the experts. So if Your Honour accepts my position, the proper scope of the expert evidence should be confined really to matters of accounting expertise, then much of what Mr. Fritchie says about what he thinks the contractual terms were must be inadmissible and irrelevant. Those are matters for you, the evidence that you have, and his evidence is not part of that. I would suggest that Mr. Fritchie just quite clearly, unfortunately, does not grasp the distinction between evidence of fact and evidence of opinion. But there we are. There can be a fine line at times, but in this case he's well over it, unfortunately. That said, as I intimated at the outset, it may be that Your Honour will come to certain factual conclusions in the course of your judgment, which could then be converted by the parties into damages. Now, obviously, the more specific those are, the easier it's going to be, and the less likely there is to be any dispute about it. But I would be very surprised if, for example, Your Honour was to reach conclusions about terms of sale and supply, and what was supplied, and therefore what remained to be supplied in the terms that they were ultimately had to be supplied on. If you accept my case, for example, on those, I'd be very surprised if the parties can't reach agreement on the numbers, no doubt with expert input just to do the calculations. But that may be one route, one avenue going forward for you. But we're in your own hands on that. That's all I had to say about my claim, Your Honour, unless you'd like to hear anything further from me.
No, I think it was
I'm grateful, thank you.
Well, Mr. Francis, it would help me if you first responded to the claim, then moved on to your counterclaim. But take your case if you need to mix them up.
Your Honour, I was planning to respond first. Thank you, Your Honour. I'll first start with the factual background and then submissions on each of Amira's claims, and then submissions on the bank's counterclaims, and then Mr. Chinana's claim. So starting with the key factual background, this is a tale of two transactions. One transaction that was presented to the bank, and a very different transaction that was agreed between Amira and AK Global. In my opening submissions, I noted that there was a significant difference between the facts that have been presented to the bank by Amira and AK Global and the facts that have emerged over the course of these proceedings. After the witness evidence at trial, we now have a few additional jigsaw pieces that allow us to reassess the factual picture that was presented to the bank from February 2018 and which was presented to the courts in May 2018. So, following the witness evidence at trial, the key points are that in 2018, Amira and AK Global only presented the bank with a 10,000 metric ton contract as the basis for the irrevocable letter. Amira and AK Global did not disclose to the bank that the 10,000 metric ton contract had been agreed between Amira and AK Global as part of an arrangement with a 30,000 metric ton contract plus other undocumented agreements. I'll run very quickly through the communications between Amira and the bank between the 1st and 8th of February 2018, but as I took you to those documents in opening, I won't turn up those documents unless you want me to, Your Honour. So on 1st of February 2018, the bundle reference is D371 for your note. Amira says payments will start coming in 15 days, which will enable it to settle the existing buyer's credits, and they will pay the supplier with fresh buyer's credit. Amira says that to get this payment in our account, the supplier has requested that the bank issue a fresh, irrevocable letter. On 7 February 2018, the bank requested, quote, contract copies pertaining to the transaction, end quote. And they also asked for the request letter from Amira's supplier.
Reference, please.
That's the same page.
Same page,
so
right.
D371.
Yep.
And then D371, the page reference is 500. It's the same tab.
Yeah, this is the chain of email.
Yes, it is, Your Honour. On 8th of February, Amira emailed the bank attaching the letter from AK Global and the 9 January 2010 contract with AK Global, which is, of course, the 10,000 metric ton contract. Amira says off the back of these documents, quote, request you to provide us irrevocable letter at the earliest, end quote. So, Amira and Mr. Chinana have confirmed that the attachments to this email were indeed the 10,000 metric ton contract, which bundle reference D243, and that's dated 9 January 2018, for shipments up to March 2018 at a purchase price of 13778 per metric ton. And the AK Global letter, dated 28 January 2018, the bundle reference is D246. This is the letter that was attached to Amira's email to the bank, and it requested the irrevocable letter, open quote, against the current shipment of that 10,000 metric tons, end quote. And of course, the Amira has, and Mr. Chinana have confirmed today that that's all agreed in terms of the documents that were provided to the bank in connection with the irrevocable letter. So on 11 February 2018, the bank issued the irrevocable letter, bundle reference D16 for your note, and it was issued to facilitate, open quote, the said transactions, end quote. Okay, that's what was presented to the bank. Now let's look at the very different transaction that was agreed between Amira and AK Global. Now, after your order with reasons in respect of the applications for new factual evidence, your order came out dismissing the application to put in the new factual evidence, we noted that you treated the 11 July 2019 letter differently. And we couldn't work out why, because we hadn't seen the reason. So that just caused us to break our sort of Chinese wall, to have a look at this document, to look at it more closely, to see what was in it. And when we did that, we noticed it gives us a few additional jigsaw pieces from which we can step back and see the wider picture. The letter, the reference is D4 tab 197, and I don't need to take you to it because we've been to it many times, but please let me know if you'd like me to. At trial, Amira confirmed that the 10,000 metric ton contract was in reality part of an arrangement with AK Global, which is described in the AK Global letter dated 11 July 2019. So that arrangement is that 30,000 metric tons of rice would be supplied at an average price of 128,750 per metric ton. AK Global would, quote, would supply various volumes at various prices according to Amira's requests, quote. The purpose was, open quote, managing the cash flow and bank facilities, close quote, so Amira could, open quote, hold the majority of their profit with their preferred bank, close quote. Open quote, the documents were made as the business required them, close quote. Open quote, the discussions of this structure were done in person on the phone, close quote. Now, Mr. Chinana endorsed AK Global's explanation of that arrangement between Amira and AK Global under cross-examination. The reference to the transcript is day one, starting from line 127, and I simply asked him, do you agree that this letter sets out the accurate description of the arrangement between AK Global and Amira in relation to the 30,000 metric ton contract? He said, yes, it does. I also asked Mr. Peters yesterday if Mr. Chinana had explained the arrangement in relation to the 30,000 metric ton contract when, for the purposes of his expert report, and Mr. Peters confirmed that he had, and Mr. Peters confirmed that the explanation Mr. Chinana had given to him was also consistent with what is set out in that AK Global letter dated 11 July 2019. So, Mr. Chinana confirmed under cross-examination that the 10,000 metric ton contract is part of an arrangement between Amira and AK Global to direct Amira's profits to its Mashreq bank account and to hold those profits away from banks like IDBI, where Amira has credit facilities. Now, the transcript reference for that is day one, starting page 130, lines 10 to 18. So I said, question, so Amira would direct the higher profit transactions to a bank where it could hold those profits safely away from any credit facilities. Is that correct? And the answer was, that's what we do to manage our cash flow. That's correct. My question was, and to manage your credit facilities, not just cash flow. And the answer is correct, correct. Mr. Chinana confirmed on the cross-examination that the price in the 10,000 metric ton contract had been agreed between Amira and AK Global in order to reduce the amount of profit that would be paid into Amira's account. Mr. Chinana also confirmed that this had not been disclosed to the bank. So, day one, page 132. Lines 1 to 7. My question, so Amira did not disclose to IDBI at the time of arranging the irrevocable letter that the price in the 10,000 metric ton contract had been agreed between Amira and AK Global at 1378 in order to reduce the amount of Amira's profit that would be paid into its account with IDBI. The answer was that's correct. So how does the 10,000 metric ton contract fit into this arrangement between Amira and AK Global based on what Mr. Chinana has told us? Well, Mr. Chinana says that it is a partial execution of the 30,000 metric ton contract. It moves 10,000 metric tons of rice under the 30,000 metric ton contract. However, this contract is not only being used to move rice, it's being used to move money. The price agreed between Amira and AK Global in the 10,000 metric ton contract has been agreed for the purpose of moving Amira's profit into the hands of AK Global. Under the 10,000 metric ton contract, Amira's profit is $20 per metric ton. That's a nice round number. Under the 30,000 metric ton contract, Amira's profit margin is $110.50 per metric ton. So 50 cents off being a nice round number. So under the 10,000 metric ton contract, Amira is overpaying AK Global at a rate of $110.50 per metric ton minus the $20 per metric ton. So that's an overpayment of $90.50 per metric ton. This is over-invoicing. So if all of the 10,000 metric ton contract was paid through IDBI, AK Global would have been overpaid by comparison to the real price agreed between Amira and AK Global in the 30,000 metric ton contract by an amount that is equal to 10,000 metric tons times the overpayment, $90.50 per metric ton. So that's the total profit that they intended to pay across to AK Global, from Amira to AK Global, of $905,000 US. Now, the question is, how is that profit recovered by Amira? Mr. Chinana has told us in his evidence at trial, and the AK Global letter of 11 July 2019 also tells us. There should be other transactions where Amira pays AK Global less than the real price agreed in the 30,000 metric ton contract. So an underpayment to AK Global and other transactions. This would be under-invoicing. It could be made in a different way, such as a direct payment from AK Global to Amira. Now, the 30,000 metric ton contract was disclosed for the first time in these proceedings with Mr. Peters' expert report on 28 January 2019. Also disclosed at the very same time in Mr. Peters' expert report was the 8,200 metric ton contract. Now, it confused us at the time we received these documents. Of course, we didn't have Mr. Chinar's explanation, we didn't have AK Global's letter dated 11 July 2019. We couldn't see the commercial rationale in how Amira said it related to the 10,000 metric ton contract. We thought that Amira was trying to link the 10,000 metric ton contract to the 30,000 metric ton contract in order to inflate its claims. We did consider whether or not the 30,000 metric ton contract was a genuine contract or not. But the AK Global letter dated 11 July 2019 has finally resolved this point, as has Mr. Chinan's evidence at trial. It is the 10,000 metric ton contract that is not a genuine arm's length contract. The 10,000 metric ton contract was not treated as a genuine contract between Amira and AK Global. If you ignore the 10,000 metric ton
not
contract...
treated by them as genuine.
Treated by them, Your Honour.
Not, you say it was not.
It was not treated.
Find that it was not treated by them as genuine.
As a genuine arm's length contract.
Well, what does that mean?
Well,
that it was a sham?
Well, they agreed an artificially high price. That's what I mean, Your Honour.
Right.
So if you ignore the 10,000 metric ton contract, the 30,000 metric ton contract and the 8,200 metric ton contract suddenly make a lot more sense. Now, the 30,000 metric ton contract, so bundle reference D242, dated 9 January 2018, so the same date as the 10,000 metric ton contract, but a different price, at a price of $128,750 per metric ton for a shipment period up to March 2018. Now that's a profit margin of $110.50 per metric ton. The 8,200 metric ton contract, bundle reference D3139, contract dated 5 March 2018 at a price of $1,289 per metric ton. So $1.50 difference per metric ton. Very, very similar to the 30,000 metric ton contract. But the shipment period picks up from where the 30,000 metric ton contract ends on its face, for a shipment period of up to May 2018, and a profit margin of $109 per metric ton. So again, very similar profit margin to the 30,000 metric ton contract. And then also the Tia Agro contract also makes a lot more sense.
Well, just before we get to that, if the 10,000 metric ton contract was a sham, so also was the 8,000.
Not necessarily, Your Honour.
Why not? On the evidence which you at present seem to accept of the explanation of structuring execution contracts. If one was a sham, the others had to be a sham.
Well, not necessarily, Your Honour, and we don't know the answer to that question. But
I'm putting a proposition to you of logic.
well, no, I think if you treat the 30,000 metric ton contract and the 8,200 metric ton contract as a contract which is regarded as genuine between Amira and AK Global, the contract terms make sense. The price is more or less the same. The product is more or less the same. The shipment periods explain why they entered into another contract on the 5th of March. Because the 30,000 contract shipment period was due to end in March 2018. So, if these contracts are valid between the two of them, we don't know, but if they are valid, they needed another contract for the next shipment period.
Well, back to the question of sham. Let's assume for the moment that, without looking at any others, that the 10,000 metric contract was a sham. Two questions seem to follow, one of which is what flows from that in your submission?
Well, I will come on to that, if I may, Your Honour, because I rely upon the 10,000 metric ton contract for the purposes of what was foreseen and what could have reasonably been foreseeable to the bank. I also rely upon the 10,000 metric ton contract for a second purpose, which is whether it amounted to an event of default from whether it caused an event of default from the very day of the issue of the irrevocable letter as a result of a breach of the information representation warranties. So I rely on those two purposes.
Let me into the secret. Is that the significance of your submission, that it's a sham? Namely, that because it was a sham, there was an event of default. Is that your point or not?
Well, there's those two purposes that I've gone through. But
No, just think about my question. I think it's a simple question.
Well, I'm not necessarily saying. I'm saying that the information was not accurate that was given to the bank, and that is an event of default. So that is what I'm saying.
Well, you don't need the word sham for that.
No, I don't.
Right. Well, so what is your point in categorising it as a sham?
That if it's been presented to the bank as a genuine arm's length contract, and that's not the case, then that's a breach of the information the representations and warranties in respect of the information that should have been given to the bank at the time the irrevocable letter was granted.
I don't know whether you're maintaining sham or not at the moment.
I don't think I need to, Your Honour. What I intend to rely upon the contract, so the 10,000 contract for the purposes of, is a breach of those information representations and warranties and what was foreseeable.
Well, this is quite significant, because if you use the word sham, that suggests some impropriety on the parties. And that is something which, even before Mr. Montague-Smith's submissions with which he began, about what I know as the rule in Brown and Dunn, I intended to tax you with, because you did not put anything of that kind to Mr. Chinana.
Well, Your Honour, I don't need to rely upon that word or rely upon that allegation. All I need to rely upon is the explanation that Mr. Chinana and AK Global have given as to how the 10,000 metric ton contract operates.
Do you now accept that A, there was a 30,000 metric ton contract, and B, that the other contracts related to it in the way explained by Mr. Chinana and through the letter of the 11th of July?
Well, we can't assess whether we don't see the full relationship between Amira and AK Global. That's my point. But if we take what they say about how it operates, that has an implication as to what was told to the bank as at
Well,
February
maybe,
2018.
maybe it does or does not. But do you wish to contest what they said? Or more precisely, what Mr. Chinana said when he endorsed what was in the letter of the 11th of July?
Well, for the purposes of what was foreseeable, and for the purposes of whether there was an event of default as of February 2018, I don't need to.
For any purpose at all. I need to know what you say I should find as facts.
What my submission is that you should find on fact is that the full picture of the 10,000 metric ton contract in relation to the 30,000 metric ton contract and the arrangement between Amira and AK Global was not disclosed to the bank as at February 2018.
Right. Well, implicit in that is that that was a true and correct picture which was not disclosed. Is that your submission?
Well, that's what Mr. Chinana has said with respect to.
And do you take issue with it?
Well, I say it leads to implications, which is.
Really, please, Mr. Francis. You can do better than this. Face up to having to make a decision.
Well, I don't want to raise my burden of proof above what I need to raise, and I don't want to have to amend my pleadings to make an allegation. And I didn't want to have to make an allegation that I didn't need to make, when the explanation that's been given by AK Global and Amira in these proceedings is sufficient to establish the points that I wish to make.
Well, in the absence of a submission that I should not accept Mr. Chinana's evidence on the fact that there was a 30,000 metric ton contract and the other contracts were execution contracts, I'd be inclined to accept that evidence. I would have no particular reason not to. But if you want to say I should not, now's the time to say it.
Your Honour, you can accept that evidence as long as it's very clear what was presented to the bank as of February 2018.
That's then the next question.
Yes.
If I accept that evidence, then that in fact enables you to say those were the true facts and they were told to the bank. Surely it's in your interest, if that's your point.
Yes, Your Honour. That's exactly what I apologise, Your Honour. That's exactly what I've been trying to say.
Well, all right. Well, it seems to me that you have withdrawn any reference to sham, and your point is simply that the facts were otherwise, in that the facts, as in the letter of the 11th of July and endorsed by Mr. Chinana, were not disclosed to the bank.
Yes, precisely.
All right, we could have got there 10 minutes ago. Carry on.
I apologise for being slow, Your Honour. So I was just about to make the point on the Tia Agro contract.
Yes.
So D4 tab 175, and just to draw attention to how it appears to relate to the previous contracts between Amira and AK Global. So the 30,000 metric ton contract, the 8,200 metric ton contract, and now the Tia Agro contract. So it follows on from the next shipment period for the 8,200 metric ton contract. So this one, the Tia Agro, is up to September 2018, but now, of course, it's for a new 2017 prop and a new supply price of 1389, and the S&P matrix records a new sale price to Kuwait Flour of 1549. So that's a better profit margin on those figures for Amira of $160 per metric ton. So going back to the documents that Amira presented to the bank in February 2018, these gave the bank the following information: that Amira's profit margin on the 10,000 metric ton contract was $20 per metric ton, and that there was 7,000 metric ton remaining to be delivered under the 10,000 metric ton contract. So, for the eyes of the bank, that looked like a maximum profit for Amira of $140,000. For your notes, I'll just take you through the documents which were presented to the bank, which would have allowed it to foresee that that was the maximum profit that would have been payable under that contract. So D380, this is an example of this is an email 14 February 2018 which confirmed that the bank received 6 payments of $699,000 each from Kuwait Supply Co. So a total of 4.194 million. And then the following documents were also provided by Amira to the bank on 14 February 2018. So 6 inward remittances. So the example of the 6th one is D391 for your notes. And then 6 corresponding invoices. So D269 is the example of the 6th one, so for invoice 148. And then 6 outward remittances. And the example is D392 as an example. So what are the implications of the facts that were presented to the bank by Amira and AK Global in February 2018? Well, that Amira and AK Global were engaged in a very low profit transaction for $20 per metric tonne. At the hearing in May 2018, Mr. Justice Cook commented that this was a very low profit margin. Amira presented itself to the bank as needing further financing from the bank in order to enable it to generate cash flow to pay down its existing debts. We see this in the February 2018 emails from Amira to the bank. So, okay, let me focus on the legal relevance of the facts that were presented to the bank in February 2018. So the first point, the relationship between the 10,000 metric tonne contract and the 30,000 metric tonne contract and other contracts was not, in fact, foreseen, and we submit could not reasonably have been foreseen by the bank as at 14 February 2018. So accordingly, we say the bank is not liable for any loss in relation to the 30,000 metric tonne contract or any other arrangements that were not disclosed to the bank as at February 2018. So, from the bank's perspective...
I'm sorry, when you say or any other arrangements, you mean the 8,200 metric tonne contract or anything at all, anything other than the 10,000 metric tonne contract? That's your ultimate submission.
That's correct, Your Honour. Yes, it's correct, Your Honour. But I'm trying to refer to any other unusual arrangements or something that would not be... But let me just stick with those 2 contracts for the moment. So the 8,200 metric tonne contract...
Well, your reference to unusual contracts just throws up more questions.
Sorry, not unusual contract, the unusual arrangement. So the 10,000 metric tonne contract, as it related to these other contracts, that was not foreseen by the bank. That was only...
Well, what do you mean by that? What's an unusual arrangement that's not foreseen?
Well, the balancing arrangement, which meant that actually the profit for that rice would be much higher than the profit that had been disclosed by the documents that were provided to the bank. So they could not foresee that, as at February 2018, that if this contract was breached, there would be a significantly higher loss of profits as a result of this arrangement that had not been disclosed.
They could foresee that there would be a loss of profits.
Yes, Your Honour.
So, but do you say that it was necessary that they be able to foresee what the level of loss of profits would be?
To a certain extent, I do. I say, well, if it's...
Either you do or you don't.
Well, if there were going to be extensive losses, so if there was going to be a massive difference between a loss of profit of, say, $20 and $110.50 per metric tonne, or indeed a much higher one in terms of a potential balancing arrangement later down the line, we say yes, that was not foreseeable. And I think I was going to come on to the authority that Mr. Montague-Smith, or the extract from Chitty that Mr. Montague-Smith took you to, but Your Honour, I think the starting point is, as you said, is the DIC law of damages and remedies, Article 12, and I think just a common sense approach of that provision and seeing what was foreseen and what was reasonably foreseeable, what could have been reasonably foreseeable to the bank as at February 2018 is enough to exclude any loss of profits from a contract that was not disclosed to the bank.
Yes, well, I can understand the submission that if the only contract to the knowledge of the bank was the 10,000 metric tonne contract, any related contract was not within foreseeability. I have huge difficulty with the submission that even within that contract, which I don't think has been highlighted before, there couldn't be foreseen, that there had to be foreseen the level of profit which would be lost. Now, as I understand it, that is now part of your submissions, am I right?
Well, let me clarify in case if I've confused the point. We say that the information provided to the bank showed a profit margin of $20 per metric tonne. So we're saying the maximum loss that the bank could have seen in February 2018 as a result of breaching that contract after a completed shipment of 3,000 metric tonnes is that profit margin on the remaining 7,000 metric tonnes. So $140,000 US. That's the extent of my point on that one.
Yes. All right. Thank you.
Okay, this is my second point on the legal relevance of these facts. We say from the very outset of the irrevocable letter in February 2018, Amira was in breach of its information, representations and warranties and facilities agreement. So this means that there was an event of default as at the date of the irrevocable letter.
Right, well, we'll come on to event of default in relation to your counterclaim, won't we?
Yes, Your Honour, but you did challenge me in opening, and I was not as familiar with the event of default terms as I needed to be to provide you with a proper response.
Let me stop you. If you're responding to the claim, continue with that. You will come on to your counterclaim to which an event of default is relevant in due course. Would it not be best to leave it until then?
Well, I think it's also relevant to the loss and damage that Amira can claim. If there was an event of default, as at the time the irrevocable letter was entered into, we say it can't be right that they can claim loss and damage as a result of any breach of the facilities agreement.
Why not? Well, they're claiming loss and damage because of a breach of the irrevocable letter.
Well, I'm going to come on to that as well, Your Honour,
Uh-huh.
because I think there's a difference.
But you say, well, so far as the bank is liable for breach of the irrevocable letter, do you say that the existence of an event of default somehow prevents recovery of damages for that breach?
Well, I think the position is what would have been the position for Amira had we made the payment under the irrevocable letter as at that date. And what I was going to come on to is, well, if there was an event of default as at the date of that payment, if we'd known there was an event of default, we would have been entitled to make that payment, treat the payment as some sort of advance to Amira, but then immediately recall it. And that would not have been unreasonable at that time.
Well, that, however, would seem to go only to your counterclaim, because that would have, the result of that would be a submission that Amira would have been unable to repay, on any view, the buyer's credits due on the 26th of February. That seems not to relate, however, to a defence to the claim.
Okay. Let me deal with it in the context of the counterclaim. But my submission for at the moment is until I come back to it in the context of the counterclaim, is that there was an event of default from 11 February 2018 that was continuing.
All right. Okay. Well,
And this is based on clause 12.1 of the Facilities Agreement, D1 tab 2, the Information Provision Act K on page 57, and then just confirming that misrepresentation is an event of default, clause 14.1b. So, yes, I mean, I've made my points on this. It meant that the bank could refuse to provide any buyer's credits, and it also means that the bank could enforce its rights under clause 14.2 at any time. I'll come on to the detail of how the event of default provision works when I come on to the counterclaim, but the short point is that there's no particular form of notice or advance warning that is needed. It's just a question of fact. Was there an event of default at the time? If there was, the bank would have been entitled to all of its remedies under the Facilities Agreement. So I'm coming on to the irrevocable letter, and I'm going to cover one of the points you've raised. So obviously the irrevocable letter is at D1 tab 6. Now, this irrevocable letter has an obligation to pay AK Global amounts once payments have been received from Kuwait Flour. There's no obligation in the irrevocable letter for the bank to provide Amira with buyer's credits. So the question is, was the bank obliged to provide Amira with, to grant its request for buyer's credits?
But isn't that a question which only relates to the counterclaim? Once you have the irrevocable letter and it's breached, we're into quantification of damages. Material to that is foreseeability in relation to the elements, let us say, of the $30,000 metric tonne contract, and we're dealing with that. But once a decision is made about foreseeability, then we get to more calculations, to which what you've just said is not relevant. It doesn't matter for that purpose whether or not the bank would have issued further buyer's credits. Does it? I may be wrong. Please correct me if I am.
You're correct. It's the question of what damages. The point I was trying to address is whether or not Amira can claim loss and damage based on the allegation that the Facilities Agreement was breached. So that's possibly a separate question that we can address when I cover the counterclaim. I did want to cover the compare and contrast the facts that were given to the bank in this period from 14th to 19th of February, in order to just make clear what the factual background is before I descend into dealing with the particular heads of claims of Amira. So, if I may, I want to go to the letter from Amira to the bank, dated 19th of February. So that's D3 tab 122. So here, it's just below the table, it says shipment to our buyer, Kuwait Supply Co. is at loading stage. It says the documents will be ready and forwarded to the buyer by second week March 2018, for which inward remittance will be received during third week of March 2018. Hence, we hereby request you to allow us extension of 30 days to settle the above buyer's credit. And then the third paragraph under the table and the second sentence. We request you to arrange fresh buyer's credit and release the payment by today/tomorrow. The delay in releasing payment will result in delay in next shipments, which will create issues with our buyer, which is a government entity. So we say that Amira gave the bank the impression that it needed three things to enable it to proceed with the next shipments. That's the phrase they use in this letter, in order to bring in further cash to pay down the existing buyer's credits. An extension of 30 days to pay the 26th February 2018 buyer's credits totaling $2.5 million US. A payment by the bank to AK Global under the irrevocable letter in sum of $4.134 million. And a fresh buyer's credit of $4.134 million to finance the payment under the irrevocable letter. So we say this is a further breach of the information, representations and warranties of the facilities agreement. As a matter of fact, this was not true that the next shipments would bring in payments to IDBI. If I can take you to bundle B, Mr. Chinana's witness statement. So tab 1, page 8. This is paragraph 47, and it's under the heading, The Impact on Amira's Business. And what it says is, had IDBI complied with its obligation to pay AK Global as it promised to do, the proceeds from Amira's transactions would have continued to be routed through IDBI. So this provides the inference that the next transactions, after the first 6 shipments under the 10,000 metric ton contract, would have been routed through IDBI. But this is not reflected in the contemporaneous documents that are now before the courts. So what do the contemporaneous documents show about what was going on between Amira and AK Global when Amira made these requests of the bank on 19 February 2018? So Amira had already issued invoices dated 12 to 19 February 2018, which directed Kuwait Flour to make payments totaling $6.99 million for the next 10 shipments to its Mashrek bank account, so not its bank account with IDBI. And for your note, an example of one of these 10 invoices is D3 tab 74, which is addressed to Kuwait Supply. This one's dated 12 February 2018. And it requests a direct payment from Kuwait Supply to Amira's Mashrek bank account of $699,000. And the 10 other invoices are invoices 149 to 158, dated from 12 to 19 February. So these are the next 10 invoices in the sequence after the invoices and shipments that have been presented to IDBI on 14 February 2018. So the submission here is that these transactions do not appear to be related to the irrevocable letter. There's no clarity on how Amira and AK Global would have treated these 10 shipments in terms of the price payable to AK Global and the profit to be taken by Amira. But what we can say is, based on Mr. Chinana's evidence, it's unlikely that these would have been low profit transactions under the 10,000 metric ton contracts that have been presented to IDBI. This is because Mr. Chinana confirmed that Mashrek Bank is where Amira preferred to hold its profits. So, in the transcript, day 1, page 148, lines 20 to 22. So we say the payments in for the next 10 transactions were never intended to be used to pay down the 26 February 2018 buyer's credits. So in the 19 February 2018 letter, Amira was not giving the bank the full picture when it suggested that the payment to AK Global was needed to allow the next shipments to be made, so that the payments in from Kuwait Flour would then come in from the third week of March 2018. So Amira appears to have been trying to put pressure on the bank to extend the 26 February 2018 buyer's credits.
I haven't grasped how this relates to quantification of the damages for failure to pay.
Your Honour, I'm trying to go through the factual background just so I get the facts straight as we see them before I go into each of the Amira's heads of claims, at which stage I hope to draw those facts to each of those heads of claims if I may.
Yeah.
So after the bank had applied the sums received from Kuwait Flour to pay down the buyer's credits due on 15 and 22 February 2018, the bank was effectively forced to provide some additional credit to Amira to the extent of the sum that was payable to AK Global, so of 4.134 million under the irrevocable letter. As I mentioned previously, in light of what is now known, that sum could have been paid to AK Global and the bank could have treated it as an advance under the overdraft and demanded repayment from Amira immediately. Okay, that's the overall factual background. So now I'll go on to each of the heads of claims. So starting with lost profits. Amira claims that it lost profit on 17 transactions on the basis of the bank's failure to make the payment under the irrevocable letter, and on the basis that Kuwait Flour made certain direct payments to AK Global. So the bank's position is Amira has failed to establish with a reasonable degree of certainty that the bank's failure to make payment under the irrevocable letter caused any lost profits. We say it's far from clear.
Any at all?
We say that they've failed to establish with any reasonable degree of certainty that it affected any. Yes, Your Honour.
At all? When your own expert arrives at a figure?
Well, that was on assumptions that what was presented in the S&P matrix.
All right. Well, you may gather I'm somewhat surprised, but explain, please.
Well, we say it's far from clear what shipments were affected or could have been affected by the non-payment on 14 February 2018, because the arrangements between AK Global and Amira in respect of those shipments and the payments are very unclear. So we've already covered that, or you already covered with Mr. Montague-Smith, that Amira has not disclosed its contract with Kuwait Supply or Kuwait Flour, and this is in fact despite it being ordered to do so in a DIOC document production order, which appears in your bundle reference E, tab 8. We say that this is a big missing piece of the jigsaw that would tell us the purchase price, the quantity, the crop, and the payment terms, and maybe the delivery timelines as well. So Amira claims lost profits on 17 shipments, but out of these 17 are the 10 shipments that follow the 6 that have been processed through IDBI, that Amira was never intending to pay through IDBI in connection with the irrevocable letter. So during Mr. Chinana's cross-examination, so day 1, pages 155 to 156 from line 25, I asked, so for these 10 invoices and these 10 shipments, so invoices 149 to 158, it was never intended that the 6.99 million that was going to come from these shipments would be paid to Amira's bank account with IDBI. That is correct, isn't it? The answer was, these shipments were going to come into Mashrek as an invoice paid had it been normal course of business. And the question was, these payments were not going to IDBI Bank, were they? And the answer was no. So it's not clear how Amira is claiming that these next 10 shipments resulted in lost profits as a result of a non-payment under the irrevocable letter, where the irrevocable letter is linked to the 10,000 metric ton contract.
Well, you've lost me. Do you mean foreseeability?
No, in actual fact,
Well, okay, if you don't mean that, Do you mean that whether the money was going to go into IDBI or into someone else affects lost profit?
Well, it's an indication of whether they were relying upon the irrevocable letter for those shipments. So,
Why? Well, aren't you relying on it no matter whether the profit is going to go into one bank account or another bank account?
well, no, Your Honour. If we look at what was actually said in the 19 February 2019 letter, Mr. Chinana is saying we need you to make those three things, so including the payment for the irrevocable letter for these purposes, in order to allow next shipments, in order to allow monies to come in the third week of March 2018. And that matches up with, or there's a gap there. So if there are shipments which are going to bring in monies in March 2019, but then there are 10 other shipments which have gone through with invoice dates and bill of lading dates dated from 12th of February to 19th of February 2018, we say that evidence suggests that this was not a transaction that was going to be under the 10,000 metric tonne contract. They were not going to rely upon the irrevocable letter in order to process. And we don't have any sight of what their full arrangement may have been between Amira and AK Global in respect of those 10 shipments. We also say it's not clear how Kuwait Supply or Kuwait Flour made the payments for any of the shipments that followed the 6 that involved IDBI. So, for your bundle reference D377, we had 13 signed letters from Amira's parent company from Mr. Chinana to Kuwait Supply with the request to pay AK Global for invoice numbers 1492 161. This doesn't make any sense. It's from Amira's parent company to Kuwait Supply, so not the claimant in this action. And Mr. Chinana's evidence on the cross-examination did not provide any clarification on this point. So day 1, pages 140 to 141, I asked, you presumed that Kuwait Supply asked for 13 other letters from the parent of Amira. Is that what you're saying? And the answer was, I did not presume. Kuwait, in my conversation, asked what the parent company you can form is for their records, and we sent them. Okay. And you recall that, is that right? And the answer is, yes, that's correct. Now I'm able to recall the sequence of events. But we then have one signed letter from Amira, the claimant in this action, to Kuwait Supply, dated 22 February 2018. And for your reference, D3 tab 133. So it seems to duplicate that instruction. Now, there's no record of any email or letter from Kuwait Supply or Kuwait Flour in the bundle. Mr. Chinana said under cross-examination that letters from Kuwait Supply or Kuwait Flour should have been provided to Mr. Peters, Amira's expert witness. But Mr. Peters, under cross-examination, confirmed that he'd only seen a letter from AK Global referring to the receipt of payments from Kuwait Supply. And the transcript references for that, I won't read it out. Day 2, pages 134 to 135, lines 25, and over the page to 10. We also see that there's no reissued invoices in respect of the 10 invoices that I've covered that directed Kuwait Supply to make the payments to Amira's Mashreq bank account. So we're dealing with a government entity that has been issued invoices to pay Amira's Mashreq bank account and then receives, on Mr. Chinana's evidence, 13 letters and then from Amira's parents and then one signed letter from Amira, the claimant, dated 22 February 2018. And there's no record of any reissued invoices being demanded. Under cross-examination, Mr. Chinana said that Kuwait Flour did not reply and simply made the payment as directed. So it's a very unusual position for a government entity.
Is the result of this that you submit that Kuwait Flour did not make direct payment to AK Global?
Well, the submission is far from clear. We don't know.
Well, I think I need a bit more than that. I have to make a finding of fact. I need to know whether you are submitting that I should find that it was not.
Well,
Payment was not made directly.
well, I'm submitting that Amira has not discharged its burden of proof to show that those payments were
That
made.
amounts to a submission that I should decline to find that the payments were made directly.
Well, without better evidence, yes, Your Honour.
Right.
Okay, so the transcript reference, day 1, page 144, line 5, I asked, do you recall Kuwait Flour or Kuwait Supply replying in correspondence to your letters directing them to make payment to AK Global Direct? And the answer was, there was no reply, they only made the payment on our request.
Right. Now, if payment was not made directly by Kuwait Flour to AK Global, what did happen about payment? I need, in order to consider whether to accept your submission, to consider alternatives, don't I? So what do you say did happen?
Well, Your Honour, it's not my burden to establish what happened between Amira and AK Global and Kuwait
It's your
Flour.
burden to make submissions which bear upon which way I should decide.
Well, Your Honour, I say that these records are available to Amira and AK Global, and those records have not been put into evidence in order to discharge that burden of proof. So, in the absence of that evidence, we say it's not safe for you to make a finding that those payments were in fact made for all of the shipments that Amira claims were diverted and were paid directly by Kuwait Supply or Kuwait Flour.
But was there not a letter from AK Global which said, I've received all this money directly from Kuwait Flour? That's the letter which I was taken to during Mr. Montague Smith's submissions, which I noted I haven't seen before on my post-it note system.
Your Honour, yes. There is a letter after the fact from AK Global which states that.
Or do you submit that that is an untruth?
No, Your Honour. We say that there is better evidence that's available to Amira and AK Global, and that evidence has not been provided. So it's a question of how much weight the court attaches to that letter from AK Global after the event, which confirms on its face, without any underlying records to show.
Why should I not accept what they say? In other words, I have to consider why would they be writing a false letter?
Well, we say in light of the documents that have been provided to the bank in connection with these transactions, the bank submits that the court should note when contemporaneous records which should be available to the parties have not been provided in order to establish fundamental parts of their claim.
Yes, well now would you like to answer my question?
Well, Your Honour, I'm not submitting that letter is false, because I've got no evidence to suggest that it's false.
Well now, then why should I not treat it as representing the fact?
Well, I would repeat what I said in a non-answer to your previous question.
Okay.
My next point is that there's no evidence that AK Global kept any of Amira's profits. So there's no contractual right for them to do so under any of the contracts that are in the record. And we've noted that Amira has not sued AK Global for the return of its profits. And if I could ask you to pick up bundle D3, I'll take you to another letter from AK Global. This one dated 21 February 2018. So it's tab 130. and it's behind tab A.
I beg your pardon, I must have a wrong reference. Tab 130 in D3.
Yes, D3, tab 130, and there should be a tab A as well.
No, not in mine. It's just a single page email or some kind of mail.
It should be the next document in the bundle. Title page number 626.1.
Yeah, we'll get you another copy here.
So do you want to take it? Come on. Well, we've got a spare, if that helps.
Okay.
Is this, do you want to just show it to Mr. Francis?
Yes, that's the one.
Thank you. Just let me try and sort this out before you go further.
Thanks.
626. Oh, I see, right. No, I simply do not have this page in this one. I have 626.
Apologies for that.
Right, okay. It's in the bundle now? Yes.
So this is a letter from AK Global dated 21 February to Amira, which confirms on its face that it's received the following payments from Kuwait Flour Mills.
This is in the bundle somewhere else. I've seen this before.
Well,
It matters not, it's in there.
I think there is actually a discrepancy here on the face of this letter, which I'm actually seeing for the first time. So they say they've received payment of 4.194 million from Kuwait Flour Mills.
IDBI.
Okay. Okay.
That's the saying they haven't.
Right, okay. Right, okay. Right, sorry. No, okay. The second paragraph under the table, it's the second sentence. What AK Global is saying here is, till the time we received outstanding payments from your side, payment for the current contractual shipment will be directly received in AK Global Business FZE account from Kuwait Flour Mills, and the monies received by us will be adjusted against the outstanding payments.
Yes.
So that, we say on its face, does not indicate that AK Global is going to keep Amira's profits. It's consistent with the wider arrangements that we've gone through in terms of there will be balancing transactions in order to allocate the payments between Amira and AK Global so that they each end up in the place that they would have been if we are just looking at the 30,000 metric ton contract. So we say that letter can be read as being consistent with that arrangement. So no indication that they were keeping profits. So the other submission I have on this is under the arrangement between Amira and AK Global in connection with the 30,000 metric ton contract, it would have been normal for AK Global to be overpaid for shipments, holding Amira's profits for some time and then returning those profits to Amira by some other transaction. And this was confirmed by Mr. Chinal under cross-examination. So day one, page 129 from line 8, I asked, so AK Global will be overpaid under some contracts? Answer, correct. And as I understand what you said previously, the adjustments would be made in subsequent for previous shipment as needed. So it's not unusual
Now, what's the point, however, of drawing attention to the last sentence at page 626.1? Are you submitting that the money should have been received back?
Well, it said
Might have been received back?
Well,
Or what?
if you take their arrangement, it should have been. It should have been received back. I'm coming on to the evidence which might suggest that it was
All right.
received back.
Well, that's thought you would come on to that. There may be a question of burden of proof here, I do not know. I don't know whether you put a submission that it's up to Amira to show, in the light of this, that the money, that the profit didn't come back under some process of adjustment. On the other hand, it may be that the correct position is that it's for you to show that it didn't, and you certainly didn't put it to Mr. Chanana, although in what you're about to come to, you may say you've achieved that. That's the question. I think we've got a question here.
Yes, Your Honour. I would say we came on to evidence of those bank statements, which I'll come on to, which we say suggests that. Well, let me make my submissions on that, and let me come to them rather than anticipate. Another thing we say, which is inconsistent with the claim that AK Global kept hold of Amira's profits, is the 8,200 metric tonne contract. So, for your reference, D3 tab 139. So this is a purchase agreement between Amira and AK Global dated 5 March 2018. And the timing of this contract and its express terms are inconsistent with AK Global insisting on keeping Amira's profits at that time. And also the S&P matrix, if it's to be believed, suggests that normal business between Amira and AK Global appears to have resumed in the period from 21 May 2018 to 13 June 2018, with profits being paid to Amira as normal. If I can ask you to pick up bundle C, this is the expert report bundle, and turn to tab 3C. And this is appendix 4.1 to Mr. Fritchie's report, and it's page 152. And I simply go here as a shortcut because this summarises information from the S&P matrix, and I apologise that it's very small to read. But if we look at the SR numbers 177 to 181 on the far left side, and then there's a column 4 along if we look at the big separate columns, which is Mr. Peters' head of claim where applicable. And if you look at those items for 177 and 181, these are unaffected shipments. So you've got 1, 2, 3, 4, 5 unaffected shipments. So we say it doesn't make sense that if AK Global is holding on to Amira's profits, that they resume business as normal, and Amira is receiving its profits as normal, but at the same time AK Global is holding back profits that are properly payable to Amira under their own arrangement. We also say that it does not make sense for AK Global to hold Amira's profits and jeopardise its business with Amira. So under the 30,000 metric tonne contract, Amira had agreed to pay AK Global 30,000 metric tonnes at a price of $128,750. That's $38,625,000 US dollars. So a very substantial sum. Under the 8,200 metric tonne contract dated 5 March, Amira had agreed to pay AK Global a price of $1,289 per metric tonne for 8,200 metric tonnes. So that's another $10,569,800.
Well, these were transactions, I think, though I'm reading these details for the first time, in May of 2018. Seems to be the bill of lading time.
Yes, Your Honour. So,
I think it was, if I remember rightly, it was a little later in May that AK Global said that it wasn't going to do any more business with Amira. Am I right?
June 28th.
Thank you. Right. That does not indicate to me that AK Global was anxious to retain the business.
Well, we say it just doesn't.
Things might have been getting rather fraught then.
Well, if things were getting rather fraught, why did they enter into a new contract? And why did they go back to business as usual, paying profits as normal to Amira,
Anyway, I take your point. Subject to the possible question of who has the burden of proof, you're going to be taking me to the evidence you put, I think, Mr. Chinana through.
Correct, Your Honour.
But you didn't actually put directly to him, listen, you got the profits back, didn't you?
Well, what I did put to him is that under the normal business cycle, as set out in the second witness statement, there should not be any payments from AK Global to Amira. And he confirmed that. So in the normal business cycle, there should not be any payments from AK Global, the supplier, to the rice buyer, or the intermediary, Amira. And I asked him about whether he recalled AK Global making any payments to Amira, and he said he had no recollection of those being received. And then I took him to the Mashreq bank statements, which appear at bundle D4, and for your reference, tabs 177A, 185A, and then there are 5 payments from AK Global to Amira over the period from the 1st of May to 14th of June, which total $1,097,755 US. And
do you have a transcript reference to where Mr. Chinana said he had no recollection of payments being received?
I do. Let me start with day 1, 172 to 173.
Thank you. We might just finish this matter off and it'll be time to adjourn, I think.
So on 172 from line 20, question, there's no part of this business cycle that you describe in your witness statement that would involve AK Global making a payment to Amira. And that's the diagram he's already confirmed above, that shows the normal business cycle between Amira and AK Global.
That's the business cycle.
Yeah. And then I asked him about, I said 24, but then AK Global was making payments to Amira directly, wasn't it? And he said, can you remind me? I said, do you recall AK Global making any payments direct to Amira in 2018? He said, I don't. I said, you don't remember any? Okay, not as far as I know. And I said, let's see if we can refresh your memory.
Then you took him through those pages, but I think it remains the position that you didn't put to him in any kind of direct sense, listen, you got those profits back from AK Global, didn't you? These questions where he answered he didn't remember making any payments are in the context of payments under the usual business cycle, which is a quite different thing.
Well, I drew his attention to the figure. I mean, he didn't recall. He said he didn't recall these payments.
He didn't recall payments under the usual business cycle.
Or no, he didn't recall these specific payments coming into the account.
Well, when you took him through the opening, yes. But
And
this is important, Mr. Francis. If it's for you to persuade me that the profits were kept by AK Global. Were not kept by AK Global. I think it was incumbent on you to squarely face Mr. Chinana with that proposition. And I don't at the moment see that you did.
well, I did draw his attention to a calculation. If the 30,000 metric ton contract was performed up to 10,000 metric tonnes, what
You
profit
said
would have been?
you put the proposition that the figures are consistent. That is as far as you went. That is not good enough.
Well, I did say on page 176, line 18, so the payment received by Amira from AK Global into the Mashreq account is enough to cover the profit that will have been payable to Amira for the delivery of 10,000 metric tonnes under the 30,000 metric tonne contract. That's correct, isn't it? And he said that's your deduction, but 30,000 contract in its full is his answer.
And that is my exact point. You did not put it properly to him. So I think on that note, we might need to take an adjournment.
Well, one final point on that. I did ask Mr. Peters just to confirm that the S&P matrix does not record any payments from AK Global to Amira, and that the reference to the transcript is yesterday, page 131, lines 3 to 8.
So what's the point of that? If one takes that at face value, it means that AK Global did keep the profit.
Well, what we have is evidence of unexplained payments from AK Global to Amira, which are not part of the usual business cycle, and the number is more than enough to cover the amount claimed by Amira, but it's actually very close to the figure that would have been profit for Amira under the 30,000 metric tonne for a delivery of 10,000 metric tonnes. So that's my submission on that evidence.
Do you make the submission that I should find that the profit from direct payment to AK Global, which you contest anyway, was repaid to Amira?
Well, I say on a balance of probabilities, I think that finding is open to you.
Please, do you submit that I should make that finding?
You're right. Well, you've already told me that I did not challenge Mr. Chan on that point. So yes, I say you should find that it's received payments of those amounts of profit and more than the big claims. But I take your point that on the reading of the transcript, I did not put that directly to Mr. Chinana.
All right. Well, now, I do have... I'm sorry, have we dealt with this question?
Yes, Your Honour.
Yes. I do have this hearing at 2. If I say I certainly won't come back to this case before 2:30, I am not sure whether that's going to be accurate. It probably isn't. But hopefully 3 o'clock-ish we might get re-going. How much longer do you think you might be, Mr. Francis? We've got quite a bit to go, I think.
I think another hour.
Another hour, okay. With experience of lawyers' estimates, perhaps we should be prepared to be sitting fairly well into the late afternoon. So I hope we can all do that. I'm free to sit until the death.
I think we didn't experience one of those. Yes.
All right. All right, so I will see you at some later time in the afternoon. Be back here by 2:30 or so. Wait around until I'm free.
I assume we need to remove at least some parts of our
I
documentation.
think you need to have a space for 2 sides, please. Yes. Thank you.
All right.
Yes, Mr. Francis.
Thank you, Your Honour. I was just going to pick up where I left off and move on to the next code of claim, which is the lost margin claim. And the short point is things have not really moved on since the opening. As a first hurdle, Amira has to first establish that AK Global cancelled its contracts with Amira due to the bank's failure to make a payment under the irrevocable letter, and we say the contemporaneous documents do not support that proposition. We say AK Global entered into a new contract with Amira on 5th of March 2018, some 3 weeks after the date for payment under the irrevocable letter, which I've already taken you to. Also, Mr. Chinana suggested that following the bank's payment on 20 May 2019, AK Global and Amira resumed business as normal. And I've taken you to those unaffected shipments that are set out in Mr. Fritchie's Appendix 4.1. On day one, page 168, Mr. Chinana confirmed this. So I said to him, lines 2 to 7. So my point is it all right for us to understand from the S&P matrix that it was business as normal, resumed for these 5 transactions with AK Global? And the answer from Mr. Chinana was, it is that probably yes, because 30,000 is the total contract, and we have the execution document for that. It was asserted by Mr. Montague-Smith in his opening that the bank's non-payment gave AK Global the excuse to escape from his contract with Amira. But we say, well, the terms of those contracts between Amira and AK Global don't give AK Global any express rights to escape for any reason connected with the non-payment.
Do you take the point that they had no right to escape, or do you simply throw that in the mix as a reason why it should not be found that they did cancel for that reason? I'm sorry, I may not have been very clear in that question. Let me ask again. Do you have a separate argument that in some way, because AK Global had no right to cancel the contract, that itself is an impediment to recovering damages consequent upon their cancellation?
Yes, with respect to the 5th of March 2018 contract, at least, we say, look, they've entered into this contract after the breach, so after the impact of the breach. They've freely entered into the contract. Business has resumed as normal after that time. There are no express contractual terms which allow them to escape from that contract, and the fact that it comes after, in time, after the breach and after the impact has already started to be felt, if there is any impact, we say, well, that indicates that, well, they had no express rights to escape, and it's the argument that they cancel those contracts is contrary to those express terms, and there's the mitigation point as well. If they did breach those contracts by terminating them, well, Amira could have enforced their legal rights to hold them to those contracts.
That's what I was really trying to get to. Are you putting an argument that because Amira did not complain and try to enforce rights or sue AK Global, they are in some manner prejudiced in recovering the damages they claim?
Well, yes, if it's a failure to take reasonable steps, at least to try to enforce their rights.
Well, it is a mitigation. It's in the area of mitigation, isn't it?
Yes, sure.
So you would have to submit that a reasonable step, which they should have taken, was to try to hold AK Global to the contracts.
Yes, sure. At least to assert the right that they should be held to the contract.
Mm-hmm. Well, I suppose that's a question of fact for me to decide, was that something that was reasonably required of them in mitigation or not?
Yes, sure.
Okay, thank you.
We also say that the Amira's argument is flawed on the but-for position by using the 30,000 metric ton contract as the reference point for the but-for position, since we say the contracts with TIA Agro and SR Agro are not comparable to the 30,000 metric ton contract, and these are reasons we've covered, so I'll go through them quickly. They were for different commodities, the 2017 crop and 2016 crop respectively. So 2016 crop under the 30,000 metric tonne contract and 2017 crop under the TIA Agro and SR Agro contracts, and they were for different shipment periods as well. So March 2018 for up to March 2018 for the 30,000 metric tonne contract, and different shipment periods for the TIA Agro and SR Agro. So September or December 2018 were the shipment periods under those later contracts. So they're just not comparable in terms of replacement, like for like, apple for apple contracts.
But do they have to be? Or is it a situation where, if by the defendant's breach the claimant has to replace a contract, it can replace it on different terms if they're the terms that are available at the time?
Well, is the burden on them then to establish that those are the only terms that are available, and that the terms are should be the comparable terms?
So it's a burden of proof point.
Yes.
Really, they haven't shown that they could not get replacement contracts on the same terms.
Yes, Your Honour, and there's also the big absence of the Kuwait flour contract. So that would at least resolve whether they were able to supply 2016 rice crop under the Kuwait flour contract that was in existence at that time. But we simply don't have that contract, despite the court's order that they produce it in these proceedings.
Right.
That would also tell us about pricing as well.
Can you remind me where in the bundle that letter of the 11th of July is, please?
Yes, it's D4, and I think it's the last
Very,
tab in
very
D4.
large. Yes. You made an earlier submission that there was no evidence showing that the termination by AK Global of the contracts was due to the breach by failing to pay under the irrevocable letter. But doesn't this provide evidence? They actually say it, don't they?
Well, in the table they say cancelled by AK Global, and then over the page they say due to the revocation of IDBI's irrevocable letter. They do, Your Honour. But this letter is obviously not a contemporaneous record. It's 11 July.
But you said there was no evidence.
I apologise.
You've got this letter.
Yes, can I rephrase and say there's no contemporaneous evidence to show at the time that they cancelled these contracts, 28th of June 2018, there's no evidence.
Right.
Okay, the third hurdle is that Amira's own evidence indicates that the TIA and SR Agro contracts were more profitable than the AK Global contracts. And Mr. Gandhi accepted this during cross-examination, and on Amira's own documents, Amira's contracts with TIA Agro and Impulse and SR Agro were more profitable than its preceding transactions with AK Global. And on the transcript, it's day 1, page 209, lines 2 to 7. And there's a question by Mr. Kuzikanani saying, so on your own sales and purchase data, we can see that the transactions under the contracts with TIA, Impulse and SR Agro provided Amira with an increase in the profit compared with its transactions under the AK Global contract. That's correct, isn't it? The answer is yes. So we've also said, if it is right, as Amira has alleged, that the only reason for Amira's entry into these contracts was the conduct of the bank, then Amira's made a profit which should be netted off against any loss that he can establish that it's suffered.
No, Mr. Montague-Smith says, however, you can't take into account the increase in price that they were able to obtain under those contracts because it's not, that price was not caused by the breach. That increase in price was not caused by the breach. Any observation about that? That's a legal proposition, I think.
Well, I think that would have been, that point would have, on a factual basis, would be easily resolved if the Kuwait flour contract had been disclosed, because then we would know exactly what the purchase price was for that rice and what the terms were. So I don't think the point goes anywhere if they have the burden of proof to show that this is the right comparable price for the 30,000 metric ton contract.
Why do you say we don't know the price under the Kuwait flour was paying, or to pay?
Well, we can't confirm it because we don't.
We've got thousands of $699,000 payments.
Well, we don't have the primary records for all of those payments. We have the S&P matrix, but we just don't know what the terms of the contract with the Kuwait flour say.
We're just talking about price at the moment, though, not the terms.
But we don't know the price.
Why not?
That's agreed in the contract.
Why not? Isn't the evidence of payment of a certain amount evidence of that was the price?
Well, you don't have evidence of all of the payments, and you don't have evidence of all of the amounts. I'm not sure. I don't want to stray. You sure you submission? I'm talking about all of them in the S&P matrix. I'm not going to say that in respect to any specific transaction without any.
The submission was you don't have evidence of all of the payments.
Of all of the payments, all the contemporaneous records of all of the payments made by Kuwait Supply for all of the transactions in the S&P matrix. No, we don't.
All right, let's move on.
No, that wasn't my submission.
Let's move on.
Okay. The reputational damage point. On the reputational damage claim, we say that the Amira's own expert evidence completely undermines any prospect of this claim succeeding. So Mr. Peters clearly was instructed to assume that the diminution in the ANFI share price of the parent company of Amira between 14 February 2018 and 12 October 2018 arose entirely from the revocation of by the non-payment by IDBI under the irrevocable letter. So Mr. Peters obviously accepted during cross-examination that this assumption was fundamental to his conclusions on the head of claim, and in the report he has stated at for your note C1 19 paragraph 613, I have requested evidence to demonstrate a causal link between the revocation of the irrevocable letter and the fall in value of shares. I have not been provided with anything that assists in this regard. I have also undertaken certain searches of public records to see if there were any company announcements or press releases. Again, I have not found anything relevant. So we'll say again, they've failed to discharge their burden of proof of showing any causal link between our non-payment and any movement in the ANFI share price.
Well, Mr. Montague-Smith, however, falls back on an ability to award something in the nature of general damages, which I somehow pluck from the air. What about that?
Well, there's simply no evidence at all to assist the court in undertaking that exercise. And
well, but hang on a minute. Just concentrate on the cases he took me to, which effectively say you don't need evidence. You can give some kind of general damages.
well, I go back to the actual DIFC rules on. So yes, so on the law of damages, Article 11, certainty of harm. So 11.3 So, okay, but certainly within the scope of damages cannot be established with a sufficient degree of certainty. So if you say there is some causal link, then you have discretion to make some assessment, but you say there's simply no records that would assist you in that exercise.
So what do I do if there are no records that enable me to calculate a figure, even a rough calculation? Then let's assume entirely in your favour that there's just nothing at all that I consider that there would have been some effect on profits from reputational effect, but have absolutely nothing to help me work it out in a calculated way. What do I do then? And this is a genuine question. I am puzzled.
Yes, well, I think your starting point is to look at the opportunities that Amira has had throughout these proceedings in order to put together all of its evidence on this point, including the document production requests that we made for documents which would have assisted in that exercise, including the appointment of an expert, a forensic accountant, who could have been instructed to address this very topic. And the absence of them having done that exercise, despite multiple opportunities, I think should be held against them by the time we're at trial. I don't think they should be given a further opportunity to provide other evidence, or the court should not indulge a further exercise and further delay in order to allow the claimant to prove their position on this point. I think this is it.
They don't have a further time where it's here and now. But really you're appealing to the principle that the degree of proof required of a party depends on the ability to prove something. You say, well, they had the ability to prove a loss of profit otherwise than by diminution in share value, by some reference to the accounts and accounting. They haven't done it. Therefore, I should not be tender in their favour by plucking some figure out of the air. I think that's the essence of your position, is it not?
It is. I would add the extra layer of expert evidence that's been put in front of the court. But it's not just that they have had the opportunity, they applied for the opportunity to put in expert evidence from a forensic accountant. They were completely free to instruct that forensic accountant to do any exercise they thought was necessary to support their case. It's for them to plead their case, it's for them to evidence their case as they wish. They've done that, they've had plenty of time. The time is now for the assessment, and if the evidence isn't before the court to support that exercise, we say that should definitely be held against them. That's our submission. But we say you don't even get there because there's simply no causal link that's been established on any of the documents. And the expert that they have instructed has looked at that and can't see any evidence of a causal link.
You're fixated on the drop in share price. I was putting something different to you.
Well, he's used that as a proxy.
Yes, I know he has, but now he's falling back on something different.
Well, the expert has used it as a proxy because there is no other alternative that was open to him. So why should the court be in a better position than the forensic accountant in the same scenario?
Okay.
So this also deals with Mr. Chinana's counterclaim, which is brought on the same primary grounds, which is the bank's non-payment and its impact on the share price of Overy. And Your Honour has also observed that there's no apparent legal basis for that claim as well. So thank you very much for that point. We'll take that. On diverted management time, we've made our point on this as well, that we say Amira has not demonstrated that it has suffered any incremental cost at all as a result of Mr. Gandhi's work in relation to these proceedings. Mr. Montague-Smith has said, well, okay, or there was some discussion with Your Honour about whether or not there is evidence that his time used elsewhere would have resulted in profits for Amira. So simply there's no evidence of that as well. The only evidence of the actual time that Mr. Gandhi has spent is an estimated, a table of estimated times. We don't have any information about the contemporaneous records, if any, that it's based on. We've also, again, not got the best evidence that is available in respect of his employment contract. Instead of a copy of the employment contract, the Amira has had to rely upon Mr. Gandhi's confirmation of the key terms of his employment contract. And the court is left just relying upon his word rather than primary evidence.
You keep on saying this sort of thing, but why should I not believe him? He knows it. Are you saying he's alive? That I should find he's alive?
No, Your Honour. It's a burden. It's a burden of proof point. There's better evidence that's clearly available to Amira, and time again it's not being produced. And we say, well, that should count against them in terms of your assessment of the quality of the evidence.
It may depend on the fact in question, but where it's just a question like Mr. Gandhi saying, I am paid so much, why should I not accept that?
Well, it's for the court to assess whether that is an acceptable answer when it would be very easy to have produced the employment contract.
I think you would do better if you kept your submissions of we don't have the primary evidence to where it counts, or might count.
Okay. Thank you. Okay, I want to cover the lost transaction as well. Again, I don't think much has moved. I don't think anything has moved since the opening. This claim is based on a single email that appears at D4178, and it's absolutely plain. We say on the face of this document that there's nothing to support a claim for $35,000 US or that figure with any adjustments. Okay, on the interest repayment claim, I took you in opening to the letter from the bank dated 8 July 2018, so figure note D4187, where a copy of the accounts and interest charge had been provided to Amira, and said that we had no response to that. Mr. Montague-Smith has said, well, that this claim relies upon whether or not buyer's credit was payable on 22nd April 2018. Well, on that, I would take you to the facilities agreement in D1. And page 49. And it's clause 4.8. Which we say provides the bank with a clear right to demand and be paid on its first demand for any buyer's credit. In terms, I won't read it out since it's a lengthy clause.
Did you say clause 4.8?
Yes, Your Honour.
Doesn't the 4.8 I have doesn't refer to interest?
Well, no, Mr. Montague-Smith said that it depended, that our ability to claim interest depended on whether we had a right to demand repayment of buyer's credit on the
I see.
second
Right.
April.
You're saying 4.8 gives you the right to demand repayment.
Precisely.
Yes.
At any time and to be paid on first demand.
Now, this is something that I may not have appreciated before. You say that this was because of failure to repay in April, and April buyer's credit, or are we still talking about the 22nd of February buyer's credits?
Well, the outstanding one is the 26th of February
2018
buyer's credit.
So does the interest then depend on whether the bank, whether the 26th of February buyer's credit amount is repayable, or whether it is the defence that it's not because that was caused by the bank's default is a valid one?
Well, I think there are a number of arguments to unpack with that. I think which is relevant to the counterclaim, which I'm going to come on to. But it's one thing about there's one issue as to whether or not it was whether we could demand repayment on the 26th of February due to the finding of Mr. Justice Cook in his judgment. But then, at any date thereafter, the bank's position is, well, it was free to call on that buyer's credit under the express terms of the facilities agreement and to rely upon those terms. Now, whether Amira has a claim for damages or as a result of our breach of the irrevocable letter, well, that's a separate issue. We say under the terms of the facilities agreement, we're able to demand repayment of these buyer's credits at will under clause 4.8.
Now, can I clear up one thing that came up in the course of Mr. Montague-Smith's submissions? It does seem to me that the question of the interest charge ought to depend on whether or not it was properly claimable by the bank. There was a suggestion earlier on that the bank says, well, even if it wasn't, we're entitled to keep it. Do you take that position or not?
No, Your Honour. This claim has always been quite unclear to us, and we thought there may be a dispute as to the calculation of the interest. So, as I said, we wrote to Amira with the bank statements. We had no response. I'm simply responding to Mr. Montague's point here today, which is, well, it seems to depend on whether or not we were entitled to call the buyer's credit. So that's why I'm addressing that point.
All right. So you agree that that's what it really depends on. And if my finding is that you weren't, the money is to be paid back, or at least credited anyway.
Yes, credited.
Yes. All right. Thank you.
Thank you. Okay, I'll move on to the counterclaim now, if I may.
Yes.
Okay, Amira's primary defence to the bank's counterclaim is that the counterclaim is based on Amira's default in not paying the 26th February buyer's credit, and that default was caused by the bank's non-payment under the irrevocable letter, and therefore Amira says the bank is not entitled to rely on that default. Amira also runs the set-off defence in the alternative, we understand. No issue is taken by Mr. Chanana in respect of the claim under the guarantee. I think it's accepted that, well, if Amira owes the money to the bank, then subject to his counterclaim, Mr. Chanana also owes the money to the bank. So I will first address Amira's primary defence to this. So in Mr. Montague-Smith's opening, he appeared to accept that in determining whether there's been a default on which the bank can rely, Your Honour should consider the position as at 6th of June 2018 rather than some earlier date. Amira says that we are stopped from relying on Amira's default in not paying the 26th February buyer's credit as a result of the judgment of Mr. Justice Cook. But we say, as noted in our skeleton argument, that Mr. Justice Cook's judgment only comments on the impact that the bank's breach had on Amira's ability to repay the 26th February buyer's credit as at 26 February 2019, not as at any other date beyond that date. So I've already taken you to clause 4.8 of the facilities agreement, which gives us a right to demand repayment of the buyer's credit at any time. I'd also refer you to clause 4.1 F, which we say would apply to any request to extend the buyer's credit. So 4.1, subject to the terms and conditions of this agreement, a letter of credit or buyer's credit will be opened by the bank if F, such letter of credit shall be valid for not more than 90 days from the date of opening, and a buyer's credit shall be valid for not more than 90 days from the date of issue. So we're saying that we're well beyond that 90-day period from 27th of February to 6th of June. So at some point in that time, or at any point in that time, we're entitled to call an end to any extension on the basis of those two provisions.
Does that amount to saying that even if there wasn't an event of default earlier, there was an event of default in June? Is that the essence of that submission?
Yes, but the two stages. We can demand payment of any buyer's credit on the basis of those two terms. If they're not repaid, then that does become an event of default.
Yes, but if I understand you correctly, your point is that, assuming against you that there ought to have been a buyer's credit issued in February, it would have been payable in June.
In any event, but what they were asking for was an extension of 30 days. So they weren't asking for a new buyer's credit of 90 days. But
more sophisticated, but one way or the other, you say that there would have been an event of default after the 26th of February.
Yes, Your Honour.
But that throws up this question that was brought out in the openings of whether you're entitled to rely on an event of default at that later date. So at some point, I think that needs to be addressed.
You're on a by later date, you mean after the 26th of February?
Yes.
Yes. Okay.
Let me explain the way I'm seeing it at the moment, so you can address it. First, that there is a pleading question as to whether you're entitled to rely on any event of default other than non-payment on the 26th of February. There's also a more substantial point about whether the notice of default being founded only on that, which I think is correct, but I'm open to correction, you can rely on anything other than an event of default on the 26th of February, quite outside the pleading question. I think those are two questions that have been raised. Mr. Montague-Smith, have I got your position?
Yes, that's right. And then there's the third point, which is the point I was addressing this morning, about what was actually dealt with in the evidence with Mr. Charnana.
Thank you. So, Mr. Francis, I do need your help on those, even if it be to show that I'm wrong in thinking they are questions.
Well, Your Honour, let me start with the question of the format of what is required to exercise rights after an event of default has arisen. So if I can take you to clause 14.2 of the Facilities Agreement, that's D1 tab 2, page 64. And the short point here is that there is no requirement under the Facilities Agreement to provide any notice or warning or time before relying upon these provisions following an event of default. It's simply a question of fact. Is there an event of default? And if there is, we can rely upon these provisions. So 14.2, upon the occurrence of an event of default and at any time thereafter, the bank may, by notice in writing to the borrower, require the borrower to provide an amount equal to the face of each letter of credit and or buyer's credit to be deposited in the cash collateral account, and such amount shall be used in Rule 7. B, declare each outstanding amount under each advance to be immediately due and payable, whereupon each such outstanding amounts shall become so payable, together with accrued interest thereon, and any other sums owed to the bank under this agreement, and/or C, declare any unutilised portion of facilities to be cancelled, whereupon the same shall be cancelled and the facility amount reduced to and thereafter remain zero, and/or invoke all legal remedies, including legal action available, including without limitation enforcement of any security documents or security interest.
Well, the important words for present purposes are by notice in writing, aren't they?
Yeah, but notice of what? Notice to require repayment, not notice to identify the event of default. Simply, we are relying upon the fact that there is an event of default, and that's a question of fact that Your Honour can determine. And if there is an event of default, then we're entitled to rely upon those rights.
What notice in writing do we have here?
Let's go through. We have a number. Okay. What's notices? Notices. Okay. Can I ask you to go to? We got the 27th of February as well, didn't we? Those ones. Okay. Can I go to D4 tab 160? So this is a letter from IDBI to Amira, dated 1st of May 2018. Okay, and if we look at paragraph 4 and 5 here, IDBI Bank, letter dated 27 February 2018, April 22, 2018, had intimated you to regularise the account immediately, which has been irregular since February 26, 2018. However, the same still stands unpaid till date. As on May 1, 2018, the outstanding in the account stands at 2.3 million. After adjusting the available cash margin, please note that the balance facilities have been cancelled and are not available for availment. 5. Apart from the non-clearance of the overdue, the borrower has not complied with the following terms of sanction. So 1, submission of unhedged foreign currency certificate. 2, submission of stock statement. 3, submission of latest promoters network statement. 4, submission of latest audited results. 5, bank statement for the period ending 31 March 2018. And then under that, non-compliance of the above requirements is an event of default with the envisaged consequence under the facilities agreement.
Right, well, then you say that's one. Any others?
Yeah, and that is pleaded. So let me just give you the pleading reference. That's in our amended statement of defence and counterclaim. For your notes, tab 6, page 22, paragraph 42. And it was, the events of default were also referred to expressly in the bank's reply. So reply to defence to counterclaim. So
Just a minute, let me look at the amended defence and counterclaim. That's tab 6, paragraph 42.
yeah, page 22. Yeah, so we're saying that in paragraph 42 there, the defendant has demanded payment in respect of the 26th February buyer's credits and or other outstanding amounts on previous occasion, including in his letters to the first claim dated 27 February 2018, 22 April 2018 and 1 May 2018.
Yes, I see that refers to it. Okay, now any others? that you say you can rely on? Presumably 27th of February and 22nd of April.
Yes, yes, Your Honour. Those don't refer expressly to event of default. They do refer to the irregularities which are referred to in that 1st of May 2018 letter.
Can you just, I'll just make a note of the references to those in the bundle if you can give it to me.
Yes. So yeah, D3136. That's a 27 February 2018 letter from IDBI to Amira. And it's paragraph 5 in particular of that letter. Which is also relevant here because it's it says here, I don't know if it's worth turning this letter up, because the bank is referring Amira to the availability or potential availability of LCs as at this date.
Well, let's just concentrate on this event of default.
Yeah, so this letter is demanding that certain issues be addressed immediately. So submission of stock statement, net worth statement, in-house financials of the company, and bank statement of the company.
Okay, now 22nd of April, do you have a reference to that, please?
Yes. Yes, it's D4153. So this is paragraph 2. As you are aware, and as intimated by our letter dated 27 February 2018, the buyer's credit facility aggregating to 2.59 million extended by us have fallen due for payment on February 26, 2018, which was not honoured by you and has been devolved owing to non-payment by the company, and after adjusting the available cash margin accordingly, an amount to the extent of 1.495 million continues to be overdue in our books. Further, borrower has not serviced the overdraft interest fallen due on 1st March 2018. There's a figure there, April 1st, 2018. Hence, the overdraft account is irregular to the extent of 1.5 million from February 26, 2018. Days past due is 56 days as on April 22, 2018. We have been time and again requesting you to clear the overdue immediately. And then paragraph 3. Actually, that's cool down to okay. So I think those are the 3 that we've referred to in our pleading before the lawyer's letters start, which I took you through on opening.
Well, I don't want to cut anyone short, but are we at this stage that in your submission those 3 letters, or at least one of them, was a notice in writing under 14.2 relying on an event of default other than the 26th of February?
Yes, sure.
And it was properly pleaded as an event of default on which you could rely to recover the money?
Yes, sure.
That's the essence of your position?
Yes, sure.
Okay, I understand, thank you.
And then we have all the lawyers' letters that we went through on opening. I can take you through those again if that's necessary, but they all end in the June 2018 letter, which is the so-called notice of event of default, even though, as I've said, that's not strictly required under the provisions of the Facilities Act.
Yes.
Would it be helpful to take you through that correspondence? Or?
No, I don't think so.
Okay. Okay. If we can also go to our reply to defence to counterclaim, so that's bundle A, tab 8, page 54. And then 17D, as the second sentence there, so this is another pleading. There were multiple breaches of the claimant's obligations under the facilities agreement as at 1 May 2018, which amounted to events of default under clauses 14A, C, D, F, M, S and T of the facilities agreement, including as set out in the following letters. And there we've quoted from the letters that I've just taken you to. So we say that all we had to do was to demand repayment in order to rely upon our rights under the facilities agreement to require immediate payment. So then we've got our notice of default dated 6th of June, so D1 tab 7. So we say even if we were wrong to refer to non-payment of the amount as at 26 February 2018, by this date there were numerous events of defaults, and in any event we were entitled to call for immediate repayment of the buyer's credit and for the overdraft sum, which is a facility that's repayable on demand. And we say Amira simply has no defence to our reliance upon the express terms of the facilities agreement in that regard. So, Your Honour, if you find that there is an event of default in existence that we have relied upon, that's clearly provides us with the rights to recall the sums for repayment as at that date. But we'd go further and say if your Honour makes a finding of fact that there was an event of default, even that we didn't rely upon, but which was in existence as at 6th of June 2018, so as I've taken you to the information undertakings that I referred to at the outset, and that would also be valid grounds for the court to find that we were entitled.
Why?
Well, because the way the express terms of the facilities agreement...
The express terms require a notice in writing under 14.2, at least so far as you've referred me to it.
Well, and notice in writing that requires repayment,
Yeah.
which is exactly what we have. So, providing it's not a notice making a demand that we're not entitled to
So
make.
your submission is that you don't need to identify any event of default in the notice, or more precisely, that if in a notice you do identify an event of default, you are also entitled to rely on any other event of default that's not in the notice.
The second proposition, Your Honour, I don't think you're just entitled to write a blank letter. But if there's a valid event of default and you've chosen to rely upon the wrong one, but there is in fact an event of default as at that time, we say it should not be held against us to render that notice and demand for repayment as being defective. And we would note that you have these boilerplate wording in these letters which you never want to rely upon, but we do have in our notice of the event of default letter dated 6th of June that the bank reserves all of its rights under contract and at law, just to avoid any implication that we're somehow waiving any right that we might have.
Okay, I don't think we're in waiver territory, but I think I would need authority to back up your proposition.
Well, that's challenging, Your Honour, because the facilities agreement is governed by UAE law. So we have looked and we can't find any specific authority on this point, and we did not think it was appropriate to give the court English court authority on the point. But our submission is very simple.
But in the absence of UAE law guidance, it seems to me there is a question. How do you suggest I resolve it?
Well, on the plain reading of the terms of 14.2, so breaking it down, is there an occurrence of an event of default?
I have to say that on a plain reading and commercial considerations, I would have thought that that a bank would be bound by the events of default that it specified. Otherwise, the poor old customer has no way of knowing whether it's able to resist or not.
Well, Your Honour, you're bringing into play reasonable conduct, and I would say that the bank should behave reasonably. And if there is any question that the borrower doesn't understand why a notice demanding repayment has been issued, or is not able to understand what it could be, I would take your point. And perhaps in those circumstances, maybe it's a bit unfair for a bank simply to issue a demand without explaining, but we're not in that territory here, Your Honour. As we said, there are plenty of letters preceding the 6th of June letter which identified events of default. I'm giving you submissions on other events of default that may not have been known to the bank as at the date of the 6th of June.
Yes, but we're addressing your proposition that the bank can rely on an event of default even though it wasn't in one of the notices. That's what I'm questioning.
Yes, subject to reasonableness. I would say you break down 14.2. Upon the occurrence of an event of default, so 1, is there an occurrence of an event of default, finding of fact, and at any time thereafter, so we don't have to rush, the bank may, by notice in writing to the borrower, so the notice in writing to the borrower only has to declare each outstanding amount under each advance, so under B, but it applies obviously to those other provisions. So just a plain reading, we say, allows that notice to just demand repayment. Well, it's literal reading.
In that case, I would expect you to put a proposition which I thought you might have been starting on, namely, yes, of course there is reasonableness, but the bank doesn't have to be reasonable. I'm joking, I hope.
Oh yeah, we're not in that territory. We say that, and I took you to the correspondence of the bank.
Well, we may not be in that territory if you're right about reliance upon the various letters that you've taken me to.
Well,
as I say, and I just like to try and make sure we're not at cross purposes on this, you put the proposition that you were entitled to rely on an event of default if it existed, even if it wasn't in any of these notices.
Correct, Your Honour, but that should be seen in context.
That's what I'm questioning. It may in fact not arise, but I would want some debate on that if it is necessary to resolve it.
I think you should also have regard to the context in which that 6th of June 2018 letter was issued, and look through the correspondence that leads up to it that I took you to on opening. There you can see that the bank is going to some lengths to give Amira the opportunity to negotiate and propose terms, including potential waivers of...
What on earth has that got to do with what we're talking about at the moment?
Well, we're not in the territory of a notice that has dropped out of the blue demanding repayment of millions of dollars with no explanation. So we say strictly the bank under these terms could rely upon that, but we are very far from that territory.
Well, let's hope we are, one way or the other.
Okay, well, even if you're against me on that point, at some point this money has to become repayable. And surely it cannot be the case that Amira can simply deny its obligations to repay substantial amounts of money for months and years without the bank having any proper recourse. The bank has been kept out of its money for a very long time. If there is any debate as to whether or not we were able to issue a effective notice as at the 6th of June, surely by commencing these proceedings, by putting in our pleadings, those should amount to a notice which makes very clear that we're demanding repayment and we identify the grounds on which we're demanding repayment. This money is overdue.
Right.
Okay, I'll just address very quickly the arguments of set-off. So these arguments were raised at the outset. Obviously, it's a rather a moot point on the point of judgment, when, of course, there'll be, in effect, a set-off. But where set-off arguments were raised, as at 6th of June, we say Amira was not entitled to rely upon such arguments. The outstanding amounts claimed by the bank relate to amounts advanced by overdraft facility and buyer's credits, which were repayable on demand. And if I could just take you to the overdraft clause 5.5 in the facilities agreement. So that's on page 50. You'll see 5.5. All drawings under the overdraft facility are repayable on the bank's demand, together with all interest and other charges accrued to the date of repayment, without set-off or counterclaim. So I think that makes the position rather clear. And of course, I've already taken you to clause 4.8, which in terms says pretty much the same thing with respect to buyer's credits.
Yes,
Okay.
thank you.
Final point from me, Your Honour, is just to point out that we have included an up-to-date interest calculation for the sums due under the facility, and that appears in Bundle C, tab 3D, page 153.1. And Matt Fritchie's team, our expert, has helped us put together an up-to-date calculation of all the sums of interest that are due on the amounts that are demanded and claimed as repayable under the facilities agreement. It goes up to 29 July 2019. With that, Your Honour, that brings me to the end of my submissions.
Yes, thank you.
Thank you.
Yes.
Your Honour, so I'm going to be dealing with the counterclaim. I do have some further comments on some of the issues that have been raised by my learned friend in relation to the claim.
Sure. You have a reply on the claim and then counterclaim. If it's convenient to deal with the reply first, just so that you keep things in order, that would be good, but take your own course.
Thank you. I'm afraid my notes on this are a little bit in the order that the submissions were made, so I'm hoping that I will cover everything, and I apologise in advance if it's not in the order precisely that makes logical sense. One thing I should, I think, say right at the outset is this. I kept my powder dry while my learned friend was making his submissions this morning. And in particular when he was submitting for the first time in open court that the 10,000 metric tonne contract was a sham. Now, I know that he withdrew it, but that is an allegation of fraud. And I make absolutely clear on behalf of my client that allegation is rejected. Had it been made in these proceedings, it would have been defended. Had it been presented to the witnesses, it would have been responded to. It is an allegation that should never have been made. It should never have been made in these proceedings. It should never have been made in open court. And it should never have been made by a bank in particular, and it should never have been made by a law firm. My client obviously feels very strongly about this. The point about making allegations of fraud in court is that if you make those allegations in court, you are in a privileged environment. You cannot, there's no, well, at least on the English model, there is no a capacity for a party accused publicly of that sort of behaviour to get any comeback at law. That is why it is absolutely essential that parties and litigators take seriously their obligations when it comes to making those sorts of allegations. Those sorts of allegations can be extremely damaging to parties, and you know that my position is that my client's business has been damaged very seriously by the bank's behaviour outside of court. And all I say, final point on this, is that my client will be watching very carefully to see whether any of these sorts of allegations find their way into the marketplace and are repeated there. So I'll leave it there if I'm. It's a serious matter. In relation to this issue of foreseeability, I've made my submissions that what Your Honour is looking for is this question of whether or not it is the kind of loss which is foreseeable. And so then the question remains, is the loss under the 30,000 metric tonne contract foreseeable to the bank in these circumstances at the time of the breach? Is the sort of loss that would arise under that contract foreseeable? And I think one can inform the answer to that question by considering it in these terms. The fact that the bank knew about the 10,000 metric tonne contract does not confine what it knew about, what it could foresee, what it foresaw and what it could reasonably have foreseen. It is a specific piece of information, additional information, over and above what would otherwise ordinarily be reasonably foreseeable to a party. So if one starts from the proposition, what could they reasonably have foreseen would be the sort of loss that would flow, even if they knew about none of the details of the contracts between Amira and AK Global, then I say, if one can quite quickly get to the answer, well then clearly the sort of loss of profit arising under the 30,000 metric tonne contract is the sort of loss that would be likely to flow if you interfere with a contractual relationship in this way. Then the question becomes, well, is what they can foresee confined in some way because they were in fact provided with the additional piece of information that there was this contract? So they were not told, for example, there are no other contracts between the parties. And it's not suggested, it was not suggested certainly, that there's any sort of sense in which it could be implied that the bank was being told that's all there is. It appears now to be accepted that the 30,000 metric tonne contract was a genuine contract pursuant to which AK Global and Amira contracted. And my own friend continually says, well, it's Amira's case, it's Mr. Chanana's evidence that there were overpayments under that contract. And that is a false characterisation of what in fact my case is, my evidence is. These are contractually binding arrangements, but the subsequent contracts are entered into for the purpose of the performance of the umbrella contract. So it is not an overpayment under the 10,000 contract, and it is strictly right that those goods are being provided pursuant to that 10,000 metric tonne contract. There are other contractual relationships in the background, but those are not the contract pursuant to which, specific contractual relationship pursuant to which those particular goods were being shipped and supplied. So there's now this allegation. We heard about it in opening. We hear about it again in closing. It goes to the counterclaim, I think, probably. It's an issue in foreseeability, but it also goes to the counterclaim because what is said is that it was an event of default because the wrong information was provided. Now, you've been shown the pleadings, and we're going to go back to the pleadings when I get back to the counterclaim. But there is nothing in the pleadings about this. My learned friend said, I think, in his closing, he didn't want to amend his case. So we can take from that the bank has taken a deliberate decision not to amend its case, and even more so, a reason to confine it to its pleadings. But in terms of where do those allegations go? They go to the question of foreseeability. What did the bank know, and what kind of loss could it reasonably have been foreseen? But it can't. The event of default argument, I say, can only go, even arguably, to the counterclaim because it can't affect what is simply a quantification exercise of the losses that my client suffered as a result of the breach which has been established. It was suggested in my learned friend's submissions, you were taken to a particular passage in Mr. Chinana's witness statements where he dealt with the reasons for his failure to pay down the 26th of February buyer's credit. I'll take you back to it, but the reference is Bundle B, tab 1, page 8, paragraph 51. And it appears that what my learned friend was suggesting is that explanation was wrong, the explanation being that the failure to pay out under the irrevocable letter had the consequence that shipments stopped and payments didn't come in to pay down the 26th February buyer's credit. As I understood the submissions, my learned friend was seeking to challenge that evidence and therefore the conclusion, what's being said in that evidence. But simply put, it is too late to do that because that is dealt with in the judgment. And I'll show you that very briefly. If you pick up Bundle E, and it's the first tab, page 7. Dealing here with the question whether or not the bank had any defence to the claim for payment out of the monies, and the answer being no, and we'll get to it at paragraph 25. The judge starts at paragraph 22, dealing with the terms of the agreement. He says those terms were on the evidence complied with, and so the bank's obligation to pay, those terms in the irrevocable letter, so the bank's obligation to pay crystallised on the 14th of February in the sum of $4.134 million, having received $4.194 million. There was thus some $60,000 in hand, the payment was made. And then the judge goes on to say the effect of the bank's failure to pay and its refusal on the 24th of February, some 10 days later, to extend the buyer's credit facilities, a refusal which was repeated subsequently on the 27th of February, was to prevent AK Global from making further shipments under the 10,000 should be tons contract to Amira, and to prevent Amira from receiving further sums from Kuwait Flour in respect to the balance of shipments which take place thereafter, which would have been utilised to pay off the buyer's credits due for repayment on the 26th of February. Then carrying on into 23, on the 14th of February, when Kuwait Flour made the payment, no buyer's credits were actually due. I've already referred to the dates when buyer's credits were due, for repayment was falling later in the month. It's only 3 days later, so 3 days prior, that the irrevocable letter had been issued and the bank had been told buyer's credits falling due would be settled from Kuwait Flour's payments. On the evidence, the sums due on 15 and 22 February 2018 to the bank would have been and were met by the sums received from Kuwait Flour And the 6 shipments made and the sums which fell due on the 26th of February would have been met from the further shipments which would have taken place if the bank had honoured its irrevocable letter of the 11th of February. There would then have been no question of default at all if the bank had complied with its obligations under the irrevocable letter. And so in light of those findings, the judge goes on at paragraph 25, he deals with some other points, and says, in the circumstances where it's clear to me that there is no conceivable basis for any defence, there is every reason for the court to make the order for payment of the sum. So it's part of the rationale for reaching his conclusion to dismiss the defence that my client was in breach at that stage, and therefore could have been ordered. So I say, the effect of that, although expressed in terms of the position as at 26th, 27th of February, is at the least, but as at the date of this order, which is the 1st of May, the judge is finding that there's no defence as of today, 1st of May 2018, for an order for payment out of the sum that is being sought. That's the logic of it, because the defence would be, but they're in breach now for non-payment of the 26th of February by his creditors.
I have a little difficulty with that reasoning. If that were right, then surely the judge would have said the cheques can't be called on.
He did say the cheques can't be called on.
He said that on an interim basis.
On an interim basis,
He did,
that's
but
right.
surely if you're right, he would have said that on a final basis.
But it depends on how it was put, because I was only asking for an interim order at that point. And in fact, what he says there is, paragraph 27, it's conceded by the bank that the claimants crossed the threshold of a serious issue to be tried in relation to the question of the cheques. That's as far as he needed to go. He says the reason for that, and so forth, it was the subject of presentation in the context of what was said to be an outstanding indebtedness to Amira from the bank. And then he says, if the irrevocable letter has the effect contended for by Amira in the context of the facility agreements as a whole, the bank's position is extremely hard to justify. Not only is there a serious issue to be tried from the perspective of the bank looking at the claim against it for breach of contract, but a harder question to answer is whether the bank can get across that threshold from the opposite standpoint in showing an entitlement to realise its security. Now, I accept that in the context of the claim in relation to the cheques, that is not a finding. If that were the only claim that were being made, then I wouldn't be standing here making these submissions, because clearly what I was asking for on that day from that judge was, in relation to the cheques, only an interim order. And so I didn't need to go any further than establishing. The judge didn't need to consider any greater test and know whether there was a real issue to be tried. But if one goes back then to consider whether or not the judge, what the judge was finding in relation to the claim for payment out, he made a final order that on that day the bank could be ordered to make that payment out. And in doing so, he considered the potential defence being that my client might be in breach, and therefore the logic of the order must have been, although expressed by reference obviously to the question of the default on the 26th of February, if he's considering the defence as it might have been advanced at that date, he's saying I can see no conceivable defence as at that date. That has to be what he's considering.
If your client was in default, if Amira was in default in that it owed money to Amira, to the bank,
Yes.
why would that have been a defence to the claim for payment of money out under the irrevocable letter?
I can't remember back to what the arguments were, because I recall them. I believe the arguments were that Amira was in fact in default as at that date, and therefore the bank was not in a position where it was required to comply with the terms of the contractual arrangements. That would flow for any number of reasons. I took your honour earlier. Well, I'll take your honour in a moment as well. Sorry, I don't think I had taken each. I referred to them in my skeleton. To the principle in DIFC law, at least, where you have mutual obligations, one party does not comply with them, and the other party doesn't have to do what it's required to do. That's one answer. Another answer would be, well, they could just give notice of default. So then there would be a breach, and they could call in all of the facilities and bring the arrangement to an end, because on that day our client was in default. So it was a feature of the question is there a defence, to look at the question, could they conceivably, could my client conceivably be said to have been in breach as at that date? Appreciate it's not expressed quite in those terms, but that must be the logic of what's being decided. But at the very least, one has this finding, which must be part of the finding. I don't think that is challenged, but at least as at the 26th of February, and the failure to pay on the 26th of February was itself caused by IDBI's breach, and therefore IDBI was not entitled to the license. So there's two potential solutions to what's being said here. One is that the breach on the 22nd, the failure to pay at that time, was a breach which the bank can't rely on because it was caused by the bank. The other is what I'm saying must be the conclusion of in effect this judgment, which is that as at the date of the judgment, there is no breach on which IDBI can rely as a result of the non-payment back in February. So that's my position on that. Your Honour observed that during the course of my own friend's submissions, my own friends slipped between saying, well, there's no evidence and there's no contemporaneous evidence. And when I pressed him on one particular point when he had said there's no evidence, he reverted back to no contemporaneous evidence. And so there's some forensic points made about what is available and what isn't available. Amongst that, it's been suggested that it was ordered by the court that Amira disclose the Kuwait flour contracts. Now, I wasn't involved in that process, but looking at the documents fresh, it's not at all clear that that is what...
I don't regard that as significant, Mr. Montague.
Well, I'll move on from that.
I'm just being reminded that, as I asked to be, we might need a break. And what's your guess as to your time?
Well, I would say the reply points I have may take me another 10 minutes. And then council's estimate, so it might be about another 45 minutes, I'm afraid. If you're willing to indulge me for that long, but I can go faster if you want.
No. Well, I think we're all reconciled to sitting on a bit.
I'm ready for that.
Why don't we just take a short break, just a bit of a relaxation, 5 minutes break, and then get back to it.
All right.
Briefly then, as fast as I can, Your Honour, there's assertion that something might have been paid back from AP Global to Amira, and the suggestion seems to be that the burden's on me to establish that nothing was paid back. That is simply wrong.
Before you go too far, it was my suggestion that that was a possibility.
Well, a logical possibility. But I mean, of course, I have the burden of establishing my client has suffered loss, but if some discrete factual element is alleged by another party, they then bear the burden of establishing that. It's all quite well established. Otherwise the position becomes that I have to, or my client has to, anticipate and address every possible allegation, no matter what it is. And you recall that this particular allegation arose in the course of cross-examination. So these are bank statements that defendants had for months. And in the course of cross-examination, you say, well, there's some payments coming in here. These are what my friend described as unexplained.
Well, it didn't actually arise in that way. It really arose, to me at least, from the letter of the 11th of July, which your side wanted in, which said we'll balance things up later, referring to the payments directly from Kuwait flour.
Right.
The question in my mind, and I have no answer in mind, is whether that means that you had the burden of showing that didn't happen.
I don't think it changes. Does it change? I don't think it changes the burden of proof, though. If it's asserted that would happen or that will happen.
I'm sorry, your burden is to prove that you suffered a loss.
Yes.
That's the point.
Yes.
This is a factor in it, undoubtedly. So who had to prove that factor was not operative.
Not necessarily, no, because that's my point. So if I have to establish, trying to think of some examples, but it's late on day 3 of the trial, and my brain isn't working as well as it was, although it was working very well in the first place. But I think the point is that I can establish my loss as of now. I can show, with the evidence that we've produced, that trades were diverted, that payments were not made to my client, and were made to AK Global. And so the suggestion I think that Your Honour is making is that from that passage of the letter, perhaps there might be, or might have been, as a matter of fact, payments which have or will be paid back to my client. But if that is asserted, if that is alleged, and it is alleged that those payments were made, that's the part that is alleged by my friend, then it's on him to establish that discrete allegation of fact. So if I suffer a loss and I come to court and say, here's my loss, I've established that I've suffered a loss, whether it be, I don't know, an accident that's happened to my house or whatever it is, I don't have to come to court with all the possible points that might be raised against me and anticipate what other people might say. That loss could have led to particular collateral benefits to me, or could have led to me clawing back items, clawing back some sort of profits. I can just show you the loss that I can establish. And absent some evidence that I have got those back, or that I will get those back, then that is the loss that I've established.
Yes, but that's not this case.
No, but then the question is who's relying on that evidence and for what, to what end? And then the question becomes, well, and then, as I say, the burden is on the party saying, well, relying on that evidence, you got something back, or you are going to get something back. It's a pretty conventional, I would suggest, analysis of how one approaches the burden of proof. Otherwise, as I say, the burden sits on my client. So Your Honour says, well, okay, there's a sentence in that letter which suggests that there might be some payment back. My owner friend says, oh, well, there's some entries in bank statements that suggest that some payments may have been made.
Well, that's a separate question.
Well, they're of different order, but they're the same sort of thing, if you see what I mean. It's the same category of point that's being made there. Does that make sense? In other words, what Your Honour is saying is that is some aspect of the evidential record which might suggest that payments are going to be due back, or payments have been made back. It is the same category of point that my owner friend is making. He wants to rely on it, fine, but that's his burden. He has to put it to my witness to say, well, look, you say this is the loss you suffered. Here is a letter which says you're going to get some of this back. You're going to get some of this back, aren't you? Here is a document which says you got some of this back. You got some of this back, didn't you? And that's my point. None of that happens. I don't say it's not open to my owner friend to rely on that sort of material. Of course it's open to him to do so. And it's not really a question of burden of proof, because what you've got is you've got witnesses who have come to this court saying this is the loss. And so you have that principle. That principle is, if you were to challenge that evidence, you need to give them an opportunity to answer those points.
Well, one answer might be, and I don't recall it well enough, that if Mr. Shinana had said, for example, as a result of this, Amira suffered loss. The loss included that the profit was paid to AK. We lost the profit because payments were made direct to AK Global, full stop.
Yes.
Then it can perhaps be said that that's evidence which calls for challenge by the other side.
Yes.
And the burden is on them to challenge it.
Yes.
That's one way. Now, I don't recall whether he said something as direct as that towards loss or not.
Yes. Well, if we're talking about the diverted claim, yeah. So if you recall, one of the corrections that he made to his evidence orally, he'd written in his first witness statement that they'd had to forego profit on the 13 of those trades. And so one of the corrections he made was that witness statement obviously was made in May 2018, I think April 2018, just before the first hearing. And and some of the trades then came afterwards, and so he corrected that evidence to say that there were 17 trades in relation to which Amira lost out on the profits because those trades were diverted. So there was that evidence.
Well, maybe that's the answer to my conundrum.
Yeah. I'm not sure it comes down to burden of proof. I mean, the burden of proof became my own friend's response to quite a lot of these problems that he faces. But fundamentally, and that's why I address it more broadly, fundamentally, yes, I accept it. It's on me to establish that there has been a loss. But if he wants to establish that it should have been mitigated, that it could have been mitigated, or that in fact there was a collateral benefit which reduced the loss, then that is for him to prove. And quite apart from the question of burden of proof, that is for him to deal with my witnesses.
I think we've probably spent enough time on this one.
Yeah. All right. There was a question about the chronology of the supply by AK Global. You were taken to that letter, which was from AK Global, which you hadn't seen before, the new one. And we won't go back to it. But in that letter, AK Global said, in effect, I'm summarising, but the effect of it was to say, until they get paid, no shipments, the shipments will go direct. That's the effect of one of the things they said in that letter. They were then paid on the 20th of May by IDBI, and then after that, you get those 5 shipments in lines 177 to 181. They come after they receive the money. So they've said, we're going to divert shipments until we get the money. Then they get the money. We get 5 shipments, and then after that, you get to June when they say no more shipments. We're terminating our relationship, and then it's after that in July that you start to see in the sales and purchase matrix these alternative supplies. So there's some suggestion that the chronology is curious and doesn't work. It makes sense on that basis. This question of, we've been over this, but this question of whether or not my client was actually entitled, AK Global was actually entitled to terminate the contract. It said, well, I say that there's a question of fact as to whether, as a result of IDBI's breach, they just stopped supplying us, whether they were entitled to or not. And then it becomes mitigation, as I think was conceded. And then the question is when in circumstances where there's a dispute between my client and IDBI in the first place, is it unreasonable for my client to look to IDBI for those losses and not to start proceedings against its former supplier with whom it does business? And the answer to that's pretty clear, I would suggest. And again, when one looks at those insurance cases, normally one would have to plead mitigation, a lack of mitigation, and that hasn't been pleaded, so we don't deal with it. But if one looks at those insurance cases, the courts repeatedly say that a party put into that sort of position, at least with the broker negligence situation, is not expected, it's not unreasonable for them to refuse to say they're going to embark on risky litigation, fresh risky litigation. Then you hear this issue about the replacement contracts, where they were different crops, but it was never even suggested, as I've said to the witnesses, that is a material difference between those contracts, let alone any evidence to that effect. Again, there's this point about burden of proof, but this is in effect a betterment argument. It's an assertion by the defendant to say you had to go, you lost your supply, so that asset was lost. You had to enter into new contracts. Your position was bettered by that. Again, that is a betterment argument. One sees it. All kinds of insurance claims, fire claims, and that sort. And there's law about it. You don't have that law in front of you. But ultimately, that is a specific assertion that's being made and needs to be backed up by the defendant. But whether it's on burden of proof or not, still needs to deal with it with my witnesses. And the same sort of points arise in relation to the question of the higher prices that were achieved. It's a question of collateral benefit. He wants to say that was caused by the breach. He needs at least not only evidence, but he needs to put that to the witnesses. Then there's this difficult question of general damages, and I appreciate it. I'm grateful for the indication. I was struggling with how to approach that. The argument is, my clients had an opportunity to show special damage. To that extent, a claimant always has the opportunity in litigation to show special damage. The point is, as was recognised by the judge in May last year, it is always going to be difficult to quantify, and therefore it's always going to be difficult for an expert witness to do that sort of analysis.
I should, so that you know what you're dealing with, it certainly is in my mind that instead of trying to prove a loss through fall in share value, an exercise of taking the accounts and pointing to a downturn in the turnover or in a particular area, and then a loss of profit from that, and then trying to attribute that to this would have been, I would have thought, an available exercise, let's put it that way.
That might be right, and you'll have seen that to some extent that's an exercise I've sought to synthesise on the material that you have.
If there's a hint at it in a couple of the tables that are in the evidence.
Mr. Gandes gives evidence as to what the profits were in the year before. He gives the projections for the profits in 2018 to 2019. And of course we're still in 2018 to 2019, so any suggestion there ought to be audited accounts and the rest of it for that it is not fair. Now, he was asked a few questions about those figures, their estimates aren't there. It never suggested to him that the materials on which he relied were the wrong materials, or it was never investigated whether or not that those were reliable figures. So you have before you figures on which I say you can rely. There's evidence before you which was ultimately effectively unchallenged, that in the previous year these were the profits, in the following year, these were the profits. We've established, I would suggest, particularly Mr. Fritchie accepted at least, that a fall in profits, a fall in income, would be consistent with the effects of damage to the reputation, financial reputation of the company. That is logically the position anyway, and you've seen the cases which say actually there's a presumption that that is the position. And so, if you have that, you can see the profits fall. I don't have the figures right in front of me at the moment. I think it was sort of $35 million down to like 6.5 or something. You can join the dots on the authorities. My other friends haven't responded to those authorities, but there we are. They're out there. The court can take a robust approach to causation in these circumstances and find that, to a large extent, the fortunes of the company, the declining profits of the company in that period, over that year at least, were attributable, at least to some extent, to these events. Those are the figures that I would ask you and urge you to focus on when considering how much, if anything, Your Honour is willing to attribute to that. I say if anything simply because I don't want to presume on Your Honour's exercise of discretion, but I say that it must be, should be, a substantial sum. Within that context, it's a substantial trading organisation. I think those were the points that I wanted to deal with in reply, unless you needed anything further from me in reply on my claim.
No, thank you, that's fine.
Great. Well, I think you probably had more than you wanted.
When you get to the counterclaim, I would like your help on the event of default, notice of default / pleading questions.
That's where I'm going to next.
Right.
So I'm getting to the counterclaim now. And as I've said, I say that actually the pleadings are much narrower than the impression that has been given, and puts particularly in context what actually is said in the pleadings. So there's separate questions, as I've said. What is in the pleadings, what is in the notices, and actually what was put to the witness. Actually what case was advanced to the witness. So let's just look at actually what the event of default was that was alleged in the pleadings. And if you pick up under A, please, you can see that at page 22. So it's tab 6. So if you've got page 22, you've been shown various paragraphs. What you haven't been shown.
Hang on a second, please.
Sorry.
A tab 6,
Page 22.
22, yes, thank you. Yep.
So on the previous, just to put it in context, on the previous page, if you go back 2 pages, you'll see the pleading has headings. And so the heading at the top of page 20 is the facilities, the final facilities. Then the defendant's rights arising on non-payment. And so there's a fair bit of pleading of that. And then we get to paragraph 40 and 41. Particulars of breach. In breach of contract, the claimant did not pay the amounts due in respect of the 26th February buyer's credits on 26th February 2018 or at all. So there is an allegation there of a continuing breach. But let's just see where this ends up. On 26th of February 2018, the principal amount of the 26th February buyer's credits was devolved into the first claimant's overdraft facility. The first, and then paragraph 41, this is the one that I rely on the most. The claimant's failure to pay the amounts due in respect of the 26th Feb buyer's credits on 26th Feb 2018 constitutes an event of default pursuant to clause 14.1 of the facilities agreement. That is the allegation of breach. You've been shown some others, and I'll put those in context and we can see that they are not what found the counterclaim. And we'll come back to that. But there are 2 points here that we need to bear in mind. The first is that what is being alleged is a failure to pay the balance of the 26th February buyer's credits. So what my client failed to pay is the first question, and when my client failed to pay it is the second question. So dealing with the first, what my client failed to pay, according to this, the balance of the 26th February buyer's credits. So we've seen some of it was repaid, but you see in paragraph 43, the amount is defined, paragraph 43, in the second sentence, referring to a letter of the 17th of May, 2019, and it says, in that letter, the defendant notified the first claimant of the amounts due and payable in respect of the 26th February 2018 buyer's credit, brackets, the amount. And so they don't actually plead what sum is due. I'll give you the reference to that, but the amount is D4, tab 168, page 704. It is defined in that letter as $2,215,934.40. So this is simply pleading out correspondence. It's not asserting in these proceedings a breach of or an event of default under the facilities agreement other than on the 26th of February. That is what is alleged at paragraph 41. So for example, 42, you get demands for payment and then pleads out letters in which demands were made. 43, letters, they wrote letters. In that letter, the defendant said X, said Y. These are not allegations of breach, these are pleadings of correspondence, things that were said in that correspondence. So, in any event, the specific amount that's being said was not paid was 2.215 million on the 26th of February. Then you get to the notice of default, so that there's pleadings about things that the correspondence that pass backwards and forwards. And then paragraph 53 pleads out the notice of default. And paragraph 53 then refers to this notice of the 6th of June 2018. And it is on the basis of that notice that it is alleged that the defendant is entitled to reclaim the monies claimed in these proceedings. And you see that from the following paragraphs. I won't take you through those in a lot of detail. Now, So what I say is that on the pleadings, it is clear that there are two options. The bank might have been saying in these pleadings, there was an event of default on the 26th of February. That event of default continued until the 6th of June. And then we gave notice of that event of default on the 6th of June. We haven't given notice yet, but we don't waive our right to do so. So that seems to be what they're doing. They're saying that is the date. So the non-payment on that date, that's the breach. We don't waive our right to rely on it all the way up to the 6th of June, and then we do rely on it. But it's still an allegation of breach on that date. That's the effect of the plea. There would have been another way to do it. Would have been to say, well, there was a breach on that date, and it was an event of default on that date, and then on the 6th of June, there was still an event of default, because even by then, in between the intervening period, it had not been paid down. And then on that date, we gave notice of that event of default, or on the basis of that event of default, we gave the notice. So that seems to me to be quite clear, at least on the face of the pleadings, particularly from paragraph 41. Now, what we certainly don't... My own friend seems still to rely on certain other alleged breaches. What you will not find in his pleadings is an allegation of an event of default in the presentation of the documents relating to the irrevocable letter. Yes, I've not found it, and maybe my own friend hasn't referred to any particular paragraph that deals with it. What he has said is he relies on something that's said in his reply, which you find tab 8. But before we get to that, we have this question of what actually, and I'll come on to whether the particular paragraphs of the reply help him, because those are dealing with failures to provide documentation and so forth. But in any event, the question that Your Honour raised with him was, well, look, don't you have to give notice of the default? And so aren't you limited to the default, the event of default that's identified in the notice? And that is the notice that you've seen at Bundle D1 tab 2. And he says, well, no, because it says I have to give notice in writing, but it doesn't say that I need to, it doesn't confine me otherwise. And so it's a question of construction, really, isn't it? Because the question is, you have to give notice, but notice of what? To give, and the notice in writing has to be a notice of something. And we would say it has to be notice of the event of default that is being alleged. My learned friend accepts, I think, that he has to give notice of a default, he has to identify a default, but once one gets to that point, it's very difficult to resist the conclusion that you have to give notice of the default. Your Honour's looking for something. You're looking for the clause.
No, clause 14.
Yeah, it's page 50. Sorry, no, it's not. Sorry. It is page 62, bottom right. No, it's not. It's not even that, I'm afraid. Sorry, it's getting late. 64, thank you. Upon the occurrence of an event of default, at any time thereafter, the bank may by notice in writing to the borrower.
No, that supports your last proposition.
Well, the question is, what do you have to give notice of? You obviously have to give notice that you are calling an event of default.
Well, Mr. Francis says that the 10 words are, the notice is, I require you to provide, I declare, I invoke.
Yes. Well, as I'd understood his position, there are 2 points here. As I'd understood his position, he accepted that you had to give notice of a default. He accepted that you have to identify a default. His position is you can change which default relying on. So there are 2 points here. Firstly, once you accept that there is some content in the notice as to what, as to giving notice of a default, once you accept that that is a requirement, and that's my understanding of this position, then it's very hard to resist the conclusion that that requirement must be that that be an accurate statement of the default in which you're relying.
Well, on any sensible commercial view, it's hard to see the point in a notice which simply says to a borrower, I declare that everything is payable, full stop.
Yes.
And the borrower would be entitled to say why.
Quite.
But this is something which might end up important in this case, and I'm sure there must be authority on it. I'm not aware of it, though I've struck these sorts of clauses in the past, but can't remember them. I wonder if I might ask both sides to have a look and see if they can find some authority on
Construction notice.
clauses talking about giving notices of events of default or notices calling money in and so on to see what is needed. I would really appreciate that.
Understood. There's a second aspect to this, though, which is that once you specify an event of default, the effect of that, I say, is you confine yourself to that allegation.
That again seems common sense, but I would include that in
Yes.
what I would like both parties to have a look at.
The logic of it, if I can just say, what's going through my head is this: that if one takes one takes the position, the bank says, you borrower in default because you're overdue on this loan, and so the borrower pays that bank. The bank says, thank you very much for the money. Here's another event. By the way, you were also in default because you failed to produce a statement of your net worth, and so I'm now going to close you down. Can they shift? Is it right that they could shift? Now, it may be that this will be informed by the backdrop of UA law of good faith and matters of that sort, which we don't have, at least we probably don't have, in the common law system. But we will do our best to see what we can get.
Yes, well, starting point might be to get ideas in our heads, see what the common law system says about it.
Yes.
But then I appreciate that UAE law is set to govern, so that may not do more than give us a principle of some kind.
Yes. Thank you. So then we go back to the pleadings about these other potential events of default. So question is it properly pleaded? Now, in a sense, I think quite a lot of this has gone by the wayside, because when we look at it, Your Honour can ask yourself whether or not the allegations that were made in the letters that are recorded in paragraphs 17D to E of the pleadings have actually been put to witnesses, have actually been properly investigated at trial. But as I understood it, what is relied on is paragraphs 17D to E of the reply. I believe that's behind tab 8. But as I say, it's important to put this in context. So what we ought to do, if I may just do this exercise, is trace through how those paragraphs arise. So you've seen, starting still in the defence and counterclaim, page 22, paragraphs 40 to 41, you've seen the particulars of breach there, and in particular the allegation of the event of default in paragraph 41, which is, as I say, the claimant's failure to pay that unpaid part of the 26th February buyer's credits. Now, the response to that then comes at tab 7, which is the amended reply and defence to counterclaim, page 37. And if you see at paragraph 20, what's said there, the defendant's failure to make the payment on or around 14th of February 2018 constituted a breach by the defendant of the facilities agreement and or the irrevocable letter. The defendant appears not to deny that. The defendant is in any event stopped from denying such breach. 21, in further breach of the facilities agreement, A, the defendant has refused to provide further credit facilities to the first defendant of the facilities agreement. B, the defendant has made it clear to the second claimant and other suppliers in the market that the defendant will not extend further credit to the first claimant. And C, the defendant presented the cheques for encashment. That's paragraph 21 of page. And then if we go over the page to paragraph 22, we see the consequences set out there, the allegations as to the consequences of the breach. Paragraph 22, the result of the defendant's breach of facility agreement. As before said, the claim was unable to repay the 26th Feb buyer's credit in full on or before 26th Feb 2018, and then explains why. And then if we go forward to page 40, we see the defence to the counterclaim. And if we go to paragraphs 27 to 29, so what we've been looking at was in the reply, that's dealing with the claim. If we go to the defence to counterclaim, we're looking at paragraphs 27 to 31. It's admitted that the first defendant hasn't repaid the 26th Feb buyer's credit. It's denied that such non-payment constitutes a breach of the facilities agreement. The reason set out in paragraphs 21 to 24 about such non-payment was caused by the defendant's own breach of the facilities agreement. And then further, defendants stop from denying certain matters. Defendants attempt to relitigate those matters as an abuse. Denies a particular paragraph, and then if contrary to the above, then there's this allegation of set-off. And then the pleading that my learned friend relies on actually only replies to one very discrete part of this case. It's actually responding to the reply. So if you go to page 54 in the next tab, what my learned friend relies on is paragraph 17, D to E. And you will see at the start of paragraph 17 where that comes in the sequence. It comes in relation to the claim, not in relation to the counterclaim. Paragraph 17, the claimant has failed to provide adequate particulars of its case in paragraph 21 of the reply and defence to counterclaim. Further, alternatively, with respect to paragraph 21 of the reply and defence to counterclaim, D, the defendant denies that its presentation of the cheques was in breach of the facilities agreement. There were, and it's in that context it's alleged, there were multiple breaches of the claimant's obligations under the facilities agreements. Then you have set out certain allegations recorded via correspondence. And they say, well, multiple breaches, non-payment after, up to the 27th of February 2018 is the first letter, continuing non-payment there of the 26th Feb buyer's credits. So again, that's before the payment is ever made pursuant to the court's order. And then paragraph 5 in that letter, you see in the middle of little 1, further utilisation of the NFB limit can only be by way of LCs only, and then there's allegations of irregularity in relation to submission of documents, submission of stock statements and so forth, bank statements and the rest. And then there's reference to the 22nd April 2018 letter. Further, the borrower has not serviced the OD interest fallen due on so forth, hence the OD account is irregular. So that's about the overdraft interest, and that is the amount that was demanded and paid, and it's the subject of the $41,000 claim for interest. So in fact, if it's alleged that that breach was not cured, then you've seen the evidence which shows that that is wrong. You can rely through that. 3 is defendant's letter up to the 1st of May, buyer's credit aggregating, and then they say that there was an outstanding, so in the middle of this paragraph 4, 2.3 million after adjusting available cash margin. Apart from non-clearance of the overdue, the buyer has not complied with the terms of the sanction. So again, allegations which haven't been followed up about not providing documentation. And then E alleges a series of other breaches, I believe, which again haven't, as far as I can see, formed any real part of these proceedings. So we've got breaches in relation to the drawing power limit, financial covenant, the undertaking for books and accounts, preparing and maintaining up-to-date books and accounts, and then for capital requirements. So all of this is directed, it seems, or at least the bits in D, which are the only bits, as far as I can see, that deal with subsequent failure to pay up to the 1st of May 2018. So they got to the 1st of May 2018. So even if you can, the way it's pleaded, you're being invited to import into the pleadings the allegations from the letters. The final letter comes on the 1st of May 2018. So at most, you have an allegation which could be up to that date. At most. Because that's the date at which that assertion is made. So the content of the letter is alleging a breach up to that date.
E is not date specific.
I'm so sorry?
E is not date specific.
No, E is not, but E is alleging a series of things which don't have to do with repayment of the buyer's credits. E is all about drawing power limits, credit capital ratios, up-to-date books and records, and capital requirements. So, assume that you can take all of this and simply import it into the allegation of breaching the counterclaim. That only could ever get you up to a breach on the 1st of May 2018. So that's as far as that can take it. But, in reality, E aside, when you're looking at D, D is pleaded in response to the allegation that there was a breach in presenting the checks. So it's about the claim. The judge had already found on the 1st of May that as at that date there was no breach. I say he made that finding, we discussed it, and I visited it, you can take a view on that there was no breach. And so if all of this is directed, firstly at alleging a breach up to May 2018, and secondly directed at allegations of the presentation of the checks, Amira is entitled, or was entitled looking at that, to take the view that those parts of its case take matters a little further. It's entitled to take the view that it's not required to engage on that. And so if that part of the pleading does what my own friend says it does, imports those allegations up to the 1st of May, and is to be used to justify allegations of events of default subsequently after 26th of February, that is a completely different landscape. The importance of those sorts of allegations changes fundamentally. But in any event, that is not actually the way the pleadings work, because as you saw, the counterclaim itself rests on the breach on the 26th of February. My own friend has already said he doesn't want to amend his pleadings. So that is where you get to on that pleading point. And then, as I've said, we've got these further allegations of default in presentation of material, in acquiring and getting the bank to issue the irrevocable letter, the failure to tell IDBI, the alleged failure to tell IDBI about the 30,000 contract, amounts it said to another breach of the facility agreement, and I think in opening it was alleged that was a misrepresentation, and then we got into this mess about whether or not it was being alleged that there was sham documents. None of that is in the pleadings at all.
I think that's fallen away with sham falling away.
Sham's fallen away.
That's my understanding. Anyway.
You've made your Honour's made your position clear. My position is that it's not part of the case, not pleading as part of the case anyway. If anybody seeks to revive that, then it will be resisted. But the upshot of all of this is that there is no allegation of an event of default.
I'm sorry, I should make it clear.
Sorry.
It's there for some effect on foreseeability.
Yes, quite.
I think
Quite.
all that
Yes.
is set to go to foreseeability. That's what I understand.
I'd understood that to be what you were saying as well. I would try and take that point.
My apologies, I think.
No confusion there. So the upshot of all of that, I said, there's actually no pleaded case on any event of default coming after the 26th of February. And it matters because it matters both what is being alleged not to have been paid, the balance of the 26th of February payment matters, because there is a set-off allegation, set-off claim, a set-off defence there. I'll deal with my own friend's points on the contract in a moment. But the timing matters as well, because it fundamentally, obviously, I'd say, affects the question of what evidence is going to be put before the court to determine what is my other point of defence, which is whether or not failure to pay on a particular date was caused by the event of default, the breach of IDBI. That is inevitably time sensitive. And so the question of when that breach is said to have occurred is absolutely critical. And my client is entitled to take a robust view as to what has been pleaded and insist that the case be limited to that, I'd say. Because, I mean, in a sense, what I'm doing is I'm making submissions in response to an application that's not being made because there's no application to amend the pleadings. And then one gets to the next problem for my learned friend, which is about what has been advanced in cross-examination. And so, in relation to these other breaches, capital limits, documents provided, putting aside the points that the sham point that appears to have been dropped, it's never been suggested, for example, to Mr. Chanana, Mr. Gandhi, that there had been a failure to provide certain documents, failure to maintain credit ratios, failure to present information, failure to provide documents. Sorry, I said that twice. As at those particular dates, which hadn't been cured or hadn't been waived, and there could have been all kinds of arguments about those sorts of things had those been raised, but none of it was even suggested. So he was never given a chance to answer that. So even if there could have been some prospect of saying my old friend could advance that case today, he didn't actually do it. So you can't maintain a position in closing. So just then coming to where that leaves us on the counterclaim, as I've said at the outset, my client doesn't deny that all other things being equal, absent breaches and so forth, the balance of the buyer's credit was due for repayment on the 26th of February and it didn't repay it. But that, as I've said, is subject to 2 points, the set-off, which I'll come on to later, and what's always been Amira's main response, which is the bank cannot rely on a breach by Amira, which was caused by IDBI's supreme breach. There is authority to that effect in the contract law itself. It's Article 78 of the contract law. I don't know whether your Honour wants to look at it. It's fairly standard feature of every common law, most common law systems, I would suggest. Would you like to see it?
No, that's all right.
I'm grateful. And there's a related but slightly different principle, which is that when there are sequential obligations between the two parties, the party who comes second in their performance need not perform its obligations until the party whose obligations come first has itself performed. Now, Mr. Chanana gave evidence as to why the buyer's credit was not repaid, generally. He explained this position, which was accepted, let's say, by Sir Jeremy Cook, Justice Jeremy Cook. If the money had gone out from the bank, further money would have come in through these subsequent trades, and that would have paid things down. And the breach interrupted the shipping and put a stop to that. I'll give you the reference to that in his Witness evidence B, tab 1, page 6, paragraph 37. And then in his first statement, and that's his first statement made on the 29th of April 2018, so that's necessarily in advance of the 1st of May. But he also talks about the impact on Amira's credit, and this is something that hasn't been touched upon by my friend either in cross-examination or in submissions. So he talks about that at B, tab 5, page 45, paragraphs 30 to 32, and he explains his attempts to get credit from third parties and that he couldn't get any. And then also from Mr. Chanana. Sorry, I might be giving you wrong references, I do apologise. Sorry. B545 was evidence from Mr. Gandhi. And then there was further evidence from Mr. Chanana in his third witness statement, tab 7, page 62, paragraph 29, where he describes seeking alternative funding that each new bank that we approach, he says, refuses to provide financing. And he also gave some evidence of that orally, and it's at page 115 of the transcript as to why these buyer's credits were not repaid. That evidence was never challenged. And instead, we had, in effect, a series of forensic questions about what was in the documents. My learned friend's cross-examination started on page 119 of the transcript and ended on page 179. But nowhere in there will you find any suggestion to Mr. Chanana that Amira could have resolved this situation after IDBI's bid breach and repaid the credit using funding, financing from some other source or from somewhere else. There's no suggestion to that effect. So we had long questioning, for example, about a particular document and a set of invoices which had Mashreq Bank written all over them, and there was that line of questioning about where the funds were going to go from that and whether it was the next shipment and so forth. And it's still not clear to me where that line of questioning was going. But if the allegation was, for example, that maybe that indicated that the money from the following shipments was never going to go through IDBI at all, I don't know. But if that was going to be the allegation, then that had to be put to Mr. Chanana, and it never was. Nowhere was it suggested to Mr. Gandhi during cross-examination that that was the case as well, that they could have got credit from somewhere else and they could have repaid this evidence. And his cross-examination is much more limited. It's at pages 192 to 212 of that transcript. As I've said, I would say that at least up to the 1st of May, this issue is already settled, and I've shown you that. If that's not right, then it's at least settled up to the 26th of February. Now, so what I say is that actually makes your Honour's job on the counterclaim rather more straightforward than it might otherwise have been. Because, in summary, the only breach that is alleged, and the only breach that is put, is the failure to pay the buyer's credit on the 26th of February. You have the judge's finding that that was caused by IDBI's breach, and IDBI is bound by that. You've got no pleading, I say, that the breach was a failure to pay after that date. If you can import those particular provisions of subparagraph 17D of the reply into the pleading in the counterclaim, even if you could do that, it only takes you up to the 1st of May. That is the date of the judgment, and that, as I've addressed you on the effect of that judgment. So after that, the payment finally comes in on the 20th of May, and it's only 17 days later that this notice of an event of default was made. Now, as to whether or not, if I'm wrong that there's a binding finding on this that covers the pleading case, then Your Honour has to look at the evidence. And what is the evidence as to what was the defendant's capacity to repay the buyer's credit, firstly before the breach, had the breach not occurred, and secondly, in light of the breach. Certainly, before the breach, had the breach not occurred, that must be dealt with by the judgment. It would have been paid off. Then the question is, could it have, what was the effect of the breach on its ability to pay that off after the breach? And you've got some evidence, as I've said, from Mr. Chanana, from Mr. Gandhi, about that. And this question about whether they could get credit from somewhere else, there's no reason to doubt that, I suggest, even if it had been attacked in cross-examination. Your Honour will recall Mr. Ravi Kumar said, in the course of his evidence, and I'm afraid I don't have the transcript reference, but this is from recollection, that he accepted, if Your Honour remembers, I took him back to a letter that was sent in 2016, and some threats, I said threats, some steps which the bank had threatened to take. And one of those steps was to enter the details onto a system which would be accepted and accessible by other banks and would record Amira as being a defaulting creditor. It's hardly surprising in that context that Amira just simply can't get credit in the meantime. And so the question then becomes, the breach having caused the initial failure, at least on the 26th of February, but I say all the way up at least to the 1st of May, something would have had to have changed for that breach to have, that money to have been paid back. But fundamentally, there was simply no challenge to the evidence that we had. Now, we get this suggestion in closing. Well, hang on, it said, imagine that the buyer's credit that would have been advanced would have been a 90-day buyer's credit as of 26th of February. So if you go forward 90 days from 26th of February, you can see that there would have been a breach anyway on the 6th of June. Now that's an illegitimate exercise for two reasons. Firstly, the order that was made on the 1st of May was that the bank comply with the terms of the contract. So if the terms of the contract were, as I say they were, to extend buyer's credit on 90 days, then the 90 days would run from the date that that credit was extended, which would be the 20th of May 2016. And as I say, the notice of default comes only 17 days later. But the second point is this, it's actually not my case. It ignores actually what my factual case is. Because my factual case is simply that, as a result of the breach, my client's been put in a position that it can't comply at the moment. Now that position may well resolve as the situation becomes easier for my client with credit, if that happens after this case is resolved. But what you can't do is say, well, all right, but let's consider what might have happened in a completely counterfactual situation, which didn't arise, which isn't anywhere in the pleadings, which is, all right, an alternative case, assume that we had paid you, well then by now you would still be in default, so it hasn't caused it now. It would be a totally different factual scenario, which again has not been explored in the evidence. Because what would have happened? You would have got that buyer's credit, say it was 90 days from the 26th of February, then there would have come a time for it to expire. But you wouldn't have all of this damage to the relationships. You wouldn't have all of these diverted shipments. There's a completely different factual investigation as to where the client would be, where the claimant would be. In
At the moment, I can't see that it would be a relevant investigation.
No.
Being in default is the factual situation, not a hypothetical situation.
Yes.
It's as simple as that, that's the way I see it at the moment.
So, sorry, I'm just trying to see where that gets to on my case. Is that said against me?
No, I think it helps you.
I see. Yes, thank you. I think that helps me to understand the comment. Look, I'll leave it there then. As you say, none of that analysis then on that hypothesis actually turns on the terms on which the credit was to be advanced. It doesn't matter. So you'll have seen that when the money was paid, the bank said, we're paying this as an overdraft. We're calling it an advance and it's going to be an overdraft. And we said, well, if you're going to give it to us, you've got to give it to us as a buyer's credit on 90 days. So there is that factual dispute. Nothing actually really turns on that, on my hypothesis. So my friend advances a case to say, well, actually, it would have been repaid because even if it was 90 days. Or I think he says, when we paid, it matters that when we paid on the 20th of May, we were entitled to call it back the next day. But he makes that case. I won't labour this, given your honour's indication. I'll run through that quite quickly. I put some submissions in my skeleton argument about this aspect of it as well. Question then, how does that change in light of the evidence that we've heard? I think the point there is that although they resisted it, or at least Mr. Ravikumar resisted it, eventually both witnesses appeared to confirm that when they issued the irrevocable letter, they expected that the money that would be paid out pursuant to buyer's credits. That's my recollection of the evidence. Again, I don't have the reference. If I'm wrong about that, I'm sure someone will help me, or I'll write in and let you know that. But that's the only change. Everything else, as far as I can see, remains the same. And so, what I say about that is, you've seen the email, in those emails that passed between, and the email on page 501 in that run of emails, where my client says, this is the package we're looking for. Money comes in, pays off buyer credit, money goes out on fresh buyer's credit. And I say, my first point is, well, when they issued that irrevocable letter, they just accepted that offer. That is the package that was agreed to. If that's wrong, the contract law is slightly different in this jurisdiction than it is in England. You'll know that under many common law systems, the court's not allowed to look at negotiation, and it's not allowed to look at post-contractual events in determining what the contract contains. That is not the position here. The contract law, Article 51A, expressly permits and requires that you look at those preliminary negotiations. That is obviously different. I say that's relevant. That's subparagraph A in contract 1 in the contract law, preliminary negotiations to inform the content of the contract. I say that's relevant because if you look at what my client wanted, if it's not an offer, it's at least the preliminary negotiations for the irrevocable letter. Practices which have been established between the parties, I rely on that too because that's how it's worked in the past. There were these two previous irrevocable letters which were facilitated by buyer's credits. 3, I rely on the conduct of the parties after contracting, and in particular, that the bank sought to arrange buyer's credit. That is indicative that that was a term of the contract. And 4, the nature and purpose of the contract, and in relation to that, I simply say, well, what is the point of arranging this irrevocable letter in this way if my client already had the money to make the payment out? So given the way that the claim is put, that may not matter, but that's my position on it. So I say that the way the claim is pleaded fails. The way which it has been actually advanced to the witnesses means that these further allegations can't be relied on. My own friend says, in sort of Hail Mary catch-all plea, well, the money must be repayable at some point. He says the money is overdue. But there is no alternative claim advanced on the face of these pleadings to say, look, even if you're right, that was all a year ago, you must by now, even if it be obliged to repay pursuant to the buyer's credit that you say we gave you on the 20th of May. There's no alternative pleading to that effect. That is not part of the case that's advanced. That is a choice that the defendant has to live with. You want to outstay my welcome, but those were all the things that I was going to say on the counterclaim.
Yes, thank you.
Thank you.
Well, Mr. Francis, I think the last round is a reply on the counterclaim.
Thank you, Your Honour. I would like to take you through some of the letters that were sent in respect of the event of default. If I could ask you to pick up bundle D4, if we can go to tab 168.
Now, what what is the point in going through these? So I have it in mind as we look at them.
Yes, it's to establish that the buyer's credit amount, which is referable to 26 February 2018, was demanded as a current amount due on numerous dates, and the event of default was expressed as a continuing event of default. So there was notifications at various dates that this buyer's credit amount was due and payable and was demanded, and non-payment would be an event of default. In conjunction with clause 4.8 of the facilities agreement, we're allowed to demand a buyer's credit at any time, and it's due and payable on demand in accordance with 4.8. The point is taken against me. There's a technical pleading point. I say it doesn't stand up to scrutiny. If you track through the letters and you look at the provisions of our pleadings, it's very clear we're relying upon continuing events of default and these demands which are made at numerous times leading up to our final demand of the 6th of June 2018. There's a second point, and Mr Montague-Smith has confused two elements. I've been talking to you about buyer's credit, which are payable on demand under 4.8. The advance was made, so this is the sum that we were ordered to pay, the 4.134 million. We were ordered to pay. We advance it as an overdraft sum. I've taken you to the provision of the overdraft repayment terms, clause 5.5 of the facilities agreement. That again is an on-demand facility. So, in respect of the advance sum, on the 6th of June 2018, we're entitled to demand immediate repayment of that sum. Non-payment of that is an event of default. So that's the story I wanted to take you through and show you very clearly where we say in our letters that these are continuing events of default, and to show you that we have the right to demand those payments upon these dates, and non-payment is a very clear event of default that's been drawn to the notice of the borrower, in line with that, and all of that is in line with our pleadings.
I follow everything except when you say it was all in line with the pleadings, because that's, I've heard what you say about the pleadings. Well, there's a debate about that. Were you going to say any more about that or not?
Well, let me, I was going to track through the letters and the pleadings just to show you exactly how, what is said in the letters in terms of continuing events of default, and events of default on dates 17th of May and 27th of May and 6th of June. It's very clear that
what one will do, take me to one, then take me to how that's taken up as something you can rely on in the pleadings.
Okay, well let's go. Well, let's start off with the letter that I took you to. So 168, 17th of May 2018. This is the bank's letter. Over the page, 704. So outstanding amounts. Top line 3.1. The following sums are due and payable under the facilities agreement. These are the buyer's credit amounts. So due and payable as at this date. So 3.2, the above sums were not paid on their due date and accordingly constitute a non-payment event of default under clause 14.1 of the facilities agreement, this is key, which is currently continuing. Then there's a demand for payment. So last sentence of 3.3, on and on, the bank would be prepared to consider a waiver of that event of default provided the borrower pays the outstanding sums in full within 7 days of the date of this letter by Thursday 24 May 2018. And then 3.4, for the avoidance of doubt, failure by the borrower to make payment of the above sum in full shall constitute an event of default.
It actually doesn't. It isn't a demand for payment. It says the bank reserves its rights to demand and then proffers coming to a deal. Does it demand?
No, it's a demand. It's a demand for payment of these outstanding sum within 7 days of the date of this letter.
I'm sorry, where do I see that?
Sorry, the last sentence of 3.3.
No, it says be prepared to consider a waiver provided they're paid. That's all it says. That's a term of an offer, that's all.
But this is this is notice of an event of default that the sum is not paid within 7 days of this date of this letter. And it's a continuing event of default. So 3.2, this is a continuing event of default as at this date.
Well, it may or may not be that, but you said it is a demand for payment, and that's what I'm questioning.
Okay, well, just to track through to... Shall I track this through to the pleading, or shall I move on to the next letter?
So let's track it through to the pleading.
Okay, so if we go to our amended statement of defence and counterclaim, so bundle A, tab 6, page 22. That's paragraph 43. So, following the order and by letter dated 17 May 2018, A&O wrote the first claim to counsel Taylor Wessing. In that letter, the defendant notified the first claimant of the amounts due and payable in respect of the 26th February 2018 buyer's credit, the amount, and that their non-payment constituted a continuing event of default under the facilities agreement. And then you've got the last sentence there. To incentivise prompt payment, the defendant stated that it would be prepared to consider a waiver of that event of default provided the first claimant paid the amount by 24 May 2018.
Mr. Montague-Smith says that this and the other letters were simply a tracking through of the correspondence, I think he used language like that, and did not amount to anything which would enlarge upon the event of default as described in paragraphs 40 and 41. So that's what you've got to challenge by taking me to these.
Well, you've got the heading there above paragraph 42. Demand for payment, which we have to do under the event of default provision, and notice of event of default. So this is what we rely upon to tick those boxes.
Mm-hmm.
So we rely upon this letter, 17th of May 2018. It's in the pleadings. Can't see how we should suffer for a technical pleading point when this is clear as this. And there are other letters that I want to take you to.
Well, so you say that the heading makes the difference. It makes it plain that
Yes.
This is being relied on as an event of default, or
Yes. That,
Yeah.
combined with the content of the letter,
yes,
combined with the quote in the pleadings.
okay. Now, are the other letters in the same category?
Well, let's track through. It becomes clearer and clearer.
No. Are they in the same category?
What do you mean by the same category?
Do I gain anything by going to the other letters?
Well, they're clearer and clearer demands for immediate payment. So yes, you do.
Let's have a look.
So tab 171. So this is our letter dated 21 May. And you've got paragraph 3. As set out in our first letter dated 17 May 2018, there is currently 2.2 million due and payable in connection with the buyer's credit under the facilities agreement. This amount excludes any default interest which may be applied. We should be grateful if you would confirm as soon as possible whether the borrower intends to pay this amount by Thursday, 24th of May 2018. And that is referred to in paragraph 45 of the pleading that I've taken you to. Okay, and then we move on to tab 173. This is our letter dated 24th of May. So paragraph 1.1, as set out in our first letter, dated 17 May 2018, there is currently 2.2 million due and payable in connection with the buyer's credits under the facilities agreement. And then 1.2, the amount was not paid on the original due date of 26 February 2018 and accordingly constitutes a non-payment event of default under clause 14.1 of the facilities agreement, and this is key, which is currently continuing. And 1.3, in our first letter dated 17th of May 2018, the bank confirmed that it would be prepared to consider a waiver of the event of default, provided that the borrower pays the amount for by the end of today, Thursday 24 May 2018. Despite repeated requests, the borrower has failed to confirm whether it intends to pay the amount in full today. So this is in respect of the amount. So this is the buyer's credit. We're entitled to demand it at any time under clause 4.8. And then 1.4, we're saying, well, if you don't pay this by the end of today, we reserve the right to demand the immediate repayment of all outstanding amounts under the facilities agreement pursuant to clause 14.2. So we're saying, look, if you don't pay this buyer's credit amount, which is payable on demand, by the end of today, we are going to exercise our rights under the event of default provisions of the facilities agreement. And that's in our pleading at paragraph 46. Then if we can go to tab 176.
But just taking this letter, isn't this all confined to an event of default being non-payment on the 26th of February?
No, it's not. It says currently continuing. It's an event of default which is continuing up to the 24th of May. And clause 4.8 of the facilities agreement allows us to make a demand for repayment of any buyer's credit at any time. I can take you back to clause 4.8.
I see. So you read that event of default in 1.4 as meaning the failure to pay by the end of Thursday, 24th.
Correct, Your Honour.
Right. I understand. Yes, all right.
Okay, and if we go to tab 176, this is our letter dated 27th of May 2018. Paragraph 2. Second sentence, the bank is concerned to protect its position. In accordance with clause 14.1A2 of the facilities agreement, the bank hereby provides the borrower with 3 business days from the date of this letter to pay the amount in full by Wednesday 30 May 2018. If the amount is not paid by this deadline, the bank reserves its right to call an event of default pursuant to clause 14.1 of the facilities agreement and to exercise all its rights under the facilities agreement, including, without limitation, to declare all outstanding amounts. So that includes the advance of the 4.134 million, which was advanced as an overdraft. So again, repayable on demand, immediately due and payable, together with accrued interest, and to apply default interest. So that is over the page in the pleading, so paragraph 50. Under the heading Final Demand.
Right. Yes.
Yes. Okay, and then we go to what we've called the notice of event of default in D1, tab 7. And you'll see that it's covered in the pleading in paragraph 53 if you already have that open, under notice of event of default. So very clear what we're relying upon in our pleading. Okay, and then we have paragraph 2.1 referring to all the previous correspondence. And the last sentence, let me take you to the second sentence just to avoid any objection. It says, the amount has been due and payable since 26th February 2018. So all of the dates since that date, up to 6th of June, the borrower's failure to pay the amount constitutes a continuing non-payment event of default of clause 14.1 of the Facilities Agreement. And then over the page, under the heading, Notice of Event of Default, the non-payment of the amount constitutes an event of default pursuant to clause 14.1 of the Facilities Agreement. And then, in accordance with clause 14.2 of the Facilities Agreement, the bank, and here's the notice in accordance with clause 14.2, declares all outstanding amounts to be immediately due and payable together with accrued interest and all other sums owed to the bank under the Facilities Agreement, declares all unutilised portions of the facilities to be cancelled and the relevant facilities amounts to be reduced to zero, and reserves its rights to invoke all legal remedies available to it without further notice to the borrower. And then C, reply default notice. And then for the outstanding amounts, so just to be clear about what the outstanding amounts are, you've got the overdraft facility. So that's an on-demand facility. So this is, if everything else that I've shown you fails up to now, we've demanded repayment of the overdraft facility, which is repayable on demand in accordance with clause 5.5 of the Facilities Agreement. Buyer's credit, very clearly demanding on this date payment of the buyer's credit. And then the advance, which we have treated as an overdraft in accordance with our payment obligations under this court's order to pay the 4.134 million to AK Global. We say that is abundantly clear, and we have pleaded everything that we need to plead in order to rely upon the 6th of June 2018 letter as an effective notice which requires repayment of all of these sums. The bank is concerned about any further delay in determination of its counterclaims. It's been obviously a very, very long time since these sums have become payable.
It'll get an answer according to the law as best I know it. Whether that means delay or not,
Well,
nobody knows at the moment, but that's what will happen.
Thank you, Your Honour. My submission, let me just limit it to, I'm not sure it's going to be of much assistance to the court to have further submissions on English law authorities or non-UAE law authorities. If it would be of assistance to the court to have further submissions on UAE law authorities, I think those are going to be very limited in giving any assistance at all to this court. I would urge the court to look at the plain words of clause 14.1 and see how we tick the boxes in terms of giving proper notice and making the request for repayment of those sums. Those are my submissions in reply.
Thank you. Nonetheless, I would appreciate the assistance that we've talked about here.
You Honour, and I apologise for this. It's something I overlooked just to mention. My other friend in his closing submissions relied on particular provisions of the facilities agreement, which he says mean that I cannot establish a set-off at all, even an equitable set-off, pursuant to the terms of that facility. Those provisions, I say, are not pleaded, they are not part of the case either. So if you look at the pleadings in response to the allegation that there should be set-off, and indeed if one looks through that pleading, one will find no reference, as far as I'm aware, to those provisions of the facilities agreement at all. Now, I hesitate to make further pleading points, but that is the position. If they were to be introduced, one can see that the kinds of defences one might have to particular contractual provisions could well be fact sensitive, depending on what the response is. So I just throw that up there as well.
Yes.
Thank you.
Well, the timing for the assistance, which I entirely appreciate what Mr. Francis says, it may not be of assistance, but nonetheless I would like to be as well informed as I can. And we all know that in this game a lot of the work you do turns out to be quite off the point. That may be the case. So, what sort of timing?
From my perspective, I think if I could have, what are we now, 10 days or so?
10 days sounds fair to me. If Mr. Francis,
That's fine, Your Honour. Thank you.
all right, well, send whatever you can get into the registry within 10 days, please.
I assume you're not expecting lengthy submissions and exchanges of submissions on this. I'm certainly not.
I'm definitely not. I'm expecting something very short with simple, perhaps propositions and references. Nothing more.
Yes. Perhaps what we could do is have that in 10 days, and should either party see the need to file something very short afterwards, then it should do so within 4 days or something. But not that Your Honour should wait for.
No. If any party sees the need, they can send a letter to the registry saying they see the need,
I see.
and they'll decide whether they get the chance.
Understood. Thank you.
I don't expect that.
I don't expect it either. Thank you.
Anything else?
Not from us.
All right.
Thank you.
Thank you to all concerned for sitting on a bit. Unsurprisingly, I will reserve my decision and adjourn.
Can I also just say thank you to the court for sitting late, and to the court staff, and just say to the transcribers, because I know it's been a long day. Thank you.
All right.